In the heart of a township on the outskirts of Johannesburg, people seized and stole at will, as they have done for the past few days. And there is little or no fear of the authorities here. Turmoil and anarchy have gripped some of South Africa's largest cities, and the government has had to respond with armed police and members of the military. But the looters and the rioters are fleet of foot, and rubber bullets do not seem to scare them. We followed the authorities down a local thoroughfare, but they only managed to catch one man before they handed the area back to the troublemakers. Later, we found the South African police minister, Bekele, doing a walkabout through the rubble, but he didn't want to answer our questions.
Minister, do you have the situation here under control? Do you have the situation here under control? Because it doesn't look like it.
The unrest began after the country's former president, Jacob Zuma, was arrested. But a series of protests have grown into something far more troubling. Here on an estate near Durban, residents filled their arms with televisions, microwaves and bikes plundered from a distribution centre. In Johannesburg, shops and businesses have been targeted or destroyed despite the efforts of the police, although they caught up with looters at this supermarket as they battled to escape through the back. In a place called Tembisa, the shops and the post office had been set alight.
All of the shops in this plaza have been looted, but they're also destroying them as well, setting fire. Individual shops, there must be half a dozen now gone up in flames, but they're still here picking through the ruins. You can hear them in this shop. Well, you can see them up on the counter. They don't like being filmed. I think we should go.
A fight back of sorts has begun to emerge as community groups seek to save the businesses that provide them with jobs. But they can't count on the authorities, and the looters feel no sense of self-restraint.
In the public sector, including organs of state and others for hearing. Council are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you. Good morning, Justice Kampepe and Justices. My name is Mpofu. I appear for the applicant in this matter, together with my learned friends, Mr. Masuku, SC, Ms. Kofa, Mr. Butelezi, Ms. Mkize, and Mr. Tulu. As the court pleases.
Thank you, Mr. Mpofu.
Thank you, Justice Kampepe. My name is Mugaitobi. I appear together with Ms. Muvangwa for the first and second respondents.
Thank you, Mr. Mugaitobi.
Morning, Justice Kampepe, Justices. I am DPC together with Kutsudas and Tubele and Kalise for the Helen Suzman Foundation.
Thank you, Mr. Duplessis.
Morning, Justice Kampepe and Justices. May it please the court. I am LaRue, appearing together with Ms. Motlasedi and Mr. Nase for the Council for the Advancement of the South African Constitution.
Thank you, Ms. LaRue.
Justices, the name is Vuyani Ngalwana. I appear for the Democracy in Action on a pro bono basis, together with my learned friend, Ms. Nomgcobo Jiba.
Thank you, Mr. Ngalwana. Mr. Mpofu.
As the court pleases. Justice Kampepe, Justices. In my 10 minutes, I will try to give a broad overview of our approach to this rather peculiar matter. The starting point for us is who shall guard the guardians? We say that because this matter involves, first and foremost, the proposition that it is the Constitutional Court itself that may have exceeded the bounds of the Constitution. We don't say this very lightly. We say it because it relates to the supremacy of our Constitution. And this is a case maybe that will portray for the first time that it is the Constitution that is supreme, not the Constitutional Court. The Constitutional Court is, of course, the most important body when it comes to our constitutional framework. But the Constitutional Court itself is an entity that is subject to the Constitution. And when, as in this particular case, the Constitutional Court has issued an order, that order, to simplify it, becomes law. It carries with it, with the necessary changes, of course, the same effect as if it was a law passed in Parliament. And that is why, on the basis of the order of this court, as we speak, the former president of South Africa is in jail, because once that order was issued, it assumed the status of law. But of course, the supremacy of the Constitution, which is enshrined in Section 2 of the Constitution, says that all law, including that order, which is inconsistent with the Constitution, is invalid. So if for a minute you indulge us and assume that the order is unconstitutional, or in one way or another exceeded the plans of the Constitutional Court, then the question is, what should then happen? Well, what should happen is what happens on a daily basis, that the person aggrieved by that order in its status as law must approach a court and seek relief. And it is on that basis that we have approached this court. Of course, there's the awkwardness of the fact that the law that we are bringing to this court is the order that was passed by this very court. But there's nothing earth-shattering about that. That is how it should be. Because it is this court ultimately, not sitting now as the body or the institution that is alleged to have acted unconstitutionally, but sitting in its capacity as the final arbiter on that very question of whether or not the judgment and order is unconstitutional. So it might sound as if there's a contradiction there, but there is none whatsoever. This is a case where we will demonstrate that in our notice of motion, it might turn out that our prayer 4, which asks for further and alternative relief, might assume certain importance, and I will deal with that when we deal with the relief. But I say that for the following reason. We are here primarily in terms of Rule 42, read with Rule 29 of this court's rules. And that is the well-known rescission rule. But we have also said that we seek further relief. We say at paragraph 11 of our founding affidavit. Alternatively, in the event that the court rejects my application to reconsider, and underline the word reconsider for now, and rescind or vary paragraph 3 of the order, that it directs that I'm given the proper opportunity to present evidence in relation to the question of whether direct imprisonment is an appropriate remedy, again underline appropriate, for the crime of contempt of court under the circumstances of my dispute with the Commission of Inquiry. But more importantly, at the very last paragraph of our affidavit says the following. Most importantly, it must be borne in mind that what we are dealing with here are not grounds of appeal or review, but allegations of conduct, which is ultra vires and unconstitutional, and therefore invalid. This matter is unprecedented also in that important respect. And I just want to say then our departure point will be that we are invoking section, or rather Rule 42, but because of what I've just read out, we are also invoking sections 38 and 172 of this court's of the Constitution. And if I may explain why we've asked for what we call appropriate relief and, of course, the just and equitable remedy, which might follow whether or not the Rule 42 is applicable. Section 36 says the rights in the Bill of Rights may be limited only, or rather Section 38 says anyone listed in this section, and that includes former President Zuma, has the right to approach a competent court alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights and so on. The court is familiar with this. Section 172, I will not read, it is along the same lines, but except that it compels this court to declare such inconsistent conduct or law to be invalid and then to give appropriate relief. So that's the broad framework. Now, I want to say this. Some of the prominent rights that we have come into assert that belong to former President Zuma include Section 12 of the Constitution, Section 35, Section 36. We also do invoke Sections 9, 10, 15, and 16 to lesser extents, but the primary ones are the ones that I mentioned. Now, if by any chance one of those rights has indeed been infringed, or the law, quote unquote, that we're here to examine or rescind or reconsider or whatever, is inconsistent with one of those sections, then we are in the world where Rule 42, Section 38, and Section 172 in that order will have to be invoked. Now, again, there's nothing strange about this. Section 35, by the way, which is the main section that we say has been infringed, is a section that is directed at the court. It is the court. That section actually directs the court to act in particular ways or another. It just so happens that the court in that context is usually will be the magistrate's court or whatever. So if I go to the magistrate's court and the magistrate denies me, says, no, Mr. Mpofu, you may not cross-examine the witness, then that magistrate or that court would have breached Section 35. and so on. If the magistrate says, no, Mr. Mpofu, you don't have the right to self-incrimination, or a high court judge, or you may not protect yourself, you don't have the right to silence, then that judge or that court will thereby be breaching Section 35. So there's nothing extraordinary about accusing a court, so to speak, of breaching Section 35. It happens all the time. The only peculiar thing here is that the court in question happens to be the Constitutional Court. But that's neither here nor there. The Constitutional Court decided in this particular case to sit as a court of instance, of first instance and last instance. So in doing that, conceptually, the Constitutional Court is in the same position as a magistrate court or the High Court or any court of first instance for that matter. And it is equally susceptible then to have breached Section 35, just like any magistrate may or may not when they deny someone the right to cross-examine or whatever is in Section 35. So again, it looks quite extraordinary on the outside, but it's quite normal. So once the court has assumed a status as a court of first instance, then it must be treated in the very same way like any other court that may or may not have infringed the Section 35 rights of an accused person. So all these, Section 36, which is also important, is also in the same genre of rights, in that it compels a court to do certain things. So it's, if you like, it's a procedural rule, but it's a constitutional procedural rule, because it compels the court, any court for that matter, a limitation. I prefer to use the word limitation because it portrays this problem even better, because a limitation gives us the proper meaning of an infringement, in that a limitation shows you that even if a right is only limited, or rather is only infringed to the 20% of it has been infringed, it still qualifies as a limitation. And Section 36 therefore kicks in. So how do we frame Section 36 as another right that is directed at the court? It is because that section compels, it's not optional, it compels the court, once an infringement has been shown, to then apply the justification analysis. If a court fails to do that, then the court has acted unconstitutionally. So the only question that has to be asked, was there a right that was limited, yes or no? If the answer is yes, then the court is compelled, impelled, obligated to do a Section 36 analysis. If it does not do so, it is exceeding its powers, because it's not a matter of option or choice. Which then brings us back to square one. The central question in this case will be whether or not the rights that we invoke have been limited, yes or no. If they have been, then one, the court will at least prima facie at that stage have exceeded its mandate, subject of course to whether Section 36 will then rescue that infringement. And that's, again, there's nothing extraordinary about that. That's what happens to every functionary, every organ of state is susceptible to the very same examination. Did you infringe my right in issuing the tender, yes or no? If you did, then was it justifiable in a democratic society, yes or no? If it is, then that's the end of me as the applicant. If it is not, then I must get a remedy.
Mr. Mpofu, your 10 minutes protection time has expired.
Thank you very much, Justice Khampepe. If I may then continue on that mode. So what we really have here is, if we go, let's start on the first base, then Rule 42. What we are saying is that this court made fundamental, what we call rescindable errors. It's just a phrase that we have coined. And we have coined that phrase, rescindable errors, to distinguish. I'm sorry.
Mpofu, can we, before you get, can you hear me?
Yes, I can hear you. Yes.
Is the remedy of rescission available to a litigant who deliberately decides not to oppose an application?
Yes.
And I'm asking this question because in Freedom Stationery, the Supreme Court of Appeal said that when you take a considered view not to participate in proceedings, you are reconciling yourself with whatever decision a court will make. So this is against that background that I'm asking this question.
Yes, thank you, Justice Chik. Yes, that's a very important question because it will help us to quickly get rid of one of the defenses that have been raised along those lines. Well, let's start. Bear in mind then, Justice Chik, that as I've said, that we rely on the rescission section. We also rely on Section 38. We also rely on Section 172. But let's answer this within the strict confines of the rescission. Firstly, the answer is, of course, yes. It cannot be that if X owes Y some money, and then X goes to court, and Y decides, well, I'm not going to oppose this because maybe I know that I owe the money or I owe 100 Rand and so on. Deliberately so. And then the court gives judgment for 1,000 Rand, let's say, or whatever, or even says you must give him the car and the house and everything. Then it means that Y cannot then approach a court to rescind that judgment, which is clearly erroneous for some reason or another. It can be. So the issue of whether you have consciously decided not to defend is really, cannot non-suit an aggrieved defendant, respondent, and so on, who, having accepted that either the court, this is a frivolous thing, the court will not even look at it and so on. And the court actually does look at it and says, well, you must give him the house. Then at that point, it cannot be said that that litigant cannot approach a court for a rescission. That's the first answer. The second answer is that rooted in this notion, and this is a more constitutional answer, if you like, rooted in this notion of voluntary non-participation, as we've called it in our replying affidavit, the defense of voluntary non-participation, is lacking behind it is a concept of waiver. It's been expressed in many ways: waiver, election, peremption, condemnation, whatever you call it, estoppel. It doesn't really matter what you call it, but that can never apply. There is authority for the proposition that constitutional rights, which is what we're here to assert, cannot be waived, or at least certain of them. And those include unwaivable constitutional rights, include the right to a fair trial, which is the flagship right that we are about here. So particularly in a case such as the following, such as this one, where it is the Constitution itself, the supremacy of the Constitution itself that is being asserted. A litigant cannot not be non-suited. In other words, you cannot say, well, you have forfeited your rights to life, for example, simply because you did not oppose a particular, and we say this in our heads, Justice Shikwi, we deal with it in where we deal with the waiver point. And we quote S versus Makwanyane, paragraph 137 of S versus Makwanyane, which makes it very clear that constitutional rights, such as the ones we are asserting here, cannot be waived. I'm sorry if I can just find, yes, paragraph 49 of our heads at page 16. We say, to save time, we must now turn, at 47, turn to the repeated defense raised by the respondents in refrain mode that the applicant was the author of his own misfortune, since he spent many opportunities to participate in the proceedings, which is a variation of the question you're putting to me, Justice, which resulted in the arrest and committal orders. According to this logic, it therefore does not matter whether the applicant's rights are irregularly infringed or not, because, quote, he asked for it. This argument misses the point only by the proverbial mile. It also offends the value of Ubuntu. We do not stoop to the level of those who offend us. The rights in the Constitution are mostly unqualified. They must be extended even to the worst among us. These rights cannot be forfeited, neither can they, generally speaking, be waived. These principles were established in the seminal judgment of S versus Makwanyane when Chaskalson P. authoritatively stated that, quote, constitutional rights rest in every person, including criminals convicted of vile crimes. Such criminals do not forfeit the rights under the Constitution and are entitled, as all in our country now are, to assert these rights, including the right to life. And then we go on to quote a passage from Curry and Deval in the next paragraph, which makes this point about non-waivable rights. Those authors say, in contrast to the freedom rights, in other words, like the freedom to participate in a political party, the freedom of association includes, as we know, the freedom of disassociation. So nobody can say, well, you have the freedom to join a political party, and therefore, if you don't join a political party, you are infringing the right, because it's a waivable right. So it says, in contrast to those rights, the nature of the rights to human dignity, to life, the right not to be discriminated against, and more importantly, the right to a fair trial does not permit them to be waived. Unlike the freedom rights, these rights cannot be exercised negatively. The right to freedom of expression, for example, can be exercised by keeping quiet, but the right to dignity cannot be exercised by being abused. What that means is sorry, to just complete the thought, is that insofar as that question is aimed at some kind of waiver or the fact that you did not exercise your rights, therefore you must live with it, as it were, then it is a precursor to these defenses that have been raised by the first and second, the HSF amici, of so-called waiver, election. You'll find that the word election litters their heads of argument, and preemption and so on, but those are expressions of the same idea.
I'm sorry to interrupt you, Mr. Mpofu. Let's just stay with the right to a fair trial. My question basically stems from the fact that here, the former president was notified that there's an application that is brought before this court.
Yes.
He was aware that the order that was being sought was to hold him in contempt.
Yeah.
And I'm going back to your example where you say that a person claims 100 rand and then a judgment would then give an order of 1,000. Here, what was sought was an order to hold him in contempt. And this court did not grant an order not to hold him in contempt, but a different order. It gave an order to hold him in contempt. So let's stick with that. And this is why I'm saying he knew that the application here was to hold him in contempt.
Yeah.
And he elected not to participate. And that is the order that this court gave. It granted an order to hold him in contempt.
Yes, Justice Chick, I understand. That's exactly the word you've used, elected. Election in law means the same thing as condonation, waiver, estoppel, acquiescence, whatever you call it. There are many words, but it's the same word. So the doctrine of election and the doctrine of waiver and the doctrine of acquiescence, the short answer to your question is that those doctrines do not apply when you are asserting the rights that I've just listed, including the right to a fair trial.
So in all instances, then, in all courts, if we are with you, would basically be saying that it is okay and open to a defendant to simply sit back and hope that a judgment will be against or in his favor or against the plaintiff. And that when that judgment is against them, then they can come to court and use the remedy of rescission.
No, Justice Chick, no. What that defendant you are talking about is entitled to do is to, as you put it, simply sit back on the comfort or in the comfort that the court will not give a judgment that says, for example, if someone goes to court and says they want to declare me to be an illegal immigrant or whatever, then I can say, well, I'll exercise my right not to oppose that because I think that there's no court that's going to find that and so on. That's fine. I'm entitled to that, right? Now, that's not the question. The question is what happens once the court then declares me an illegal immigrant? Am I now remediless simply because I knew that person who was taking that to court? Surely not. That cannot be the law. It can't be the law that I'm now completely helpless. I must just live with my election and move to some country that I don't know. It simply cannot be our law, just even at the level of logic. Surely, particularly when you are exercising constitutional rights, the point at which you perceive your constitutional rights to have been abrogated, whenever that point might arise, whether it arises at point 1 or point 25, doesn't matter. But at that point, when you perceive that your rights have been infringed, you have a right to seek a remedy. Ubi remedium, ibi jus, ubi remedium. So there cannot be a right that has no remedy. So if I have a right to assert my constitutional right at any point, even on my deathbed, one cannot say, oh, well, you should have done so when you were still healthy and so on. Otherwise, the rights in the Constitution are hollow and meaningless if they cannot be asserted in a court of law at any point, Justice Chick.
Maybe I should stop here because maybe I'm not understanding the elements of rescission or what needs to be proven by an applicant in a rescission application. Maybe I'll follow that up later.
Yes,
Mr.
thank you.
Thank you.
Mr.
Thank you,
Mpofu,
Justice.
Mr. Mpofu, can I raise 3 aspects with you, please?
Yes, Justice Machit.
The first one emanates from your opening address, where you said that you're bringing the application under further and alternative relief. When I read the papers, and it's made clear in paragraph 1 of your notice of motion that you seek rescission based on Rule 42, read with Rule 29 of this court's rules.
Correct.
So must I understand that when you raise these other aspects, you are raising it on the basis that Rule 29 suggests that Rule 42 must be adapted, must be modified as necessary. That's the basis. I just want to get that clear.
Yes, the answer is yes, Justice Machit.
Yes. So ultimately, we are still looking at Rule 42, modified where necessary.
Yes, modified. Yes, that's correct, Justice Machit. Yes.
All right. Now, thank you. The second aspect is this case that both you and Mr. Ngowana cite, and the SCA that gave judgment 2 days after ours.
The De Beer case.
In Minister of Kokta versus De Beer. We're not talking about the same thing, are we? That's a case of scandalizing the court. What had happened in that case is that there was a summary procedure employed. I'm talking about Mama Bolo now. And in this case, what the SCA did was, in giving judgment on the challenge on the state of disaster regulations, at the end, the court said, Mr. De Beer wrote an insulting letter to the President of the court and other justices, and therefore they referred the matter to the NPA. That was a case of scandalizing the court. It's a case similar to Mama Bolo and to Machabeng in this court, isn't it? It's completely different it's completely different from the disobeying of a court order that we're dealing with here, isn't it, Mr. Mpofu?
It's not completely different. It's another species, yes, of contempt of court, that I will concede. But to say it's completely different, especially in relation to the rights of the accused, quote unquote, would be stretching the point, Justice Mitchell.
In Mama Bolo, this court was dealing with an official of correctional services who had said some insulting remarks about Judge Els in the Eugene Terblanche case. And in that case, this court had to consider whether the summary procedure of contempt was constitutional. And the court pointed out there that it's a species of criminal contempt. And the same in Machabeng. It was a case of criminal contempt. We are not dealing with criminal contempt here. We're dealing with civil contempt. And the judges make that quite clear. You can read Machabeng at paragraph 50. And you can read Mama Bolo at paragraphs 34, 35, and paragraph 53. If you want to, we can go through it. But the point that I make is we are dealing here with a different species. It's civil contempt. And civil contempt has been tested in this court, the constitutionality, and it has been declared in PECO as to be constitutional as in Faki, where a court deals with it on motion procedure, isn't it? So that case is completely distinguishable.
Okay, well, that's where we differ, Justice Machit, with respect. When you say completely distinct, it's not complete. They're different species of the same thing, or genus of the same thing. Criminal contempt is a crime. Civil contempt is a crime, right? So we're dealing with two crimes. The fact that it's like, if you said, I want to assert my Section 35 rights, then you say, no, but the other person was charged with bank robbery. You are charged with murder. It doesn't matter. The Section 35 rights apply to crimes, any crime in this country. That's the principle that we seek to assert. We're not saying that every crime is the same. In fact, not even every murder is the same as another murder. So we accept without qualification that two crimes. But are they crimes? Yes. And if they are crimes, does Section 35 apply? Yes. If it does, was it infringed? Yes or no. If it was, did Section 36 apply? Yes or no. That is really, this case, despite all, it looks like complicated, but it actually is not. It is a simple matter of whether in a crime of whatever description, the the rules were followed. If they were, they were. If they were not, they were not. It's really that simple.
Right, let's agree to disagree then. It's paragraph 53 of Mamabolo. Krishla J says the following. Now remember, we are dealing with scandalizing of the court.
Yes.
As you say, as a species. Krishla J says the following, quote, a person so summoned for scandalizing the court is an accused person as contemplated by section 35(3) of the Constitution.
Yes.
And in Peko, this court made it very clear, and in Faki, the SCA made it very clear that a person in this instance of disobeying of a court order in a civil contempt proceedings is not an accused person for purposes of section 35(3), although some of those protections may be afforded to that person. Do you accept that?
No, not at face value. Let me explain, Justice Majid. And this is where the problem really is about some of these descriptions. In Mamabolo, I think the word that is used is combination or dual nature. And then
no, that's in Peko, Mr.
Yes.
Mr.
Well, yes.
Mamabolo was not dealing with
this court.
Mamabolo was not dealing with civil contempt at all. You're talking about Peko.
Yes, whichever. Faki, Peko, Machabeng, doesn't matter. The point here is this, is the hybridity of these proceedings is often misunderstood. Maybe that's why I'm using that word. The word hybrid might well not be the right word, because, or amalgam, as Justice Kampepe called it in the judgment here. Because an amalgam, as we know, is something which is intractable. So it's an amalgam of certain things. That's why I prefer the word combination or the dual nature, because it's very confusing, this idea of the amalgam. When we say it's a combination, it makes it clear it's a combination of two things, of civil proceedings and criminal proceedings. Now, that is why in Faki they use the word accused in quotes. They say the accused. If you go to paragraph 24, 25 of Faki, it talks about the accused in quotes. That is simply because in that particular context of the entitlement to Section 35 rights, the person is obviously an accused, must be regarded as an accused person. It would be foolhardy to talk about Section 35. Section 35 rights are only available to accused persons, by the way, which is what this court said in Zuma 1, in this case, the judgment of Chapter J, correctly, if I may add. So you cannot be entitled to Section 35, if you are entitled to Section 35 rights, then for that purpose you are an accused, full stop. But you are also, because of the unique nature of these proceedings, you are also a respondent or an applicant or whatever in the civil context. But that does not denude you of your status for constitutional purposes as an accused person, right? Now, and that is why you are dealing with so for a minute, you have to conceptually forget that you are also called the respondent or the applicant and say, now we're dealing with you for the purposes of criminal purposes. You are an accused, and you have to be entitled to all rights of every other accused person in the country. And that is why that distinction is artificial for the purposes of what we are discussing here. So whether it's scandalizing the court or whatever it is, insofar as you are an accused, you are entitled to section, which takes us to De Beer. The De Beer case is an illustration, because we must substance over form. In substance, what Mr. De Beer was accused of doing is exactly the same thing that that former President Zuma is accused of doing in his statements and all that scurrilous attacks and what have you. So that's the reality.
Sorry, Mr. Mpofu, I don't like interrupting counsel, but can I just stop you there? Mr. Zuma wasn't sentenced because of the insults and the vilification of the judges or of the judiciary or even of the court. He was sentenced because he was in contempt of a court order, of the order of this court.
No,
Yes.
I'm afraid that is absolutely not the case, Justice Bashir. We are told in more than 5 passages that what makes this case unique and extreme and so on and unprecedented are the attacks that were made by former President Zuma. We can both go to the judgment. I'll find you not less than 10 passages that refer to that. That is why the minority judgment says, let's conceptually assume that there were not those scurrilous attacks. What would we be left with? We would be left with what you are saying it is, a normal contempt of a court order. But there can never be any denying that in this particular case, what was being punished was even more than the disobedience of the court order, the egregious, scurrilous, and all sorts of adjectives that have been used so to separate that, which is really the thing that took him to jail, rather than I'm now not talking about, let's assume he's guilty of not
well, sorry, can I stop you there? You see, we're talking about 2 different things, Mr. Mpofu. You're talking about sentence. I'm not a sentence. I'm talking about his conviction. All I'm saying to you is Mr. Zuma was convicted not for vilifying the judges of this court or the court itself. He was convicted of contempt of court because he disobeyed an order of this court. And that's what the minority also says. That's their finding. Do you accept that? We're not talking about sentence. We're talking about the conviction. Do you accept that?
No, I don't accept that you can separate it like that, Justice Machit. I accept that that's why I said, assume for a minute that he was correctly convicted, because I was avoiding that kind of debate. If you assume that he was correctly convicted, that's the point I'm making, then of course, even the conviction for that matter, I don't think it can be dissected to say he was only convicted of the one part. But let's assume for argument's sake that that's the case. The point that brings us here is that throughout his trial, quote unquote, his Section 35 rights were denied, right? Whether you are talking about the conviction stage or the sentence stage, the question that must be answered, were his Section 35 rights denied, yes or no? They might have been denied in stage 1, stage 2, stage 20, or both, or whatever. That's not the level at which we're pitching.
No, Mr. Mpofu.
Yes, Justice Matlang.
No. You are moving to a different point altogether. Of course, you are entitled to argue that point, and I accept that it goes to the heart of your argument. But that's a different point altogether to what my brother Justice Majid is raising with you. And I do not think it's something that we can simply gloss over. I agree with my brother, subject of course to responses that you may give. You are conflating 2 totally different issues. My brother is saying the conviction itself related only question of disobeying this court's order. You are quite right in saying that this court judgment, the majority's judgment, is replete with references to Mr. Zuma's conduct, his utterances, and so on. You are quite correct on that. But what my brother says is that is a totally different issue. Those references relate to the question of sanction. So it is not correct for you to say, in making your point, that the matter of Mr. Reno de Beer, either basically the same as this one or similar to this one, to say that Mr. Zuma or former President Zuma was also convicted of something, or rather his utterances, just like Mr. Reno de Beer was. The short point is, as you correctly say, yes, this court, the majority does refer to those utterances, but it does so and relies on them in the context of sanction. If you insist that it does so even with regard to the question of guilt, I would ask you to show us in the judgment where we say, or where the majority says, we find former President Zuma guilty because he said this and that and that. The conviction relates only to, there was a summons for former President Zuma to appear, he did not appear. That is the basis of the conviction, not the utterances. And it's on that basis that my brother Justice Majid says, this case therefore differs from that of Mr. Reyno de Beer.
And Mr. Mpofu, before you answer, can I ask you to look at paragraphs 43 and following of the judgment of Kampepe J, the majority judgment, please?
Okay, no, that will not be necessary. Maybe it's me who's not articulating this correct. I don't know why I'm being told that the conviction was only for the, I said that many times. That's why I said, let's accept for a minute that he was correctly convicted. But in case there's any ambiguity about whether I accept that the conviction was only about the court order, all you need to do is to go to paragraph 3 of the order issued by this court. It's very clear. It says it is declared that Mr. Zuma is guilty of a crime of contempt for failure to comply with that order. That's not the point I'm making. I accept that. That's why I even said, assume that this is even a correct conviction. I went further. So I don't argue anything different. All I'm saying is this, that notwithstanding, what is undeniable and what we have come to this court for is to say that even, and it's said that it's in the founding affidavit, I don't know which paragraph, we say, even in a situation where you would say that the conviction was correct, we don't accept, of course, that the conviction was correct. But we say for intellectual debate purposes, even if you accept that the conviction was correct, the Section 35 rights that we have come to assert would have been infringed in relation to the sentence. So we would have been entitled, as the judges know, sometimes people go to the SCA or wherever and say, I've just come here to appeal or to rescind or to do whatever, or review, whatever it is, the sentence, not the conviction. So I'm prepared to say, for the sake of argument for now, let's not dissect this thing between the sentence and the conviction. Let us say where Mr. Zuma's Section 35 rights infringed, yes or no. Whether this is what I was saying, whether they were infringed at this stage or that stage or the other, for now is not the point we're making. We accept, Justice Majid, without any qualification, that order number 3 of this court was specifically confined to the issue of
thank you, Mr. Mpofu.
Breach of the order. But what we're saying is that the committal order, it would not be the same thing. To say that is not the same thing as saying the arrest and committal orders were confined to the order of Zuma 1. That one is certainly not true. Now, the only
Mr.
point that I
Mpofu,
want to make about
Mr. Mpofu, Mr. Mpofu, can I jot in there? Just on the distinction between De Beer and this matter.
Yeah. Right.
Does it matter that Mr. De Beer was not a party to contempt proceedings, number one? And also the fact that his conduct or his statements were made after the hearing, but before the judgment. Is that a factor that, are those two factors that we can use to distinguish DBA from this matter? First one, and more important for me, the fact that here we specifically had contempt proceedings, and the former president was a party to contempt proceedings. And the fact that in DBA, after the hearing, during his correspondence with the registrar of the Supreme Court of Appeal, he then made those statements. Is that a distinguishing factor?
Of course, no two cases are the same. Those are distinguishing factors. The question is whether those are material distinguishing factors for the purposes of what we are here about today. And my answer is a big no. And let me explain, Justice Chick. Of course, as you know, this happened, this one said this at a particular time. But the point is not that. The point is this. When a person, and that's why this distinction that Justice Machit and Justice Madlanga were making becomes important. Because ultimately, it would be, let's assume Mr. De Beer and former President Zuma, for whatever they did, both end up in jail or having paid a fine or whatever it is. When they are there, when they are detained, no, they're not going to say, oh, well, I'm here because I was in the court and I spoke to the registrar and so on. At that point, their right to freedom, to personal freedom, has been equally infringed because they'll be in the cell next door. The one will be in the cell next door. So that's really where we must look at this problem, not at the artificial levels of the differences of how they got there. Now, here's the question. And it goes to the point I was making about Section 172. This court in particular is enjoined to protect the rights of all of us. So this is what the De Beers case raises. If there are two ways in which those rights can be protected, one, let's call it the Zuma way, and the other one is the De Beers way. Which one protects the rights of our people? Is it the route where do not pass begin, go straight to jail, no trial, no mitigation, no appeal? Or is it the De Beers way, which says the matter is bad, you've been scurrilous and all that, but you're going to go to the magistrate's court, you're going to go to the High Court, you're going to go to the SCA, and maybe you'll end up in the Constitutional Court. Which of the two is the discharge of the duty of this court to protect the rights of those two people, Mr. Zuma, Mr. De Beer, standing in front of you, both of them? If the court chooses to adopt the Zuma way, then it is exceeding its powers, it is abrogating his rights. If the court, as the SCA did, chooses the De Beers way, then it is vindicating Mr. De Beers' right. It is that simple. And secondly, the issue is this, and that is why the minority actually coincidentally suggested what we call the De Beers way. So what we really have here is that within the space, and this case is unprecedented in that fashion as well, within the space of 48 hours, 7 judges preferred the Zuma way, and the 7 judges preferred the De Beers way. That's where we are as a country.
Sorry, Mr. Mpofu, I must take issue with that.
Yes.
You say in your heads, even if De Beer, you and I disagree on it, but as I see it, De Beer is scandalizing the court. It's a completely different case. You say in your heads at page 4, paragraph 8, significant differences in the approach of our 2 highest appellate courts in the handling of similar crimes require some attention. Now, even if De Beer was on point, if it was comparable to this case, then obviously the doctrine of stare decisis would have meant that that court would have been bound by this court's decision, isn't it? So it would have been irrelevant anyway.
Yes, you see, of course, you are right, Justice.
Because there's no two appellate courts, highest appellate courts in this country, Mr. Mpofu. There's only one. It's the apex court. It's been like that for 8 years, 2013.
Yes, no, Justice Majid, you know, at the level of technicality and ranking the courts and all that, you're 100% right. But that's not the point I'm making. I know very well about static cases. What I'm saying is the following, that 2 crimes, and I have to go back to this, because this one was scandalizing the court. The word similar means exactly that they're not the same, right? But the point I'm making is that 2 persons, let's forget the technicalities and the Latin, 2 persons who have done the same thing. One is dealt with in a way that vindicates their Section 35 rights, and they get a trial, a proper trial as we all know it. The other one does not get that trial. It's the same as the distinction that is made with respect artificially about the case of P.W. Botha. Of course, P.W. Botha was charged under the Commissions Act. Of course, we all know that. But what is? Let's forget about these artificial things. What did P.W. Botha do? He defied a commission of inquiry. What did President Zuma do? He defied the commission of inquiry, assuming he's guilty of that. The point of the matter, the difference between P.W. Botha, the way he was treated, and the way this court treated President Zuma, is that P.W. Botha ended up going to court, getting a suspended sentence or a fine and so on, having all his rights of appeal, and he actually exercised them and appealed. Whereas former President Zuma did not have that. He does not have even the right, which this court said is so sacrosanct in terms of Section 35(3)(0). This court said in the case of Zukudza, State versus Zukudza. I don't know if the court received we sent some authorities yesterday, but let me cite it anyway. 2000-11 BCLR 1252 CC.
We did receive it, Mr. Mpofu. I received it this morning.
Thank you. Okay, then yes, that's paragraphs 11 and 12 of that of this court's judgment of Ackerman J are crucial. Towards the end of paragraph 11, the Leonard Justice said, an important aim of the right to a fair criminal trial is to ensure adequately that innocent people are not wrongly convicted because of adverse effects which a wrong conviction has on the liberty and dignity and possibly other interests of the accused. Let's just pause there. What does in the Section 35 is not just there to ensure, and this is the point that kills the distinction between a conviction and a sentence. Section 35 is there to not just to protect you against the wrong conviction, but about anything wrong with the process of that trial. There are, however, other elements of the right to a fair trial, such as, for example, the presumption of innocence, the right to free legal representation, a trial public, which is not unreasonably delayed, which cannot be explained exclusively on the basis of averting wrong conviction. It's not all about a conviction, but which arise primarily from considerations of dignity and equality. Now, dignity and equality has no eyes as to whether now we're dealing with sentence, now we're dealing with Section 174, now we're dealing with this or that or the other.
Mr. Mpofu, may I please take you to the matter of Mr. P.W. Botha. Would a more comparator not be this. If after Mr. P.W. Botha had disobeyed the commission, there had been an application to court for him to be ordered to comply with a summons. This is on the assumption that the Conciliation Commission also issued summons, to comply with a summons issued by that commission. And then upon his failure to comply with that summons and therefore not here before the commission in accordance with that summons, for there to be an application for contempt of court, wouldn't that be a more apt comparator? Because there was no question of the interposition of any contempt of court. So on that basis, at least at face value, it seems to me that there is no comparison at all.
Okay, Justice Mazanga, I have to say this again, I'm sorry. Of course, that would be the best comparator in the world. If P.W. Botha was also an 80-year-old person from Kandla and so on. That's not where I am. I am saying P.W. Botha committed the crime that just former President Zuma is accused of. I'm at that level. The people out there don't know these niceties about whether this one did this or did that. But what they know is that there are two persons who robbed a bank. And the one bank robber gets a suspended sentence. The other bank robber gets 15 months in jail. Now, of course, it
is exactly why I want you and I as lawyers to disabuse those people of false impressions that they might have, because you and I at least do know some law. I will not say we know all the law, but you and I at least know some law. So we should disabuse their minds of any wrong impressions they might have. And for the reasons I gave, your comparator is not an comparator, but of course, yes, you are still responding.
Yes, Justice Matlanga, please, if you hear nothing else I'm going to say today, just hear this. It does not matter what crime we are discussing at a particular time, whether it's stealing a loaf of bread or killing 1 million people. I am saying both those accused, the one who stole a loaf of bread and the one who killed 1 million people, are equally entitled to Section 35 rights. That's what we're here about. So I'm not going to stand here and say, no, P.W. Botha, yeah, this, and then, no, he absconded, and then, that might well be. I'm not interested in that. I'm interested only in saying crime in South Africa imposes upon a court, any court, including this one, duties, certain duties. Those duties are listed in Section 35 of the Constitution. Loaf of bread, million murders, rape, whatever. Those people are equally entitled to the rights in Section 35. Were those rights in this case infringed, yes or no? I'm not interested in the loaf of bread.
Mr. Mpofu.
I'm sorry, Justice Mhlanga. I don't mind being interrupted. These machines are prone to interruption.
Yes. I just wanted to find out from you the status of the directions which were issued by this court after the hearing, where we asked the former president, Mr. Zuma, to submit an affidavit dealing with, amongst others, the question of sanction. What do you say to that? And
yes,
link to that, the response that we got from him in
yes,
relation to that request.
Thank you, Justice Mhlanga. Well, as it happens, I was about to read paragraph 12 of the case. So before I answer, because the answer lies there as well. The Constitutional Court then went on to say, more particularly in relation to sentencing, again, to show that we are aware of that distinction. In the context of the present case, it seems to me that what the right to a fair trial requires, amongst other things, is a procedure which does not prevent any factor which is relevant to the sentencing process and which could have a mitigating effect on the punishment to be imposed from being considered, underline considered, by the sentencing court. In the present circumstances, a fair trial would also have to ensure that in the process of sentencing, the sentencing court being put in possession of the factors relevant to sentencing, the accused is not compelled to suffer the infringement of any other element of a fair trial right. That's the answer, the legal answer to your question, Justice Chancellor. But here's the factual answer. If it is indeed, if the Constitutional Court was correct that the exercise of the right to mitigation must not prevent any factor which is relevant from being considered, then this is what is wrong with this picture here. This court generously, we have to concede, extended made those corrections on the 9th of April, asking for mitigating circumstances in a particular way. That was not done. We don't have no quibble with that. What we are saying is, let us look at that paragraph that I've just read and examine the facts in this case. And we say the right to mitigation was limited. And that's where that terminology becomes important. It was limited. We cannot say it was totally denied. But as I said earlier, the limitation of a right is the same thing as its infringement in constitutional language. So to the extent that the right to mitigation was limited, then it was infringed. And if we agree that it was infringed, that calls for a section 36.
So you say it was limited where a person has been given an opportunity and decides to reject that opportunity.
Yes, let me explain, Justice Mhlanhla. We talk here about the timing of that opportunity that you are referring to. We say that to the extent that that opportunity was given before conviction, then the right was limited. Why? Because we all know that under normal circumstances throughout the whole country, and we make the point that even in non-criminal proceedings, even in labor-related disciplinary matters at work, you undergo your process, you get convicted, and then at that point, you are asked for mitigation. You cannot be asked for mitigation in April and be convicted on the 29th of June. I'm sorry. If that happens, to that extent, your right to mitigation has at the minimum been limited. I won't put it higher than that. Why do I say that, Justice Mhlanhla? You know, as you know from the normal courts, Mr. X could be convicted on the 9th of April. And then he's called to court on the 9th of April. And they say, give us mitigation just in case we'll find you guilty in July. Now, Mr. X will say, okay, well, yes, you know, I'm in charge of 2 children and what have you. And then in May, Mr. X's parents both die. To that extent, he has been denied the right to say, oh, on top of this, I'm also an orphan. Because why? Because the right to mitigation was asked prematurely. before he even knew that his parents were going to die. But secondly, the asking of that mitigation prematurely also affects the ability to even exercise that right, because you are exercising it in the air. And as we say in our heads, if you are charged for 10 offenses and then you are asked prematurely for mitigation, then you're going to give mitigation for all those 10 offenses. But in July, you are found guilty of only 2 of those. And maybe these were not the ones where you emphasized your mitigation. So to that extent, again, your right for mitigation has been limited. And as I say, I'm not putting it higher than that, it is limited. But in constitutional law, the question is simple. Has therefore the right been limited by this court by asking for mitigation prematurely, yes or no? If it has, then what I just read out kicks in, because the sentencing court, which is the court that set, the sentencing court must not be prevented from considering any factor which is relevant to sentencing, to the sentencing process, and which could have a mitigating effect on the punishment to be imposed. That's what this court said, and this court was right. So that's what we say about that right. It was limited. We accept without fail that to some extent it was granted. 50%, 60%, I don't know. 90%, we might differ. But anyone who can argue that that right was extended 100% in these circumstances then does not understand what that paragraph 12 of this case is saying. And that's the point.
Mr. Mpofu, Mr. Mpofu, this way,
if you are correct,
we all know that, oh, sorry, continue.
If you are correct on that point, Mr. Mpofu,
right,
then what you are suggesting is that the court would have to then vacate the sanction, but the actual conviction of contempt, that is para 3, will still stand. And what would happen then? What would be the next step? Would that mean that what the court would have to then again issue directions and ask a former president to submit, make submissions on sentence, or what?
Well, if that's what justice, justice takes time, I'm afraid, the real justice. And that is why that the idea that Mr. Zuma must be bundled to court, or rather to jail, because it will take long, as the majority said, it will take long to traverse, I think the expression was, all the roads to appeals and so on. In other words, he should not be treated like anyone else, because it's just going to take long. I'm afraid if that's what it takes, Justice Mkandla, that's what it takes. The duty of this court is to afford Mr. Jacob Zuma his rights in full, 100%. Now, let me then come back. If the, and I like the way you pose the question, Justice Mkandla, because again, let me make my usual disclaimer. We're not accepting that the conviction was correct, but for the purpose of your question, let's say that it was correct. And your question is, what should then happen? Well, the answer is, what should happen is the same thing that happens every day in the SCA, in the High Court, where a person comes to only appeal against the sentence. It happens every day. There's nothing new about it. That which should happen is exactly that the sentence, as you say, would have to be set aside. And then in the interest of justice, this court will fashion an appropriate remedy under Section 172. Whether that remedy might include extending the real proper mitigating opportunity or whatever, then that's what it will mean, assuming again for a minute that the conviction stands. So what normally happens in all courts will happen. And that is why the remedy that we seek primarily. All these things, whether you are going to go through the Rule 42 route, Section 38 or 172, the real prayer that we want is prayer 3, which is that paragraphs 3, 4, 5, and 6 of the order of this honorable court be set aside. That's at page 2 of the papers. So again, it goes to this notion that this is a disguised appeal. It's nothing of the sort. What we're saying is that the two things, whether it's an appeal or review or rescission or whatever, they all come to the same road, which is set aside. So the fact that we also want those paragraphs 3, 4, and 5, and 6 to be set aside is neither here nor there. But that's what should happen. That's a short answer, Justice Nhlanhla. But let me just quickly roll back to the conviction, so that it must be clear that why paragraph 3 is included in that array.
Let's just finalize this point,
yes.
Mr. Mpofu. Does affording a person a right to be heard mean that such a right should always be afforded in a manner similar in all respects?
No.
To a criminal trial?
No, it does not mean, it certainly doesn't mean that. It's like audi alteram partem. It can be exercised in many rights, but there's only one way in which it cannot be exercised. It is in a way that limits that right. Otherwise, it can do it in 100 different ways.
So it can be done in 100 separate ways, and we know that this matter concerns civil contempt, and it was a hybrid process. So it was not a criminal trial.
No. Yeah. Yes, I accept that, Justice Chick. As I said to Justice Machit, let's for now.
No. I understand that. You know, I'm leading up to a question to you.
Yes. Okay.
The former president wrote a letter after receiving those directions. And in that letter, he did not, if I read it correctly, say that I would prefer to give my submissions on mitigation only if I am convicted. He didn't. He simply said, I'm not participating in this.
Yes.
Didn't we take that into account? That even at that stage then, he didn't say, well, I do not want to do it now, but he said that I am not participating in this proceedings.
Yes, but I'm afraid, Justice Chick, we are going back to the waiver point. So therefore, he did not say that.
I'm now saying he did respond.
Yeah.
Right. He did respond to the directions, but said, I am not participating. He didn't say, well, if I am convicted, then it only then that I will then consider whether to make submissions in mitigation or not.
Yes.
That's the only point I wanted to highlight.
Yes, but that point, I'm afraid, can only take us to one place, which is the waiver acquiescence. Let's assume he wrote a letter.
But we agree that that is what happened. At least yes, I just want me and you to agree that that is what happened.
Yes, Justice Chitri, let's agree that that's what happened. The question is then, what are the legal consequences of that? And I'm saying the legal consequences of that. Let's assume he didn't write anything. Or let's assume he wrote, I do not want to give mitigation, full stop. Or let's assume he wrote like Mr. De Beer, you can take your mitigation and throw it in your dash. It does not matter. Those rights cannot be waived. because the point here is that his right to mitigation stands. It was given by the founders of the Constitution. It was given by the drafters of the Constitution, and it is there. It's one of the non-derogable rights, even in Section 37 of the Constitution, which means even under a state of emergency, that right cannot be taken away. Right.
All right.
So, sorry.
Let me then ask you a final question. Although we've agreed that these were hybrid proceedings in the sense that they were not criminal trials, but I'm going to pose a question relating now to criminal proceedings.
Right.
Two scenarios, Mr. Mpofu. An accused in a criminal trial decides that he is not going to testify. What did this court say in Busak concerning that? Because remember, that accused has got a right to be heard, but he decides that he is not going to be heard. Should then a court then be hamstrung, or should then a court says, well, I've explained what your rights are, and I'm going to then proceed because you've then decided that you are not going to exercise that right?
No, thank you, Justice Chiku, for that question. I really welcome it. You see, that's again, it goes back to this conflation of the civil proceedings with the criminal proceedings. And I'm glad you posed the question like that. So for a minute, let us cast aside the civil proceedings. And then we ask the question that you're asking me and say, insofar as this was a criminal proceedings, by the way, which is what the commission only wanted punishment. So really, the civil proceedings and so on is just a mirage in this particular case. There was no civil proceedings. They came here to ask for imprisonment. It was a disguised private prosecution. But let's put that aside. The answer to your question, Justice Chiku, is the following. If that is exactly why the criminal courts behave differently from the civil courts. Because in the civil courts, if I do what you've just described, then I'm in jeopardy of getting judgment against me. So in other words, if someone was claiming 1,000 rand and I just decide to abscond, then they're going to get the 1,000 rand. But in the criminal courts, it doesn't work like that. You abscond and you don't come to court, and a warrant of arrest is issued. And then, let's say you also don't honor the warrant of arrest. Then you are sentenced for breaching the warrant of arrest, not for the murder, which you were absconding from. And that's where the conceptual mistake is made. That this thing of, oh, well, you chose not to come. This is not, these are criminal proceedings to the extent that we are talking about. So the punishment for absconding, it doesn't say, oh, well, you didn't come to court, therefore you robbed the bank. It doesn't work like that. Because to do that would be to breach.
But if you're a party, if you are there in court and you exercise your right to remain silent,
right?
What should a court do?
If you exercise your right to remain silent in a particular case, well, the court must still, unfortunately, have a trial. Except that in that trial, there will be no witness called the accused. But it will have a trial nevertheless. It will call witnesses. It will do, it can't just say, oh, well, because you're going to exercise your right to silence, boom, 20 years in jail without any trial. That is what the right to a fair trial means. It cannot be bypassed, I'm afraid. And it cannot be waived, and it cannot be abrogated, and it is non-derogable. It is there. It was put by the founders of the Constitution. We cannot wish it away. The only question is whether in a particular case it was observed or not observed. Simple. So we then have to come to the specifics of that particular case and see whether the right was observed or not. But there's no shortcut to Section 35. It is either those rights are afforded to a particular accused, and I use this deliberately because I know it's a hybrid and all that, But we're talking in specifically now insofar as criminal consequences are envisaged, insofar as someone is going to jail. Because when you're sitting in prison, the point is this, Justice Chief, to put it simplistically. Former President Zuma is the only person in this country. I don't know, let's say there are 100,000 inmates. He's the only one who did not have a trial. Now, of all those other 999,000 people had a trial. So it does not.
Mr. Mpofu, I think before I ask this question, you are going to move to another point.
Right.
And I think you've responded to me. I just wanted to wrap up this whole issue about him having been given an opportunity to say something in mitigation. And when I looked at his letter, he deliberately did not say that, well, look, I'll only do it in the event I have been found guilty of this contempt. He simply said that on conscientious reasons, I am not willing to participate in that. And that's all, not more. And yes. I was saying to you that it's not as if he was not given an opportunity. And I just wanted to wrap up on what Justice Mhlandla and you were debating. You yes. can proceed and deal with it.
Thank you very much. Thank you very much, Justice Chick. Yes, well, to round off that point before I move to the next point, which is about the right to appeal, all we're saying is, yes, let's not waste time on denying, saying, no, he didn't. Let's assume, as I say, he didn't even write any letter. The fact remains that he is entitled to that right. Or rather, let me put it more bluntly. The court is obliged, as a duty, to afford him that right. And I have no doubt that when this court extended that right, it was fully aware that that former President Zuma was not participating in these proceedings. And that's why I said it was a generous offer indeed. But that does not change the fact that it was generous does not change the fact that it was limited and did not go the full extent of that right in Section 35. And if that is so, then the right was infringed. If that is so, then Section 36 should have been applied. If that is so, then the court omitted to do that, and the court, that is a rescindable constitutional error. The mere fact, just what I've just described, if I'm right. Assume I'm right in all three. Assume that the right was not given in full. Assume that after it was not given in full, the Section 36 was not applied to it. Then it's a no-brainer then that what should then happen is that the resultant order, which comes from that kind of process, which is tainted, quote unquote, in terms of the constitution, the procedure prescribed by the Constitution, then must be rescinded. There's no doubt about that. But let's then move to the right to appeal.
Mr. Mpofu?
I'm sorry.
Yes, before you move to your next point, Mr. Mpofu, a few moments ago in your submissions and in your answer to Justice Mhlandla, you said that the applicant is seeking the rescission of paragraphs 3, 4, 5, and 6 of the order of this court. Is that right?
That's correct, Justice Tara.
If I can draw your attention to paragraphs 5 and 6, please.
The order.
Of the order, yes.
Yes.
That was not the order sought by the applicant in the notice of motion.
I'm just getting to it. Sorry, I'm sorry. Yes, I'm there now, Justice Theron. You are referring to 5?
To 5 and 6, Mr. Mpofu.
Yes. Yes. No. I accept that, Justice Theron. Well, what we've called them, I think the shorthand we used in the founding affidavit was that these were consequential orders.
Yes.
In other words, they obviously flowed from the other 2. Yes.
Yes. Now, I'm not sure if, as you say, they obviously flowed from 3 and 4. Well, because if you look at section 173, we have, this court has the power to regulate its own processes, but it also has the power to go further and make such orders to ensure that their orders are effective.
Absolutely. Exactly, that's what I mean by consequential. In other words, those orders are consequential to the main orders, if you like. I'm using those words loosely, which would usually be the declarator for invalidity and so on and so on. And then the court 172(1)(b) then says, effectively flowing from that, then the court may grant such relief as it may deem fit. So it's usually consequential upon a finding at 172(1)(a). So it's only in that sense that we lumped them together, Justice Theron.
Now, you also referred to, in the course of your argument, to a warrant and a warrant of arrest being issued. In my experience, a warrant, whether it's a warrant of arrest or a search warrant or a committal warrant, such a warrant would be issued on application.
Yes, it could be issued on application, but again, it might be implied. In this case, I would say that the mere citing of the Minister of Police and the National Commissioner by the applicant was pregnant with the idea that when it comes to the implementation stage, they would be the implementers.
Yes, no, that was the reason for citing the second and third respondent. My question, well, maybe it may be academic now, but if the applicants are still persisting with the rescission of paragraphs 5 and 6, maybe not so, whether this, are there any provisions which authorize this court to mero moto issue a warrant?
No, there are not. The only way, the only justification for such an action would be under the catch-all 172(1)(b), just an equitable remedy. But in my respectful submission, that section cannot go as far as to authorize the court to issue a warrant. But let me add this very quickly, Justice Theron. We know that the law, and I'll find the case now, the law on rescission, at least in particular, is that once a rescission order is granted, the consequential orders fall away. And the case that I have in mind, and I will refer to later, was about ejectment orders. So it was said in that case that once the main relief, I can't remember what it was now, probably to declare who's the owner or whatever, is rescinded, then the ejectment order will automatically fall away. So it is that I'm assuming in favor of the court for now that assuming the court had the power to issue those orders, then they will, and that's why we have prayer 3, they would suffer the same fate as the mother orders which gave rise to them.
Thank you, Mr. Mpofu.
Thank you, Justice.
Mpofu, can I just ask you on that aspect? If a court grants a judgment, let's say it's a default of payment of a bond, court grants judgment in a monetary sum declares the property executable, and also orders that the respondent must do everything necessary to comply with that order for execution, and failing which the sheriff must do everything possible, and so forth. We know those kind of orders.
Yes.
If you on rescission succeed and you get an order setting aside the default judgment, you don't need an order setting aside the order to make payment, the order to comply with execution. Everything falls away. It's consequential, isn't it?
Well, it's not that simple, but yes, it is consequential. I've said that. But what we are talking about here is something much more. We're talking about almost a standalone deprivation of somebody's liberty by the so-called consequential orders. That's why I was giving the long answer. But yes, at the level of what I call the main orders and the orders that follow, obviously that it happens again all the time in the court. Sometimes, as you know, Justice Majid, the court doesn't even go to say, even in review proceedings, for example, the court might say this is invalid. It might, on one occasion, not have another order that says, therefore it is set aside. But we all know that once it has been declared, administrative action has been declared invalid, then it is consequentially set aside. So there is that relationship between the orders, yes.
So simply put, if you get an order in terms of your notice of motion that paragraph 3 of this court's order be set aside, everything else falls away. There's nothing left.
Absolutely. There's no, that's exactly what we mean by consequential. But of course, a pleader, any reasonable pleader, must anticipate that 3 might remain or 4 might remain. But you're quite right, Justice Majid.
Thank you.
So the next point I want to address then is the issue of the appeal rights. And I'm doing that advisedly, because here now we're dealing with both the sanction and the sentence. Of course, the question of mitigation can only relate to sentence. But when we're talking about the right to appeal, then we're talking about the whole enterprise. Now, we ask the same question, and if I may, I know I'm preaching to the converted, but the starting point is in this book called the Bill of Rights Handbook, Carry and Devour. They simplify what a court has to do as follows at page 24. The first step is the normal first step in the substance stage of the litigation involves interpreting the provisions of the Bill of Rights. The court must consider, by reference to the facts of the case and to the interpretation of the Bill of Rights, whether, and that's important, this is the first stage, whether a right has been violated. If the court does find that a right has been violated, it must then consider whether that violation is justifiable, is a justifiable limitation of the right. Finally, if the court finds that a violation of a right is not justifiable limitation, it will have to consider the proper remedy. So that's what the court does every day and any day. So with that background, let's then go to the appeal section. We say, with the greatest respect, step 1, what is the content of the right? The content of the right is in section 35(0) of the Constitution. And that simply says that every accused person, everyone who's arrested for allegedly committing an offense or has the right I'm sorry, yeah, every accused person has a right to a fair trial, which includes the right of appeal or review by a higher court. So every person, including former President Zuma, has a right of appeal or review by a higher court. That's the entrenched right. Now,
the intro in that section says everyone who is arrested for allegedly committing an offense, then the rest comes. So are you then saying in the contempt proceedings, because
no,
they...
No, I'm sorry, you're reading the wrong part, Justice. It's 35.3, not 35.1.
Okay.
Thank you.
Thank you.
All right. 35.3 then says that you are every accused person, quote unquote, is a right of appeal to a higher court. Now, this is what we say. Again, let's simplify it. Was former President Zuma afforded or denied this right by the conduct of the court? Yes or no? No. The question is, was it justified? If the answer is no, again, I'm afraid the answer is still no. And therefore, comes back to your question, Justice Mklanka, what should then happen? Then it means
before you get to that question, what should we make of the fact that the proceedings in this particular case, direct access had been granted?
Yes.
And we know that there is no right of appeal there.
Well, that's exactly the problem, because we know that there's no right of appeal in direct access proceedings. It means that was another error. I have never heard of direct access, let alone urgent criminal proceedings. So that's the point. The point and the reason for that is exactly because we have such a thing as Section 35. It's not because other complainants wouldn't like all other litigants to just go on an urgent basis the following Tuesday and run a criminal trial. They would love to, but it has never happened in the face of the earth. Why? Because the criminal proceedings, urgent and direct access criminal proceedings, are ipso facto a violation of the fair trial rights of an accused. There is no way that when the Constitution, the people who drafted the Constitution made the provisions for direct access, that one of the things they had in mind was the criminal proceeding. So why? Because
this was a hybrid process.
Yes, I know, but let's assume, that's what I'm saying, insofar as it is also, that hybrid has got somewhere in it a criminal proceedings, okay? So insofar as that's what I'm saying, let's assume it was a combination of 10 things. I'm only talking about the part where it is criminal proceedings. I know there'll be the other proceedings and so on. But insofar as criminal consequences are envisaged, there is no way, I'm prepared to put my neck on the block on this one, that the direct access provisions envisaged the complete wiping out of Section 35 rights. It cannot be. And that was the approach that was taken by this court in S versus Rennes, one of the cases that we submitted yesterday. I think it was Justice Madala, where it was said that if any provision of the Constitution, any other provision, in other words, one that is not in the Bill of Rights, that must be interpreted, of course, in conform. It can never be interpreted to breach the Bill of Rights. So the direct access provisions, I think in Section 167, can never be interpreted to deny somebody their birthright and fundamental rights which are enshrined in Section 35(0). That would be the biggest travesty of justice. So it is no answer to this point to say, because then it's just a secular reasoning, to say no, but the right of appeal was denied because of the direct access. That doesn't work that way, because firstly, let's start at we agree that the right of appeal was denied. Then we must stop there and say, well, we know the reason is direct access. We'll come to that just now. But if that right was denied, then what should happen? If that right was denied, then it must be applied, Section 36 analysis must be applied, and so on and so on, those 3 steps that I read out. So it all turns out on the facts, I'm afraid. So the facts, the law is very simple. The facts are, was the right of appeal denied, yes or no? And I will just now demonstrate that that right was denied. When this court elects to sit as a court of first instance, which is what I said in the morning, then it literally is relegating itself, and I'm not saying that negatively, in a positive way, because we know that there were reasons why this was done. But for legal purposes, it then relegates itself to be treated like any other court of first instance in criminal proceedings. Whether that is the High Court, the Regional Court, or what have you, or the SCA, well, the SCA is never a court of first instance. But let's say it was a High Court or a Regional Court or a Magistrate Court. Now, once the court does that, once it clothes itself with the robes of the court of first instance, then it must not be expected to be treated as an appellate court. That's another conceptual mistake that is being made in this case. Of course, we know this is the highest court in the land. Of course, it's the apex court and so on and so on. But in this instance, it brushed itself as a court of first instance. And to that extent, then it must extend the rights in Section 35, as I say, is a catalog. It's actually, these are instructions, let's call them that. The rights in Section 35 are instructions which are given to every court of first instance, including this one. And if any of those instructions is not carried out, then a breach has happened. Now, for good reasons, for bad reasons, for indifferent reasons, it doesn't matter. But once, as a rights holder, it's my business that this was done for this or that reason. As a rights holder, all I want to know is, I got these things in Section 35, I take them. Was this one done? Yes, no, yes, no. If it was not done, it was not done. And if it was not done, there must be legal consequences. Now, I'm saying this then. This court said in Shinga that every accused, I'm sorry, Justice.
Mr. Mpofu,
yes.
If I may request you a short adjournment.
Thank you. As a court pleases.
We'll take a short adjournment of 10 minutes.
10 minutes, thank you.
Court will adjourn until 11:10. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 10. Should you exit, you may use the same link to rejoin the hearing.
I can still do another 45 minutes to an hour.
Justice Kampepe,
That should be sufficient.
That should be sufficient.
Thank you. I'll try and time myself.
Justice Kampepe, before Mr. Mpofu proceeds, can I please ask Mr. Naidu to check with Justice Pillay? I don't see her online, please. Justice Kampepe, may I suggest that Mr. Mpofu proceeds in the meanwhile, and I'm sure Justice Pillay will reconnect in the next minute or so.
Okay.
Thank you.
You may proceed, Mr. Mpofu.
Thank you very much, Justice Kampepe. When I was muted, I was saying that I was just apologizing that I have to just go back a little bit to the issue of mitigation before I proceed with my argument regarding the appeal. And I wanted to make a reference to the case of Madlanga J in Van der Walt versus S, which we have cited in our heads. And that it's at paragraph 28 of that's 2020 volume 11 BCLR 1337. And it relates to the question that was posed to me by Justice Mhlanhla about what should happen if it is found that the mitigation rights were limited. And I simply say that the point that I make, although again, it's not on all fours, so I know that this case dealt with a different matter. But the simple point I make is that Justice Madlanga in that matter related to the importance of the stage at which a particular right might be afforded. In other words, the fact that it might be afforded at one stage or another might make a huge difference to whether that right has been limited or not. And this is what the court said, because it was argued there that, well, it made no difference, as it might be argued here, that it made no difference whether the right was given on the 9th of April or the 29th of June. And Justice Mazanga said, of course, that misses the point, the no difference argument. It fails to address a crucial issue, and that is this: the admission and rejection of evidence at the right time, that's where the emphasis is, may influence the decision whether to close one's case without tendering any evidence. Nor can one ever guess with any degree of accuracy what impact evidence, if tendered, might have had on the outcome. The no difference argument is thus misconceived. It calls to mind the famous words of Margaret J. in John versus Rees, who said, quote, "As everybody who has anything to do with the law well knows, the path of the law is strewn with examples of open and shut cases which somehow were not, of unanswerable charges which, in the event, were completely answered, of inexplicable conduct which was fully explained, of fixed and unalterable determinations that, by discussion, suffered a change." And I'm quoting that in the context of saying we will never know what mitigation X, which was given in April, might have been different to mitigation Y, which is given in June. But let's then go back to the issue I was busy with, which is the issue of the appeal rights. I was saying the following, that the constitutional... I'm sorry.
Mr. Mpofu.
I can't... Oh, Justice Chapter, yes.
Yes. I'm trying to understand the argument. Does your argument relating to the limitation of rights depend on whether or not there should have been a trial.
Yes, among other things.
Isn't that the anterior question that we have to determine first whether the process that was followed, call it hybrid or whatever, I don't know what it should be called, whether that process should have been followed.
Yes.
And if you say it shouldn't have been followed, why should it not have been followed?
Yes, thank you, Justice Chapter. Can I answer that question in two parts? I will start by the easier part, which is the process was followed. We know that as a matter of fact. So the point is this: even if you accept that the process was followed, and even if you say the process was rightly followed, let's say, because it's a hybrid or whatever, even then, Justice Chapter, the real question will be whether in that process, whatever you call it, the rights of the accused person, quote unquote, which are listed in Section 35 were followed. So that's the first answer. And so irrespective what Faki and all those other cases say, Machabeng say, is that the court must see to it, for lack of a better word, that those rights are not negated. And of course, I accept that it says not all the rights. I think Faki says not all the rights. Sorry,
the difficulty, the cases that you're referring us to make it plain that the contemptor is not an accused person.
Well, I wouldn't put it that strongly, Justice Chapter. Even Faki uses the word accused, but it puts it in quotes. But I don't care.
But if it's in quotes, it's not the real thing, is it?
Yes, let's assume it's a half thing. But to the extent that the person is entitled to the Section 35 right, just like an accused. Let me put it that way. So sorry, Justice Chapter.
You see the difficulty that I have, and I know it's not the fault of the litigants. It might be the fault of the judiciary itself in not clarifying some of these things. The difficulty that I have is this. If the common law process, which led to a criminal sanction being imposed for a crime, and I agree with you that it doesn't matter whether it is in the context of civil contempt. Contempt of court is a crime. That's what the law says. We accept that. Now, the difficulty is this. The common law rule or process allowed the common law process in relation to contempt allowed for a process where in civil proceedings there would be a criminal conviction followed by a criminal penalty. Okay? And when you look at the Constitution, the scheme of the Constitution, you see a distinction being drawn between those two processes. Okay? The Constitution, in some respects, tells us that there should be a trial. Now, the question is whether the common law process, which is well established, is compatible with the demand by the Constitution that there should be a trial.
Yes.
Now,
Okay.
isn't that the point that we need to resolve first? Because if the common law process is constitutionally compliant, then all these arguments about the specific rights may fall away, because then the Constitution would have sanctioned a process that leads to the limitation of those rights. Everybody knows you argued under Section 36 that the rights are not absolute, they may be limited under certain circumstances. So I want to understand whether or not our Constitution demands that before someone can be convicted of crime and have a criminal penalty imposed, that there should be a trial.
Yes, again, Justice Chafter, forgive me, I'll answer it in two parts. The first part is that you are, let me start by saying, what we know for sure is that our constitutional scheme requires that even in contempt of court proceedings, the rights under Section 35 and 12 must be given effect to. That we know. All the cases say that, Machabeng, Peko, Faki, and so on. Now, your real question is this. Assuming that I'm right, that those rights must be afforded to the accused person, or half accused, or whatever you call it. Should those rights then be enjoyed necessarily in the context of a trial? And that's the nub of your question. The answer is twofold. It is that it may not necessarily be, in other words, it might not be a process issue. It might well be that in so-called sui generis civil proceedings of this nature, there is still room to ensure that Section 12 and Section 35 are not violated, which is what Faki really says, which is what all the other cases say. But the second part of the two-part answer is that if you go to paragraph 100 of our founding affidavit, we say there that we bring to the attention of this court that actually we have instituted proceedings to I'll just read it out. We say at paragraph 100, for the sake of completion and transparency, and although of no direct and immediate relevance to this application, I wish to disclose that I've given instructions to my legal representatives to launch parallel proceedings in the High Court aimed at inter alia challenging the constitutionality of the Criminal Procedure Act insofar as it fails or omits to cater for affording the normal fair trial rights to persons facing imprisonment in proceedings which are solely aimed at such imprisonment. In other words, what we're saying there, Justice Chafter, is that we are prepared for the first part of my answer is that to work within the current framework, which forces you into civil proceedings. But we're saying at the same time, we are challenging the constitutionality of that regime. So even when it stays as it is, we say we should still succeed. But more so if we succeed in the other action, or rather application, then it will be a no-brainer, because then the Criminal Procedure Act, of course, if it accommodates this scenario, will accommodate it within its normal framework. You go to court, you plead, you cross-examine, and so on.
But why would you want to go the route of a frontal challenge against the Criminal Procedure Act when the law of general application that imposes the limitation is the common law?
Because
I don't understand that.
No, that it is for the same reason that you prosecute murder by using the Criminal Procedure Act. It doesn't change murder from being a common law crime, but what it does is to have a mechanism that the Criminal Procedure Act, whether it's fraud or whatever, they will remain common law crimes. But it's the procedure by which those crimes are prosecuted that we have a problem with, not so much with the source of the crime itself.
No, Mr. Mbofu, you're missing my point. My point is simply this. We know that, or you have argued that your client's rights in the Bill of Rights are limited by the process followed in the judgment under consideration.
Right.
And we know that that process is a well-established common law process. Are we still together?
Yes.
You seem not to be convinced.
No, I'm convinced. I'm convinced it is.
Okay.
Yes. So far we're together.
Because I don't want to go back to some submissions that you made in relation to the application of Section 36. As I understand it, Section 36 says you can only limit rights in the Bill of Rights if that limitation itself is imposed by a law of general application. Okay?
Yes.
Secondly, that limitation must be reasonable and justifiable in an open and democratic society. Okay? Now we know here that what was relied upon by the Commission in moving the court to determine whether your client was guilty of contempt of court relating to not obeying a court order, that process is permitted under the common law. So the common law becomes the law of general application, which imposes this limitation your client is complaining about. Now, if that is the case, I don't understand the attack on the criminal procedure instead of attacking the common law to say this limitation imposed by the common law is not complied with the Constitution for ABC reasons, and therefore you can't rely on it. Because as I read the judgment of the court, it sets out that this is well established. And in the past, if you were to put aside the Constitution, we wouldn't argue about this.
Yes.
at all. We argue
Yes.
about it because there is the imposition of the Constitution. It's a well-established procedure under the common law. So
yes,
that is
no.
in that context that I
Yes.
say, I don't appreciate the answer that says, we have gone to Pietermaritzburg to challenge the Criminal Procedure Act, because what is going to happen in Pietermaritzburg is not going to give us an answer relating to whether or not the common law process or procedure that had been followed is constitutionally compliant.
Well, then I completely don't understand that part, because my understanding is that if the Criminal Procedure Act is amended,
yes.
and therefore the Parliament then imposes a new process because of that case that we have, then ipso facto, that new process will override the common law process to the extent that, well, that's what legislation is. It either codifies or amends, quote unquote, the common law. But let me put that aside for now. Maybe it will be debated in Maritzburg. The point I was simply making, Justice Chafter, is the following.
Yeah.
Let's look at now these particular proceedings we have here as primarily as rescission proceedings. Then you will say to me, well, Mr. Mpofu, what is this rescindable error that you are complaining about in this area that we are discussing? And we are saying the rescindable error is the fact that the majority judgment, unlike the minority judgment, failed or omitted, that's the rescindable omission, omitted to even apply what Justice Chafter, what you are saying to me. In other words, they ought to have done a Section 36 analysis and then maybe come up with the answer that you have just given me. But they failed at the first block because they did not even, unlike the minority, they did not even think that there was a violation, let alone any need for a justification analysis. And if we are right on that narrow basis, that a Section 36 exercise, whatever its outcome is going to be in the end, it doesn't matter, was not done. It might well be that, let's say, if the majority had said, we're doing a Section 36, but we find that it's justified. And then the minority says, we're doing a Section 36, we find that it's not justified. Then we would have no reason to complain, because that would be like an appeal. But we're not appealing here. We're simply saying the failure to follow a prescribed process by the Constitution is itself a rescindable error.
Now, Mr. Mpofu, I am not sure whether that is fair to the majority. For this reason, we did not have a frontal attack on any law of general application which would have taken us into the ambit of Section 36. If you look at Mamabolo that you referred to, there was a frontal attack. And when there is a frontal attack, you and I know that you have a two-stage inquiry that you have to follow. First stage, you ask the question, is there a limitation of a guaranteed right?
Yes.
If the answer is no, that's the end of the matter.
Absolutely.
But if the answer is yes, then you have to proceed to the justification analysis.
Right.
So one has to understand or read the majority judgment in that context.
Yes. Yes. No, we are completely agreed, Justice Chapter, you and I. But what I'm saying is one thing. The Section 36 analysis is not only confined to attack on a law. What I read out now from Curry and Deval, what they call the three-stage theory. So if stage one, if there's an allegation of an infringement of a right guaranteed in the Bill of Rights, then the three-stage process kicks in. In other words, you say, was there an infringement? And as you correctly say, if the answer is no, that's the end of it. If there was a limitation, yes. Well, Karim Deval say in constitutional language, limitation, infringement, and violation are synonymous. That's why they said page 151 of their book. But and I prefer the word limitation because it gives you the minimalist approach that even if it's a 10% violation, but that's fine. Let's use limitation. So if there's a limitation of the right as alleged by the applicant or whoever is approaching this court or high court or whatever. Once the answer is yes to that first question, then you have to move to the second question because rights are not absolute. So it's not a simple thing of saying, did you limit my right? Yes, and therefore I must get a remedy. You have to go to the second stage, which is the crucial stage that we are discussing now, namely whether there's a justification. Now, all I'm saying, Justice Chafter, is that there was no frontal attack, you are correct in this case, but that did not stop the minority from applying a Section 36 analysis. Why? Because exactly of what I've just said, because there were allegations of, or at least there was an examination of whether or not Section 35, Section 12, and all those rights had been violated or not. And it's inevitable. Once you have that examination, it can only lead you to one thing. I mean, to two roads. The answer is no, as you say, then we all go home. But if the answer is yes, then you have to apply a Section 36 application. Now, what I'm saying is a very narrow point, which is that the mere failure of the majority, assume for now that we have established at a factual level that there were inroads, limitations, whatever you call it, into the rights of the applicant. Then the success of the minority to go to stage 2 and the failure of the majority to go to stage 2 is a rescindable error. That's all we're saying. Without preempting what the outcome would be, please, Justice Chafter, it would be different if we were coming here and say, as I say, the majority did a Section 36 analysis, but they found wrongly. Then we appeal. We say, no, we agree with the minority. But that's not what we're doing. And that's where the confusion with the other side, when they accuse us of having an appeal in this court, is misplaced.
Am I wrong, or did I understand the majority wrong? Because the impression that I have is that the majority came to the conclusion that the justification analysis under Section 36 doesn't even arise in this matter. That is why they did not undertake it. So there is a finding, or rather a conclusion, a legal conclusion, that to the effect that justification analysis doesn't apply here. Now,
yes.
Short of an appeal, can we reconsider that legal conclusion? Is it not binding on us?
No, Justice
Okay.
Chafta. No,
Let
that's
me-
then if that argument were to hold, then we must scrap the process called rescission, because every time you do a rescission, that it is that court, let's say whether it was the SCA or and so on, which would have made the finding. Now you'll be chasing your tail if you're going to be saying, well, the judgment that you want to rescind is binding on the very court. No, the issue is this: in a rescission, as you correctly found out, just in the case of sorry. I think it's Nwabeta, which was the case in Mthatha. I'll find it now. You, Justice Chafta, as you then were at that point, said that if three things, I'm paraphrasing, if the error, explaining what the error might be, that it might be an irregularity or the court acting outside of its competence. And I might be misquoting you, but at least it's tried that if the court exceeds or acts outside its competence, then that's a rescindable error, as opposed to it might also be an appealable error. I don't know, but at least what we know is that it's a rescindable error. Now, what I'm saying, Justice Chafta, is this: it is exactly what you are saying that we are saying is the error. In other words, if I am correct that the appeal rights, the trial rights, the mitigation rights, what have you, were indeed infringed, limited to whatever extent, then it is an error, a procedural, if you like, although that doesn't really capture what I'm saying, a constitutional procedural error, let's call it like that, to fail to, in other words, the procedure that's prescribed by the Constitution, to fail to apply a Section 36 analysis. That is the very error. I'm not talking about the outcome of that analysis. I'm talking about its absence. The mere fact that it was not done is itself calls for the rescission of the judgment. Only, of course, if I'm correct that there was a violation. And that's why I was at the level of explaining that in this case, there was indeed a violation of Section 35(3)(0). And whether that a violation, I'm sorry, Justice.
I'm trying to understand it, Mr. Mpofu. On the rescission lane, does it matter or not that there is this finding that you and I are talking about? Does it stand in the way of us reaching the limitations that you have referred to? Because if it doesn't matter, then my concern would be misplaced. But
Yes.
if it matters, it forces us to say you have to remove it out of the way first before you can get at the alleged limitations. And my concern is that that would be something that you can do on appeal, because you are saying, well, the court was wrong in reaching this conclusion of taking out the consideration of the application or applicability of Section 36 of the Constitution. It should have followed it. So it was wrong. And therefore, we have to correct that error. I am not sure within the lane of rescission, how we get there.
Yes. No, I understand exactly that issue. In fact, I debated it with somebody a couple of days ago. Justice chapter, let's go to base 1. And I'm saying this, I know I'm repeating myself. If that was correct, then there's been no rescission of judgments in the Constitutional Court, because we would forever be chasing, we would say, well, you can't want to rescind a judgment. Here's a judgment. Let's say it's unanimous. Forget about minority and majority. Unanimous judgment of the Constitutional Court, binding as they come. And then you say, it would then be unrescindable, because every time you want to rescind it, you will be told that, no, but there's a binding judgment. Which one? The one that, the one that you are rescinding. It can be. If there was a court of, if there was a higher court, let's say, higher than the Constitutional Court, then that court would, and this is the quagmire we're in, because this court, as I say, relegated itself into a court of first instance. Now, we know that as a matter of right, a criminal litigant is entitled, as a matter of right, Justice Chapter, to a I think it's called a reassessment of his or her conviction. That's what it says in Twala and Steyn and all those cases of the Constitutional Court. Now, where then would that, for an accused person, quote unquote, who was given, or rather was tried by means of direct access to the Constitutional Court, where would they exercise that right? That right that every other accused person has of having the matter reassessed by a higher court, or let's just say another court. The only way that can be done, Justice Chapter, is for us to accept as a fact that this is the highest court in the land. And therefore, that reassessment must also happen here. It's not ideal, but we can't impose another court just for. So if otherwise we're denying that person the rights of every other accused person to have the matter reassessed at least once. I think one of the cases says the matter must be reassessed at least once. In other words, that's the, sorry.
I understand the thrust of that argument, Mr. Mpofu.
Thank you.
But I think my debate with you relates to rescission based on Rule 42.
42.
And you and I know that the authorities suggest that that error must be of something that the court at the time it was granting the order was not aware of the nature, if the court was aware of, could not have granted the order.
Yeah.
Now, the debate that I'm having with you is within that background, within that context. If you are to say to me, well, Rule 42 has shortcomings, I'm not relying on Rule 42 for pleading for reconsideration of the order or the judgment by the Constitutional Court. If you were to say, for example, to me, look at Section 167 of the Constitution. It says the rules of court and legislation must facilitate the process of coming to the Constitutional Court in the interest of justice. That would be a
Yes.
different pathway altogether. But I am debating at present the Rule 42 pathway. And that Rule 42 pathway has its own requirements. They are well established. And it seems to me where a court has said, no, what you are doing, the minority, it's not relevant because Section 36 does not apply. To me, that appears not to fit neatly within the requirements of Rule 42.
Well, unless that can only be so, Justice Chafter, if we are not permitted to then go and look at the facts and see whether or not indeed the Section 36 analysis was not triggered. And that's the point I was making. If it doesn't matter what the majority or minority says, but if upon looking coldly at the facts, we are able to distill that actually, objectively, the Section 36 analysis was triggered, then it does not matter, with the greatest respect, what the majority said or the minority said or did not say. What matters is that there was what I've termed a constitutional procedural error of not doing that which is prescribed by the Constitution, which is even worse than something prescribed by the rules. Remember, Rule 42 applies to even procedural inadequacies. For example, if the rule said you have 10 days and a judge says, well, I'm kicking your case out because you should have done this in 5 days. Even that level of procedural error would be rescindable. So how much more of an error which is of the order of something prescribed by the Constitution, which you have failed to do, when objectively speaking, it can be shown that you should have done. Surely, but surely, that omission, let's call it, would apply as a rescindable error in that context. And the case I was referring to is Mutebwa. This is Mutebwa, 2001, Volume 2, SA 193, the Transkei Division, and it was Chapter J, as I say, as it then was, who explained that even this thing about it should be on the record, that actually the most important point that came from that case was that a rescission application must be judged according to the allegations in the rescission application, and that those cases that said it must be judged in relation to the record were wrong. And that judge was correct.
I may have been wrong, Mr. Bofu.
No, I insist, Justice Chapter, that you were correct. In fact, Erasmus, for that matter, even today, relies on that case for the proposition that I'm making.
Mr. Bofu, what I found strange here, I'm sorry to detain you for so long.
I appreciate it, Justice.
What I find strange here is you started by saying we have to find first whether there has been limitations of rights, which is unusual because when you come to court for rescission or some relief, you first have to show that the court must entertain your matter. And once you have shown that it must be entertained, then you go to the merits of it. Your approach is start with the merits, evaluate whether or not there were limitations. Then once you have done that, then you can come back and say this is the approach to court is justified because of. You didn't say that.
No. That's absolutely the exact opposite of what I said. Well, I started this morning when I was given 10 minutes to talk without interruption. I said, one, we come primarily under Rule 42. Then I said, we also come under the alternative relief is based, and I referred to the pleadings on Section 38 and also Section 172. And I said, if, and obviously those are in cascading order. So I was saying, even if you were to find that the case does not straitjacket into Rule 42, and that is why Justice Majid asked me correctly that, Mr. Mpofu, are you saying under the wording in Rule 29, which says with the necessary adaptations? I think I'm paraphrasing, it probably doesn't say that. That's how you are invoking, and I said, yes, that is correct. In other words, I'm saying Rule 42 itself must not be applied mechanically as if we are in the High Court, because we are in the Constitutional Court. And those words in Rule 29 that say with the necessary adaptations, mutatis mutandis, must, among other things, as Justice Majid understood my point then, mean that the remedies that might be available to a High Court, or the other way around, the remedies that might be available to this court in its application of Rule 42 might well be wider than those remedies that would have been available to a rescission High Court. And I was doing that deliberately because that's why we said at paragraph 11, and I think the last paragraph of our pleadings, if the court, and that's why the word reconsideration only comes there for the first time. Paragraph 11, Justice Chapter. We say rescission or a reconsideration. In other words, I'm sorry, 11 of the founding affidavit. Just 1 second, please, Justice Chapter. So, as they say, jurisdiction, we don't do what you are saying, Justice Chapter, when we establish the jurisdiction of the court. We say at paragraph 11, alternatively, and in the event that the court rejects my application to reconsider and rescind or vary paragraph 3 of the order, that it directs that I'm given a proper opportunity, that's partly an answer to Justice Mhlahla, to present evidence and so on in mitigation. But more importantly, the last paragraph of that pleading is where we invoke the Section 172, what I call the Section 172 approach. Most importantly, we say it must be borne in mind that what we are dealing with here are not grounds for appeal or review, but allegations of conduct which is ultra vires and unconstitutional, and therefore invalid. Those words are taken directly from Section 172, 1A. And then we say this matter is unprecedented also in that important respect. In other words, assume for a minute that we don't meet the requirements of Rule 42. This court cannot then say, well, go away. It will have to say, if it agrees at the very least that there was unconstitutional conduct on the part of the majority, as we forcefully allege, it will then have to say that, well, what must be done about it? And what must be done about it is to set aside those, is to grant prayer 3. So it's a much simpler way of getting maybe to the same outcome. and you did say with respect, Justice Shafter, or at least maybe you were not aware at the time, that we did invoke these different pathways, as you call them. So yes, undeniably, our primary attack route is Rule 42, but we have foreshadowed the possibility that if it is applied mechanically, one might say, oh, what about this and that comma here and a comma there, and not adapt it to a as what Rule 29 we think says it should be done. Let's assume then it's applied as if we were sitting in the High Court. That will not absolve this court with respect from its duties under Section 38 and Section 172 to still set aside these orders on the basis that the unconstitutionality, which we have to establish on the facts, we accept that onus, must be remedied somehow. So how else can it be remedied if but not by granting the appropriate or adequate or just and equitable relief that is required? That's the structure of the case. Thank you very much, Justice Shafter. I really appreciate, because that then gives us I think the basis to look at the three pathways, as I say, in a cascading way. Thank you, Justice Shafter. Thank you. Now, I was just saying, and this is, I hope I'm getting to this point eventually, which is the appeal point. I'll paraphrase it because we don't have time now. The appeal point we make is this, Justices. One is the one that I've already made, which says that ipso facto, the error in this case was to, or at least one of the errors, was to grant direct access in criminal proceedings or quasi-criminal proceedings, call it what you will. In those quasi-criminal proceedings, then it means you have instant justice in a criminal matter. That is not allowed. You can't fast-track criminal proceedings by having urgent criminal proceedings. There's no such thing in our law as urgent criminal proceedings, for a good reason. Why? Because unfortunately, the tedious route that is prescribed in Section 35 has to be followed. It's obligatory. And that is why there is something called Section 35. If there was no Section 35, then criminal proceedings would be dealt with under Section 34 of the Constitution, in which case you would have such an animal as urgent criminal proceedings. But the mere fact of having urgent criminal proceedings, or no, let's forget the urgency for now, direct access criminal proceedings, means that ipso facto you are denying the right of reassessment, which every other accused person has. You are denying the right of appeal, which 35.3.0 says every accused. Why should every accused be entitled to Rule 35.3.0 except former President Jacob Zuma? Why? There cannot be a situation where everyone, as I say, who's sitting in jail right now, had Rule 35.3.0 available to them, except one man. Now, if that is so, then it comes back to the discussion I've just had with Justice Shafter, which is then plainly there has been an infringement of at least 35.0. If there has been an infringement of 35.0, then there should have been a 35.6, rather a 36 treatment. Was that done, yes or no? No, it was not done by the majority. Is that a good thing, or does it invalidate the procedure actually followed? Yes. If it does, then it must be rescinded. Alternatively, it must be remedied in terms of Section 172. That's it. So the mere fact that we end up in the same place, whether we had come directly as Section 172, or we had come as Section 38, or we had come as Rule 42 or Rule XYZ, doesn't really matter. It's the substance of what the relief was seeking that should be considered. And if the criticisms or irregularities, maybe let me use that word because that's the language of Rule 42. If the irregularities that we point to are established as a matter of fact on what happened. So let's say, for example, Justice Chafta, that the majority says the issue of the right of appeal does not arise. That's what they say. How can it not arise when the 35O, they're not even saying no, it was not infringed. They say it does not arise. In what world can the 35O rights which are afforded to every accused, not arise at all, let alone not being breached or no, there's a justification and so on. We don't even go there. It does not arise. That is a constitutional error of the most highest magnitude, because what it does is not a theoretical debate as if we're in a constitutional debate. It actually, that thing has resulted in a man sitting in jail now as we speak, right now. So it's not a theoretical infringement of a right that we know we can look at it this way or that way. It has directly resulted in somebody being detained as we speak.
Mr. Mpofu,
I'm sorry, Justice.
Mr. Mpofu, at para 77 of the judgment, it says,
of the judgment, yes.
It is simply unavoidable that a contemner in civil proceedings will not be categorized as an accused person, which means that he will not enjoy those rights that you are referring to.
No, that's wrong, Justice Mkhandla. There's no case that says that, in fact, if that is what was meant, then it was even worse than what we suspected. Because there's no case, all the constitutional court cases on this topic, up to Machabeng, all of them, even Faki, say that to the extent that there are criminal consequences, of course, we accept that it's a hybrid. Of course, we accept that it is not just, it's like saying something is water and sugar, but it's still water. So the mere fact that there is in that amalgam or hybrid or whatever you call it, one of the ingredients there is criminal proceedings, entitles a person. We can call them whatever, accused or Mr. So-and-so, it doesn't really matter. The point is that that person, whatever you call them, is facing criminal consequences, has committed a crime, allegedly, as we have now all agreed. And to that extent that they have committed a crime, they cannot be denuded of the rights of fellow South Africans who have also committed crimes. Whether you call them accused or professor or whatever, it really doesn't matter. The point of the matter is that that human being has, among 100 other things, committed a crime. And to the extent that they've committed a crime, they are entitled, according to Faki, at least to not all the limitation, rather the rights in Section 35, but to some of them. And this is what the minority pointedly said, that the majority was arbitrary. Maybe that's not the words that were used, but the majority simply said, not all the rights are entitled, but it didn't then go and say which ones were applied, which ones were not applied. And that is the height of arbitrariness, because it cannot be left to a court one day to say, okay, there are 20 rights. Today I'll give you the 10. Tomorrow I'll give you 15. Other day I'll give you 6. And I won't even tell you which 6 I gave you. Oh, what is that? Because that,
I'm sorry. I think we have to be loyal to the language of the Constitution.
Right.
It is the very Constitution that says an accused person. So for us to appreciate who is entitled to the rights in 35 sub 3, we will have to look at the Constitution and say, is he an accused person? I understand the argument that you're making about the development of the common law. Remember, we're proceeding from the premise of the common law that brought us this hybridity.
Yes.
And the cases that you are referring to are saying, well, look, you can't use, for example, the civil standard of proof, even if it's motion proceedings, because ultimately you're going to take away the physical freedom or physical liberty of a person.
Yeah.
So that is done in the context of the development of the common law.
Mm-hmm.
The issue of who is entitled to the rights in section 35 sub 3 is resolved by the Constitution itself by saying an accused person. When you look at the rights under sub 2, you will notice that those are conferred on not only accused persons, even those under sub 1. So I was making that narrow point that we shouldn't readily say, well, whether you are an accused or not, it doesn't matter. It may well be that for all intents and purposes, you are an accused in a particular case, even if you are not called an accused. And if in effect you are an accused, you are entitled to those rights and all of them.
Yes, it might well be, Justice Shafter. That might be so, but I don't even need that high argument. All I'm saying, let's assume, for argument's sake, that Faki is right, that you are entitled to some of them. Let's assume, because that's what Faki says. It says, it uses the word not, it's a negative, double negative. It says you're not accused, you are entitled to not all the rights in section 35. So it's fine. Let's say there are 20 rights and you are only entitled to 2 of them. I don't mind. The point will remain, those 2 that you are entitled to according to Faki, according to Machabeng, according to all the cases. Machabeng says at paragraph 69, the applicants in both matters seek leave to appeal a decision of the Free State and the Supreme Court of Appeal respectively on various grounds. And they say the 2 matters raise constitutional issues as the rights in terms of sections 12.1 and 35.3 of the Constitution are implicated. That's what the Constitutional Court said. So the Constitutional Court didn't say, oh, well, because now you are not an accused like your cellmate next door. The section 35.3 rights are no longer available to you. They said the exact opposite. That even though you are this quasi-accused, or whatever we call it, your rights in terms of section 12.1 and 35.3 are implicated. So that's the answer to this. The answer is that, and the criticism really that I was leveling was simply of a lower level, which says that the majority found incorrectly that the 35.3 rights, 35.3.0 does not even arise. But that's not why we're here today to visit the Constitutional Court. We're here because as a result of that finding, they then committed a rescindable error which was not to apply a Section 36 application, which is why the minority was correct, because the minority was correct on both scores. It was that 3530 is implicated, but it doesn't end there. The minority then went to do what we're really complaining about, and that's why this appeal rescission thing it can be confusing, because we're not here to say it's the mere fact that the majority found that 35.3 does not apply is the end of the story, therefore you must rescind the judgment. No. We're saying that fact led to the real rescindable error, which is that because of that appealable error, let's call it like that, the rescindable error then emerged, which is that the Section 36 application was not done. That can never minimize the impact of the procedural irregularity, for lack of a better word, that resulted from denying former President Zuma a process by which a Section 36 analysis was deserved and not implemented. So it's a step-by-step process, but it leads us to the same place, which is that the irregularity, and I'm using that word advisedly just to fit it in to the language of Rule 42, that the irregularity that or the error that were on the granting side is the failure to apply Section 36. But remember, Justice Chafter, that there's also irregularity, or rather the rescindable error of the seeking side. In other words, when it was erroneously sought, and we say that too was committed because it was erroneously sought. The mere fact of having a disguised private prosecution in urgent direct access proceedings is erroneously seeking an imprisonment of a person. Because what the commission should have done, if they were really seeking the imprisonment of a person, is to do what was done in DBA, what was done in Bota, of ensuring that that person goes through not some shortcut route where they are denied their Section 35 rights and their Section 12 rights, but like every other accused person, they go through, and that's the importance of the DBA and Bota analogies, because it begs the very question. When we say the commission should have proceeded in terms of the Commissions Act, we are saying exactly that. We're saying the commission should have done what was done to PW Bota, which is to go through the Commissions Act, and then that way it would have ensured that all his Section 35 rights would have been looked after, just as Mr. De Beer's rights will be looked after, just as like Mr. PW Bota's rights were looked after. And that's the nuance that we introduce in comparing these three, what we call, should this court have adopted the Zuma way, the De Beer way, or the Bota way? And we say whether it had taken the Bota way or the De Beer way, that would have been, constitutionally speaking, the correct thing to do. What the court did now was not the correct thing to do, because it took the route that denies the God-given fundamental rights enshrined in the Bill of Rights. And even if you look at it at that simple level and say there were three roads, it was a three-way intersection. And the court could have taken this route, which was more just and equitable, or taken this route, which was also just and gives Section 35 rights. But it took this route, which leads to the hell that former President Zuma finds himself in as we speak. So that's really at the simplest level is what we are saying. The court granted, therefore, the order in error in those circumstances. But if we are wrong, and it was not a rescindable error, then in any event, this court should grant appropriate relief under Section 38. And if we are wrong in that, because it's optional, it uses the word may, then the court must certainly grant relief under Section 172, because its own, well, not its own, the procedures or the prescripts prescribed by the Constitution were not followed. So it's the same thing as if a high court did not follow Rule 12 or Rule 13 or whatever it is. That court would have to rescind its own judgment. Why? Not because it's appealable or whatever, but simply because it will be saying, oh, we failed to follow the prescripts of the Uniform Rules of Court or whatever. This court is in a similar position. And this court is not, just because it is an apex court, in a better position than any other court of first instance would be. Neither should former President Zuma be in a worse off position and lose his right of having his case reconsidered or reassessed or reevaluated merely because the applicants, or rather the commission, took the shortcut and not the one that is even available to them in terms of the rules of subsidiarity. There must be a reason why the legislature said the commission, when it is aggrieved, as it is here, must proceed in terms of the Commissions Act, because that route ensures that the person they are aggrieved by will also enjoy their right. They will have their right to complain as a complainant, like any other complainant. There's nothing in our law that elevates the commission to better complainant than me if my house has been broken into. If my house has been broken into, I go to the police station and I say, my learned friend, Mr. Masuku, has broken into my house. And then Mr. Masuku will be entitled to his Section 35 rights, Section 12 rights, like everybody else. I can't say, no, I'm just going to go to Braamfontein and get an order that says Mr. Masuku violated my rights by breaking into my house and he must return my goods. And therefore, then he breaches that order. Then he must go to jail tomorrow. It can't be. It can't be. If that is allowed, then it means we're undermining the intelligence of our people, because we're saying to them that the two people could have done exactly the same thing, but by the expedience, because you have lawyers and all sorts of people who can go and go directly to Braamfontein, while your neighbor next door must go to Hillbrow police station for the same thing. Then by that facility, you must deny an accused person. And I use that word advisedly in this context. Where your sole purpose of going to Braamfontein or Hillbrow police station is exactly the same, which is to put that person behind bars. You say, I don't want a coercive order. I don't want all I want is for this person to go to jail, just like my neighbor whose house was broken into. But in this case, because, I don't know, you are the commission or the chair of the commission or whoever, you must bypass all those stages and go straight to Braamfontein on the one hand. On the other side of the coin, because this accused, the one who broke into this house, was of a poor person who cannot go to Braamfontein, then that other accused must then go through the tedious process of the regional court, the high court, the SCA, and the constitutional court. It cannot be like that. There is not a chance that that is what the framers of our constitution intended, because it's unjust, because it is wrong, because it takes for granted the rights of a person, as I say, call them whatever, the one thing we must agree on is that they are human. Whether we call them an accused, whether we call them this or that, the question, are they human? And if they're human, then they're entitled to human rights. They're entitled to all the human rights that are listed in our Constitution without fail. And it doesn't matter if you're a bad person, if you're a child molester, if you are an unpopular president, if you are involved in state capture, or what have you. In fact, the higher, the more vile the person, the more they are entitled to these rights. If they were charged for violating a traffic offense, maybe we can cut corners. But if they are charged for multiple murders and child rape and so on, then we have to stand up even more to ensure that their rights and it doesn't matter if that person has insulted the Constitutional Court with the greatest respect. In a million imaginable ways, that person is entitled to the rights in Section 35. And the rights in Section 35 are orders and instructions to every court of first instance to obey them. If that court of first instance fails to obey them, it has exceeded the Constitution. If it has exceeded the Constitution, its order must be set aside, as it is done every day with orders that come from the High Court or from the Magistrates Court or from any other court. The mere fact that that court happens to be the apex court is neither here nor there in the context that we're discussing. It's just a coincidence of history. Let's assume if there was another court called the Constitutional Court, then we would have taken the matter there. But for practical purposes, the hierarchy of courts has to stop somewhere. And it stops here with you, justices. And it is your unenviable duty to reassess as by whatever means necessary to grant former President Jacob Zuma the right to have his conviction and sentence reassessed that every other human being enjoys. And that right, in this case, can only be exercised through Rule 42, Section 38, or Section 172. But to say that that right exists and it is remediless, it would be a violation of our Constitution. Because if that right exists, then it must have a remedy. And there's nowhere else we can turn to get that remedy except yourselves. And the mere fact, just to come to a question that you raised, Justice Jafta, if we go back again to the narrow Rule 42 issue. We have presented, and because of time, I will not go through them, but we have presented facts which we say were not adduced by the Commission, and which, if they had been adduced, would have had an influence on the outcome. And those facts primarily, just paraphrasing, relate to the age, the medical condition, and so on of the former president. And we say that if you go back to the mitigation issue, if those mitigating factors, the court had also or committed a rescindable error in so far as it negated to apply the so-called triad of justice, which looks at the offender, the nature of the crime, and the interests of society. As far as the offender is concerned, and again, magistrates do this on a daily basis. As far as the offender is concerned, it cannot be that in one passing sentence, we were just told, oh, well, his age was taken into account. Do we know, is he a first offender? Do we know whether he has dependents? Do we know if he has old people or minor children that are dependent on him? Do we know, what do we know about this offender? How can we sentence somebody that when we don't even know what mitigating factors exist or don't exist at the point of conviction? And I'm saying that for a reason, because I know that the question will be, oh, well, but in April, he was given an opportunity. I'm saying if we don't know at the point of conviction whether he has COVID-19 or what, but we feel entitled to sentence him, then we're doing something worse than what every magistrate in this country does, which is to say, accused person, how many children do you have? And they make a note, even if they know what they're going to do. Right? Are you working? No. And then they say, okay, on the basis of this, I'm sentencing you to 15 months. But this court, the Constitutional Court, no less, has found it possible to sentence somebody to imprisonment directly without the option of a fine, without the option of even purging the contempt, without going into those questions. Please, justices, if this, your task in this case is to look beyond the history, look beyond the insults, look beyond the whatever, look beyond the cocking a snook at opportunities that were granted by this court, and simply say exactly because of that, exactly because as they said in Esma Kwanyane, the rights in the Constitution are reserved for the worst among us, the worst. So it does not say the death sentence is unconstitutional, but if you kill 200 people and those 200 people are children of 6 months old, then, well, that's where we draw the line. It doesn't work like that. The death sentence is unconstitutional, full stop. Whether you have insulted the court, whether you have molested babies, whatever, if it's unconstitutional, it's unconstitutional. We can't have different rules for those who insulted us or those who have gone around vilifying us. And that is not whether they are guilty or not of insulting us. They may well be, I don't know. But that question will be answered one day in the magistrate's court in Nkandla. That's where the question should be answered, not here. Whether the letter was so scurrilous and what have you must be answered in the magistrate's court in Nkandla, not in Braamfontein in the Constitutional Court, as more so by the people who were the victims of that insult. So it must be answered by someone else dispassionate, who will say, you can, just like Mr. De Beer's unacceptable insults to the SCA will be answered one day by the magistrate wherever he lives. And that magistrate will then say, Mr. De Beer, how could you say this to the Constitution, to the SCA? But the SCA can't say, well, you insulted us, you must come here. We'll sentence you to 15 months tomorrow. No, that is an injustice. It is not allowed by the Constitution. It is unconstitutional. It should not be allowed to stand like any other unconstitutional conduct. If you look at it as conduct, if you look at it as law, as when I started, let's take that order now as a law, as a statute, then it's an unconstitutional law. And it is on the basis of that unconstitutional law or conduct that former President Jacob Zuma, as we speak, is sitting in a cell somewhere in Escort, where he should not be. For as long as this injustice is corrected and remedied, then the doors of the Escort prison must be swung open so that, like any other accused who is a victim of a constitutional limitation, the processes that should be followed. And Justice Nhlanhla, just to come back to you, yes, we do say that the those orders must therefore be expunged for those reasons. And whatever else will happen, as I say, will happen, which is what happens to every other accused. It might well be that the process, which the commission now tells us that they did start it at the police station, will take its course. And that's another complaint we make, to come back, Justice Chapter, that even this was not disclosed. Actually, the minority was under the impression that that process was not followed. We're now told that actually the charge was indeed laid under the Commissions Act at the Hillbrow police station, and the papers have been annexed. So that is the process that must take its course. It doesn't matter that it will take long. It doesn't matter that we might be angry and we might want swift justice. And we cannot want it to have it both ways. We can't say we want swift justice on the one hand, and then we say, no, but this is not the Mamabulo situation. Because the Mamabulo, S versus Mamabulo situation is exactly where swift justice is asked for. So when we say this is a summary process, again, we're not wedded to the terminological exactitudes of that term. We are saying it is a summary process compared to a normal criminal trial. So we can call it what we call it, but it is swift justice, and that swift justice must follow Section 35 and Section 12. Thank you, Justices. Those are our submissions. What we really say is that there are other...
Mr. Mpofu, just before
you... Yes, Justice Matlanga.
Just a matter of clarity. What, if anything at all, should remain of civil contempt?
Civil contempt, well, firstly, it must remain a crime. So let's start there. And if it remains a crime, then all we need to do is to do, short of whatever is happening in Maritzburg, where we are attacking its constitutionality. Let's put that aside. As we speak now, this is what should happen, Justice Matlanga. Every time, excuse me, a person is brought before a court, whether it's the civil court or a criminal court or whatever, a court, or the constitutional court for that matter. Every time a person is brought before a court of law, and one of the things that they are in jeopardy of suffering is imprisonment for committing a crime, every time, then the rights in Section 35 must be accorded to that person. Whether that person is, as I say, is in a particular setting called the applicant or the respondent, whether in another setting they are called the accused, whether in another setting they are called this, that, or the other, a human being who is facing criminal consequences, one of which is incarceration in a cell because of the power of the state, that person is entitled to Section 35. Because the power of the state to put somebody in the escort correctional services does not come, correctional center, does not come from the air. If those people who took former President Zuma there to that place had taken them to their garage in their house, they would be guilty of a crime. The only reason why they are not guilty is because the power of the state entitles them to take him to escort correctional center. And once that is the consequence, then Section 35 accrues. Even, as I said, in a state of emergency, it's one of the non-derogable rights. Then dignity accrues. Then equality accrues. Then Section 12 accrues.
Maybe to be more direct, even where a court, where the relief sought is a coercive order, which of course is sometimes coupled with the possibility of imprisonment. So you would still say the full gamut of your Section 35 rights must come into the. It's obligatory.
No, I didn't say
that. That's what I had in mind. You know, when
okay.
I what, if anything at all, should remain of civil contempt.
Yes. What should remain of civil contempt, Justice Madlanga, is what was said in the case of Faki, and what has been said in Machabeng, what has been said in Peko, which is that to the extent that, and it was in that context that those cases used the word accused in inverted commas, to the extent that the person, the human being, is facing criminal consequences, and they are quasi-accused, as I just okay. In the case of Bechel, which was approved in most in Machabeng and in Peko, I think it is said. Froneman J said the following at paragraph 8. Is committal for civil contempt still a criminal offense under the Constitution? That's the heading. Then he says, in my respectful view, this is a fundamental question that needs to be resolved right at the start of an analysis or discussion. If committal for civil contempt remains a criminal offense under the Constitution, then it inevitably follows that a respondent in such committal for contempt proceedings is an accused person under Section 35(3) of the Constitution. The constitutionality of the civil contempt procedure, as well as the nature and incidence of owners, the need to be assessed in the context of the respondent's right to a fair trial under Section 35(3). And it says, to hold that a respondent in civil contempt for committal proceeding is not an accused person would be a radical departure from our common law, right? So it cannot be clearer than that. To hold that a respondent in civil contempt for committal proceedings is not an accused person would be a radical departure from our common law. And it says at paragraph 11, upholding the rule of law and effective administration of justice would thus, in general, justify the retention of committal for civil contempt as a form of the crime of contempt of court under the Constitution. In my view, it cannot be denied that the entrenchment of the individual right to freedom and security is a fundamental right, and so on. And then under a separate section, he says, are civil contempt proceedings consistent with fair trial provisions of Section 35(3)? Then he says, paragraph 14, two distinct but interrelated aspects arise in this regard. This is the part I was looking for, where the hybridity is explained better. The first is whether the civil application procedure lends itself to conformity with the fair criminal trial safeguards in Section 35(3). The second is whether the nature and incidence of the onus in a criminal trial, namely proof beyond reasonable doubt of the guilt of the offender to be discharged by the prosecution, should and can be accommodated in such proceedings. And then the last part, Justice, it says, the same paragraph 17, the same constitutional considerations at issue in committal for civil contempt of court orders, upholding the rule of law, the need for effective administration of justice, the protection of an individual human being's right to freedom and security, and the fair trial provisions of Section 35(3) of the Constitution. It says, were present in some form or another in Singo and in S versus Mamabulo. So that distinction, as I say, is a distinction without any difference. Because in both instances, whether it is criminal contempt or civil contempt, as a la Mamabulo versus this case, the protections in Section 35(3) apply. Yes, so that's really the answer. It doesn't, the label really doesn't matter. Whether you call it civil contempt, it's a crime. And that crime, it could be shoplifting, civil contempt, bank robbery, it doesn't matter. That crime must entitle an accused person, as described here by Justice Foreman, to the rights that are in Section 35.3. And the simple question then becomes, did that happen? Yes or no? Were those rights limited? Yes or no? Was the right to mitigation limited? Yes or no? Was the right to appeal limited? Yes or no? Was the right to whatever? Cross-examination, it could be any of the rights in 35.3. Yes or no? And if it was honored, that's the end, then we all go home. If it was not honored, then a Section 36 application must be made. And if even that is not passed, then the person must go to jail or whatever needs to happen. I'm sorry, I know this is a long answer, Justice Madlanga, but it's at the heart. It's at the heart of that question is at the heart of this is what Froneman J went on to say at paragraph 27. Civil contempt proceedings have always had a dual nature. Yes, and I prefer for the purposes of this case to use that word dual than amalgam or hybrid, because that gives a notion of something which is untraceable. You know, once it's an amalgam, you can no longer take away the sugar from the water. But here, a dual, in other words, it has two legs. And the discussion thus far has focused only on its criminal aspect. So it has a criminal aspect that is self-standing and fulsome. In my judgment, the perceived difficulties associated with its continued treatment as a criminal offense should not prevent attention being given also to its purely civil character and the possible development of the common law in that regard. I love this, because what it does is to say, insofar as it is a civil proceeding, how do we look at it? And then we close that door. Then we say, insofar as it is a criminal proceeding, how do we look at it? And it says, in addition to its retention as a criminal offense, albeit with a stricter standard of proof, the potential effectiveness of issuing a civil declaratory order that an offending litigant is in contempt of court should not be underestimated. Such a declaration would have as its purpose to uphold the rule of law. And that's where the intersection of the two things happen. As you know, Justice Madlanga, in Faki, that was where the line was drawn. That you may ask for a declarator, you may ask for all the civil consequences which would follow, including, by the way, the so-called coercive order. You may ask if it was a contract. You may ask for the performance of that specific performance, let's call it, and all those things. And you may end there. But once you move away from there and you now also want the person to be locked up, then we are in a different world. We are now in a world where that person must be treated as an accused to that extent. And it's not a second-class accused. No, there's no such thing. To the extent that that person is treated as an accused, then they must be accorded the rights in Section 35.3. Whether all of them, some of them, one of them, 15 of them, 60, well, I'm not debating that for now. I'm simply saying they must be afforded those rights. And there must be, at least those that are being afforded must be afforded fully. As you, Justice Madlanga, found in the case of Van der Walt, in relation to the question of mitigation, for example. Can we say, honestly, objectively, looking at it coldly, that the person in this case was accorded their right to mitigation fully in the circumstances that we've described earlier? If the answer to that question is yes, then we must lose. But if the answer to that question is no, then we must succeed. Can anyone objectively, coldly, dispassionately, arm's length, say that the right of appeal or reassessment in this case was sitting with was not limited to any extent? If the answer is yes, we can say that boldly, that the right to appeal was not limited. Well, then we must lose. Because what are we doing here? But if the right to appeal was limited to any extent, by whatever, for whatever good reason, whether it is because there was direct access or whatever, but if it was limited for that good reason, then we must succeed. If the right to dignity, the right to equality, if, as we sit now, the person sitting in the cell next to that of former President Zuma was treated with dignity and was given his fair trial rights, but he was not, then Section 9 of the Constitution, which guarantees all of us equal protection before the law, was not honored. Because his protection before the law must be the same as the person sitting in the cell next to him. Even if he insulted the Constitutional Court or the Queen or the King or whoever, he must be treated as in the equal fashion as the person sitting next to him. Can we say that he was accorded the same rights as the person in the cell next to him now? Yes or no? If the answer is yes, we must lose. If the answer is no, we must succeed. Is he being punished for expressing an opinion about the Zondo Commission and exercising his rights, as in the Mababulo example of expression? I don't know. Maybe that's what he will argue in the magistrate's court, that in any event, I was not supposed to be convicted because I was exercising my Section 16 rights of expression by criticizing the Zondo Commission. I didn't know that it will earn me a 15-year jail sentence. Unlike other human beings who are free to criticize whoever they want to criticize within boundaries. Section 10, we can go through the entire Constitution. The fact is that Section 9, Section 10, Section 15, Section 16, Section 35, Section 12 of the Constitution, those rights were limited in this case, undeniably. And if they were, then this court did something more than a rescindable error. It did a constitutional rescindable error, or a series of them. And that judgment cannot stand. It can't. On what basis? It can only stand on the basis that we say, well, the Constitutional Court is not capable, unlike magistrates, the Constitutional Court is not capable of having a judgment that must be reassessed like all other judgments in criminal proceedings. Well, if that can never be our law, because what was said in Shinga was that the job that we're asking you to do, Justice Madlanga, was described as follows in relation to the magistrate, and I dare say it applies equally to this court in this context. It was enforcing or re-emphasizing the rights 3530, the importance of that right. It says, although that task has now got to be carried out by magistrates, and before, I'm sorry, I'm reading from paragraph 53. It says, under Section 309 procedure, it's a judicial task of some delicacy. Oh no, sorry, let me start with the previous sentence. This task that has been carried out by the High Court judges for many years, but it is new to magistrates under Section 309B procedure. But here's the important part. It says, it is a judicial task of some delicacy and expertise. In other words, the task of reassessing the thing. it should be approached on the footing of intellectual humility and integrity, neither overzealously endorsing the ineluctable correctness of the decision that has been reached, nor over anxiously referring decisions that are indubitably correct to an appellate court. What that means is that the task that and we apologize for this, that we are imposing on this court is not an easy task. We know this. It's the same task, Justice Madlanga, I know that same task that you perform when you apply for leave to appeal. It's an unenviable task because judges are human beings, contrary to
let me say this. Let me say this. You prefaced your last point by being apologetic. You should not be apologetic at all.
Thank you, Justice. Thank you for the permission. Well, on that note, you might regret giving me that permission, Justice. I think I'm better off when I'm apologetic.
Well, you know, but you know the rules of ethics.
Of course. No, thank you, Justice. That was on a lighter note. The point I was making on a serious note, Justice Madlanga, is that judges are human. We are all human. As human as the magistrates are, as human as the judges of the Constitutional Court are. All of us, when we are assuming the judicial pose, must be susceptible to the very same rule that an accused person is entitled to a reassessment of their. There's no special accused or special tribunal that must be immune from that. And the reason why I was apologizing is exactly because the suggestion that comes from that quote might be that I'm suggesting that this court will not approach the matter with the requisite doses of humility and and integrity, and I am not. Speaking for myself, I have no doubt that this court will approach this matter like any other matter. Whether it was this court, indeed it was, that was allegedly insulted, is neither here nor there. It could have been any other institution. This court will be true to the fidelity of the oath taken of office taken by all of you with respect, that whatever provocation might be there, the simple questions must be simplified to the basic level, where the rights in section 35 followed, yes or no, where the rights in section 12, and so on and so on and so on. And if this court finds that yes, those rights were abrogated, and yet it failed to go to stage 2, as the minority was imploring it to do, or that it failed to take the approach taken by the SCA, which I accept is a lower court, but the point I'm making is that 5 judges and 2 judges of the Constitutional Court within 48 hours felt correctly, in my respectful submission, that an accused person like this should be sent to the NDPP. 7, that's 7 judges. 7 judges making up the majority felt that that is not necessary to go to the NDPP. That is where we are as a country now, where we have 7 judges of the highest courts finding that one should go what I call the De Beers way, the NDPP way, maybe let's call it that. And the other 7 judges of the same country finding that we must do it the Zuma way, which is no trial, detention without trial, which is exactly what 12(1)(b) says should not be done, which is a violation of 35(0), dignity, equality, and so on. That's it. That's the choice this court has. The Zuma way, the NDPP, or the Batoyi way, let's call it. Because this matter should, if we are going to be true to the Constitution, be referred to the proper authorities to deal with it as any other criminal offense, which I concede this is, if assuming for now again that the conviction was correct, then it's nothing else but a crime. Why is it different? Why? Because the chairperson of the State Capture Commission was the one who was defied. No, can't be. Whether it's the chairperson of the State Capture Commission or the owner of a Plaza shop in a township who was insulted, the crime should be the same. Whether it's somebody who has access to senior counsel who can go to the Constitutional Court, it should be the same. Whether that person elects to oppose or not to oppose those proceedings in the Constitutional Court, that's got absolutely nothing to do with it. Whether that person then is given an opportunity for mitigation and they write a rude letter in return, what has that got to do with it? Absolutely nothing.
Mr.
Nothing.
Mbofu.
Nothing.
Mr. Mbofu, let me see if I understand the argument broadly. You're not asking us to allow your client to exercise his right to appeal. You're not asking.
That's a difficult question, Justice Chapter. Let me say why I'm saying it's difficult.
Case, that's why we ask difficult questions.
Of course. No, I'm saying that in the most welcoming manner of the word. Yeah. The reason that it's difficult is this, Justice Chapter. I'm not asking you primarily. In other words, I'm not saying you should give him a right of appeal here, for example. But I'm saying if you do what was done in De Beer, then by logical implication, his right, like any other human being, his right to appeal will be incurred. So it is in that sense that I'm saying it's a difficult question. So I'm not saying this court must now put an order that says President Zuma must be given the right to appeal. No. The mere fact that he is afforded that right of appeal is already, it won't be given by you with the greatest respect to you. It was given to him by the Constitution. So it's not for you to give or to take it.
My question was, if you listen to how I carefully prefaced it, is
yes.
You're not asking us to allow him to exercise the right. He has the right. He has not exercised it. So that's my question.
Yes, no, I agree.
You see, what concerns me, on the one hand, we have this court as the apex court.
Yes.
And that must mean that its decisions are final.
Correct.
They can't appeal against further.
Correct.
But as I understand, your argument is that, no, courts, apex courts all over the world have the power to reconsider their decisions. So the issue is whether or not here we agree with you that that pathway of reconsideration has been satisfied.
Absolutely.
And if it has been, then there's nothing novel about an apex court reconsidering its decision.
Absolutely.
Now, as I understand your argument, broadly, it says, well, here, look at the limitations of the rights. And that, or those limitations constitute non-compliance, for lack of a better word, non-compliance with the Constitution. Now, I want to know whether on this process, putting aside Rule 42, because we talked about Rule 42, we know its requirements. On this approach, does it mean then that reconsideration and rescission must be available in every case where it is shown that the decision is not consistent with the Constitution?
Yes and no. That's a lawyer's answer. No, to the extent that some of those decisions, or rather some of that reconsideration, if we use the word neutrally, would in any event happen even in an appeal, then of course that reconsideration would happen in that context. But insofar as the reconsideration is sought before this court, on the available avenue of Rule 42, which was made specifically available by Rule 29 of the rules of this court, consciously, then the reconsideration is available on that route, number one. And then, as you said, Justice Jafta, insofar as the reconsideration is also competent under either Section 38 or Section 172, then it is also competent on that basis. But it does not mean that so the answer is, the real lawyer's answer is, it depends. So if a particular applicant came here and said, I'm putting my colors to the mast, I don't care about Section 38, I don't care about Section 172, I'm here with Rule 42, I don't even care about the common law rescission, then that applicant must then satisfy the requirements of Rule 42. If, however, applicant B says, I'm here for Rule 42, alternatively the common law, then that applicant B must certify those rules. If applicant C, President Zuma says, I'm here and I'm invoking 42 common
Wi-Fi. An interruption.
Like, oh my God.
Thank you, Justice.
Kampepe, I'm very sorry. Please, can I ask Zune to check who Mpoteme is and whether she should be allowed or he should be allowed into this room?
I think it's the fake.
I have managed to mute them, Justice Kampepe. I think we can carry on in the meantime.
Thank you. Yes, Mr. Mpofu.
Yes, well, the answer is, the short answer is, after that interruption, I'll shorten my answer. The short answer is no, not every applicant. It depends on which applicant you have before you, and what relief they are seeking under which provision of the Constitution. And in Makwanyane, it was said that these assessments must, well, not just in Makwanyane, in almost every case, must be done on the case-by-case basis, particularly under Section 172, because as you know, that's a flexible remedy. There's actually no end to what remedies you might be entitled to under Section 172. It's up to the court. It can order literally anything, well, within the bounds of reason.
Now, you see, my problem is law must be clear. That's what the rule of law requires.
Yes.
If we are to say, in addition to the requirements of Rule 42, rescission is available, we have to specify the circumstances so that litigants beforehand can know that I can ask the Constitutional Court to reconsider its decision because I fall within the group or category of litigants who can do that. So I wanted to know whether one can go insofar as to say any decision that is not consistent with the Constitution is subject to reconsideration. So anybody might say, in this matter, the decision is not consistent with a provision of the Constitution, even if it's not the Bill of Rights. They can say, court, please reconsider your decision. I want to know how far we can go, because now we are on uncharted territory, so to speak.
Well, Justice Chapter, at least if the one thing that the majority cannot be accused of, it's not saying that. They did say many times we're in uncharted territory. So here we are. So the answer, that's what I said, the answer was yes and no. I answered the no part. I say yes to the following extent. To the extent that, Justice Chapter, one can be able to distill from whatever it is that you are accusing the court of having done or not done. But if that thing amounts to a violation of the Constitution, then inevitably you are in the land of Section 2 of the Constitution, read with Section 172, 1A. What does Section 2 say? Any conduct or law or court order that is not consistent with the Constitution is invalid. Full stop. So if you can show that the conduct or law or court order or regulation or constitution of a soccer club is inconsistent with the Constitution, then it is invalid. But then what do? You are now a litigant. So what? Then you proceed under Section 38 or 172, or rather the court then says what I said earlier, ubi ius, ibi remedium. Once you have that right, there must be a remedy. Where is that remedy to be found? It will be found in Section 172, which says that 172.1a, any law or conduct which is inconsistent with the Constitution must be declared, must be so declared and be invalid to the extent of its inconsistency. And so the mere fact that that act comes from something called the Constitutional Court, or whether it comes from the Johannesburg City Council, is irrelevant for the purposes of this discussion. That conduct which is inconsistent with the Constitution must A, be declared invalid, and B, must be a remedy must then flow. So there's no special rule. It's irrelevant. That is the Constitutional Court. It's just another organ of state. Well, okay, maybe that's pushing it. It's just a public entity. Let me call it like that. You know what I mean, Justice Chaft. So so any conduct on the part of anybody that is inconsistent with the Constitution is invalid.
And on your submissions, this expanded rescission is only available to decisions of this court.
Yes.
If it's a decision of the High Court where an appeal is available, it should not be allowed. Is that the argument?
Again, not quite. The point I'm making is that it might well be that that statement is correct for the following reason, Justice Chapter, and I'll qualify it later. Because we know as a matter of fact and as a matter of law, and we all accept that the decisions of this court are not appealable. So if a client comes to my chambers and says this decision of the High Court the court exceeded its mandate or jurisdiction, what can we do about it? I might say to that client, well, it depends, as we always say. If that is an appealable matter in any event, well, we might as well then just proceed in terms of Section 19, or rather Rule 19, and also raise this issue that the High Court exceeded its mandate anyway. But if the following day another client comes with a similar problem, but they say, but this time it was a decision of the High Court, then my first answer, I won't even go there. I won't even talk about Rule 19, because Rule 19 does not apply. So I will then say to that client, well, let's then look at Rule 29 and see whether Rule 29 applies. If it does, it does. If it doesn't, it doesn't. So that's the reality of the differentiation between the two courts. So only if I find that on the facts of that case, the Rule 29 read with Rule 42 applies, then we go ahead. Otherwise, it's goodbye to that client.
Now, as a matter of setting principle, are you suggesting then that in the case of a decision of the High Court, it is up to the choice of the litigant whether to seek rescission as expanded or an appeal? Is that the submission?
Yes, absolutely. But the tricky part is that, and this is the question I don't have a ready answer for. The tricky part, the reason why I was a bit hesitant is because the real question would be, okay, let's assume then you take, for the client A, you then go to the Constitutional Court and say, well, I'm appealing, but also there was a rescindable error somewhere in the mix. Then the Constitutional Court, does it then apply the expanded Rule 29 version of the Rule 42 or the pure quote unquote Rule 42? But that's not the question you're asking me, Justice Chapter. Is the short answer is that what you call the expanded version applies when the Rule 29 applies. I think that's the.
I don't understand that answer.
Okay.
Perhaps you can help me.
Yes, I'll help you.
I don't understand why, and Rule 29 of which rules? I'm talking
the Concord rules.
No, we talking about, we settled that one. Remember,
yes.
You said to me, because you can't appeal, the decision of this court is final. You have to expand the room for rescission so that there can be reconsideration of unjust decisions.
Yes.
Okay.
Now you. At first you use the word rescission, and I wanted to correct you. No, that formulation I agree with. Reconsideration, not necessarily rescission. Yes.
Well, Mr. Mbofu, if the decision is wrong in law or it's unconstitutional, as you put it in your argument, and this court agrees with you, is there any other option other than rescinding it?
Yes.
What is the option?
The first option is, in fact, there are more options than even those we have discussed. The first option would be rescission, as we all know it, right? Normal Rule 42. So you could go that route. The second option would be rescission a la Rule 29. In other words, with such modifications as may be necessary. That's another route related to the first, but it's what Justice Majid and I were discussing in the morning.
Take me to Rule 29. Take me to Rule 29 so that I can
Yes.
follow.
Rule 29 says
what?
Are you there, Justice Chapter?
Yes.
Yes. The following rules of the uniform rules of the High Court shall, quote, with such modifications as may be necessary, otherwise mutatis mutandis, apply to proceedings in the court, in the Constitutional Court. And then one of those is Rule 42.
So now, Rule 29 incorporates rules of the High Court into the rules of this court.
Yes, with
Rule
such modification.
Yes, but Rule 29 itself doesn't grant you rescission. And your submission was Rule 29 grants you rescission.
No, that's not our submission. For that, that's easy to dispel. If you can go to page 1 of the record.
I'm talking about, I'm sorry, Mr. Mpofu. You see, I was listening to your oral submission now. What I'm trying to get at, and because it's late in the day, I want us to cut to the chase. I understood your argument to be this. We are not asking for an appeal here because you can't appeal. We are asking for the expansion or, opening up of the scope of rescission, because this court is the only court that can reconsider its decision. Then that I understand. Now I was saying to you, will that apply? Because remember, we went through the exercise of saying, in every decision which is not consistent with the Constitution, a decision of this court, which is not consistent with the Constitution, there must be a reconsideration because it cannot otherwise be corrected. Okay? Now I moved away from that. I said, what would that expanded rescission also be available to decisions of other courts where there is an option to appeal? We talked about that, and you ended up saying to me, well, it would be a matter of choice of each litigant whether, if they are faced with a decision of the High Court that is not consistent with the Constitution, whether they want to appeal against it or they want to institute a rescission. So we were debating that, because if we are to say that in our judgment, it has profound implications to the law relating to appeals. Because remember, you and I know that if a decision is still susceptible to be corrected by the court that made the decision, you can't appeal against that. You have to deal with it there.
Yes.
So that is why I'm trying to understand how far we should go in clarifying the law on this uncharted territory.
Yes. Thank you, Justice Chapter. Well, for the purposes of this applicant, you should not go further than what I've argued. But for the purposes of developing the law, I accept without any, in fact, that's what I was explaining, Justice Chapter. I'm saying for the purposes of the options that would be available to any litigant faced with what you and I are calling an unconstitutional or exceeding of the Constitution or a violation or whatever you call it. Then I was simply saying that litigant has got at least four, there might be more, I don't know, options. That litigant could come to you and say, I am coming to rescind this judgment, simpliciter. Or the litigant might say, I'm coming to ask you for the rescission of that judgment, bearing in mind that you are the constitutional court, and therefore you must put such modification as may be necessary. Or they might say, I'm coming to you purely, forget Rule 42, I'm not interested in Rule 42. I'm coming to you to say, under Section 38, you must grant appropriate relief because my rights have been infringed. Or fourthly, they might say, I'm not interested in Rule 42, expanded or unexpanded. I'm not interested in Section 38 either. I'm here because under Section 172(1)(a), my conduct or law that is inconsistent with the Constitution has happened, and I want you to declare it as such and give me a remedy under 172(1)(b). Those are, as I say, the minimum, at least off the top of my head, those would be the four options available to such a litigant. There may be others. So what am I saying? I'm saying that a litigant is not forced to want to squeeze in some expanded definition of Rule 42. If that litigant is confident that under the other four options, they would equally get the joy of the Constitutional Court. But if a litigant, for argument's sake, has chosen, as this one has, to come and say, I'm asking the court to consider the whole gamut of these available options. A litigant is entitled to do that. Because the prize is one, setting aside those. So whether you set them aside by means of an appeal, by means of an expanded Rule 42, by means of 172 attack, or this or the other, really, from the point of view of the litigant, that's not an issue. From the point of the court, I would say you draw the line at saying that if you come before us under Rule 42, then at the minimum, you must satisfy the requirements of that rule, except the following. This is where the qualification comes in. In defining what is a rescindable error or a rescindable omission in the context of constitutional litigation, surely that concept cannot be limited to a breach of the rules of the Concord. It must also extend to a breach of the procedural rules, such as the application of Section 36, which are prescribed by the Constitution, or the other prescriptions of the Constitution, such as those prescribed by Section 35, and so on and so on. So otherwise, what you said in that case, in that Transkei case, would not apply, because when we say an irregularity can be rescindable, surely that must embrace what you and I are discussing now, which is an irregularity committed by the Constitutional Court in that it exceeded its powers, or whatever the accusation might be from case to case. Because that's a higher form of irregularity. So the higher form of irregularity must a fortiori be embraced if even a mere procedural irregularity could entitle me to rescission.
Thank you, Mr. Mpofu. I guess what I was trying to establish was, once we expand the scope of Rule 42, does that expanded scope also apply to the rule when invoked in the High Court? But I think I got
okay. I see what you mean. Well, but remember, I'm afraid, Justice Chapter, there's a disjuncture with I remember, we're not here to ask for you to expand Rule 42 primarily. We're first saying you must apply Rule 42 as it is. But we're saying if under the normal Rule 42, relief cannot be granted, it is open to this court to expand the rule. And then we go on and on and on. So I don't want ever to be misunderstood to be saying that the first thing that we're asking for this court is an expanded Rule 42. And that's the reticence in my answer only owes to that fact. But to the extent that Rule 42 may have to be expanded, then I understand your question. I agree that it would have to be extended for all time, so to speak, because yes, for every court. Yeah.
Thank you, Mr. Mpofu.
Thank you, Justice. Well, there's just a compare 5 minutes, I promise, or even less. There's just one aspect that which we have raised in the supplementary affidavit we filed on Friday.
Yes, Mr. Mpofu.
Thank you. And it's a quick one. It really applies to this issue of assuming if the judgment of this court will be reserved, then what should happen in the interim? And again, just taking on the discussion I just had with Justice Chapter, we have said in the supplementary affidavit that we've submitted that in terms of both sections 172 and 173, this court would be empowered to fashion the remedy that we seek there, namely that in that eventuality, in the interim, the former president be released from custody on the basis that, of course, the outcome it's the usual irreparable harm kind of test, because we don't we don't say this lightly. The previous court took 3 months on urgent proceedings, and by the way, we're indebted to the court for having treated this matter as an urgent matter. But as we know, it might take, even if it's a day or two, it doesn't really matter, because a person's liberty is important. And we implore this court to exercise its jurisdiction to grant under 172 that interim relief. As the court knows, we approached the Pietermaritzburg High Court, but it came with the view, which we will probably bring back to this court, that it had no jurisdiction to grant even interim relief pendente lite, simply because the main case, the decision, was in the Constitutional Court. We don't think that is our law at all. It's very clear that it is not, but as we have to respect court outcomes, and therefore the current state, and that is the court, by the way, where we are also challenging the discussion I had with Justice, I think it was Justice Majid, where we are raising the issue of the constitutionality of no, it was Justice Jaff, of this contempt of court regime. And we simply wanted from that court interim relief pending that attack on the constitutionality and pending this rescission. And the court, as I say, found that it had no jurisdiction to grant that interim relief. Unfortunately so. And that state of events that led to the reality now that Mr. Jacob Zuma is in prison, because the police were now in a quagmire. Either they are to be charged with contempt of court for not arresting, or they'll be charged for contempt of court for arresting when they know that they are pending proceedings. In the judgment of Piccoli, I think, says that if any official actually executes when they know that there's a pending court judgment, they may be found to be in contempt. And obviously, faced with those two evils, they chose the evil of erring on the side of effecting the arrest. Unfortunately, we wish they had chosen the other option. But that's where we are, and therefore we implore this court as a court of justice, in the interest of justice, part of its just and equitable jurisdiction, for obvious reasons, that if it is found a month from now, a day from now, 2 days from now, 2 months from now, that the arrest was invalid, then it would be, to say it would be irreparable, it would be an understatement, because it's a person's liberty we're talking about. And if, on the other hand, it is found that the arrest warrant was valid, then nobody will suffer anything, because then the sentence will be served at that point. Former President Zuma is not by anybody's description a flight risk or anything of that sort. Whether the sentence is served now or served next month or whenever, it really should make no difference. It's just cruelty, cruel and degrading punishment for him to remain there while waiting for the outcome, which may or may not be favorable to him. He's a 79-year-old person who suffers from comorbidities, and he is. We know the state of the health in the country at the moment, and as we said before the High Court, he is always in the custody of the law enforcement officers anyway, because his security detail is made of those. So there can be no, except really to just be vindictiveness for any party to suggest that he should await for the outcome while he's sitting there. We don't expect that anybody will be that callous and cruel, but you never know.
Mr. Mpofu, sorry, I have a final question. It relates to the application to lead further evidence. Actually, it's two questions. How can this application be granted where the applicant refused to participate in the proceedings? That's my first question. The second question would be, what route would the applicant have followed to lead further evidence had this played out in the High Court, for example, or in the Magistrates Court?
Yes. Thank you, Justice Theron. Yeah, thank you very much. Firstly, you will remember that one of the gravamen of the findings of the majority was that, quote unquote, there was no hope that former President Zuma would obey an order to appear before the commission. And therefore, it would be a brutum fulmen to order that. Well, we have presented to this court evidence unrefuted, where President Zuma himself says that, in actual fact, even in the letters that are criticized, I have never said that I will not appear before the commission. One, in fact, this whole dispute arose in the course of my second or third appearance before that commission. So we're not dealing here with someone who says, like P.W. Botha, this is a circus or a Mickey Mouse thing, I'm not going to be part of it. He has been there, everybody knows in the country. He has been there more than once. The only issue that needs to be resolved is whether, rightly or wrongly, he has the right, like all of us, to say, I will not be tried by a person that I'm saying is biased against me. And that does not mean that that person is biased. It simply means that former President Zuma perceives that person to be biased. That's sufficient in our law. And former President Zuma has considered before this court that in the best way to assert that right would have been to approach another court for interim relief pending the review application. And that has been established in the public protector cases. And when we say that, people out there, they say, no, we're saying that he got the wrong legal advice or bad legal advice. That's not what we're saying. What we're saying is that any lawyer can give you different advice. I probably would have given them the same advice, which is that it's unlikely that the Constitutional Court would hear a criminal case on an urgent basis and direct access. And if it turns out to be wrong, well, it turns out to be wrong. But it can be that the mere acceptance of that advice must land you in jail, with respect. So that's my first answer. There is no evidence that former President Zuma would not appear before the commission subject to what I have said. On the contrary, there's evidence that he's a willing participant. In his statements, some of the scurrilous statements make that point exactly. But can this court then go as far as to say Mr. Zuma must be forced to appear even if he thinks that the person is biased? No, it can't. But this court has every right to say that if you think anybody is biased, then you must just follow the law like everybody else. That we will accept. The second point related to that, by the way, is the fact that the term of the commission has been expanded, I think, to the end of September. And therefore, all things being equal, he can appear between, it's no longer the situation. Remember, the so-called urgency, which was argued before this court, was based on the fact that the term of the commission was ending in March. Well, it was expanded to June and then again to now. So that alone is a factor that is a new factor before this court, which would, on its own right, entitle this court to reconsider that decision. But we're not there now. So the short answer is yes, it can still be done, Justice Theron. There's nothing, nobody has brought any evidence to refute the evidence in the founding affidavit of justice of former President Zuma that he is willing to go, and that he concedes that it might require him having to ask for interim relief. In fact, speaking for myself, I won't say I have instructions on that. That's exactly what I would advise him to do. It would be to either go to the commission, but if he feels strongly that he should not go there, to follow the route of the law and do whatever is necessary to delay that. And the court might say, if the court says no, you must go, then he would have to go. Because as he says, for the past 20 years, he's a person who has been obeying the rules of the court. And he does not subscribe to the notion that anybody is above the law. If he did, he would not have been going in and out of courts for the past 20 years, or even to this commission for the past 2 years.
Yes, Mr. Mpofu.
Sorry, Justice Mpepe. You haven't answered my second question, Justice, Mr. Mpofu.
Thank you, Justice Taran. If you can remind me.
What options would have been open to the applicant if this matter had played out in the High Court regarding the application to leave further evidence?
Okay. Well, the whichever court would have, if it granted him that the mitigation on the mitigation issue in particular, because that's where he really that's what he was referring to, the medical evidence and all that. Then if it was in the High Court, well, it wouldn't matter which court, Justice Theron, in my respectful submission. But if any court granted him that audience, it would have to be either this court to determine the issue of sentence. But remember, that's not what we are primarily asking for. We're asking for the relief that was envisaged in the minority judgment and in De Beer, in which case the matter would be referred to the correct authorities, let's say the NDPP. And in that arena, then of course he would be free to raise or refuse to raise any issue that he wants, like all litigants. If he said, like many people did in the 70s and the 80s, I'm not going to participate in this court because of this and that, I'm a conscientious objector, then he'll be treated like those people were treated. And the trial will be conducted in those, under those. There'll be nothing extraordinary that would have to be extended to him. He would have the same rights like any other accused person.
Thank you, Mr. Mpofu.
Thank you so much, Justice Kabebe. Thank you, Justices. These are our submissions.
Thank you, Mr. Mpofu. The court will take a short adjournment of 30 minutes.
Thank you.
As the court, please.
Court will adjourn until 2:10. You are welcome to switch off your video and mute yourselves, and please switch on video and sound when you rejoin.
Mr. Mbali, the adjournment was for 30 minutes.
Oh, for 30 minutes, apologies, Justice Theron. Court will be back at 14:20.
Thank you.
Justices, all counsel are online.
Thank you very much. Mr. Ngalwana.
It says you cannot start. I'm trying to start and it's not. It says co-host. Oh.
Yes, Mr. Ngalwana.
Yes. Thank you, Justice Kampembe. Thank you, Justices. We're starting with a bit of a handicap because we had less than 24 hours to prepare our written submissions, and we missed this morning's meeting where there was time allocation. So may I seek an extreme indulgence, and the reason for us not being able to join the meeting this morning was connectivity issues. May I seek an extreme indulgence, Justice Kampembe, if you will indulge us, if we could have something in the order of 12 minutes to address you uninterrupted. Chances are we may be able to perhaps anticipate some of the questions that may be in your minds and deal with them. And then we can take any further questions after the 12th minute. We only have about 5 issues that we want to raise with an average of about 3 minutes each.
Yes, Mr. Ngalwana, you missed today's pre-hearing meeting with counsel. We had arranged with counsel at that meeting that counsel for the amici will have 5 minutes uninterrupted time during which to address us, and they will have 30 minutes within which to wrap up their oral argument.
Yes, that's the message I received, hence the request I'm making. I wouldn't go anywhere near 30 minutes. Left to my devices, 12 minutes should suffice, uninterrupted. Then in the remaining 18 minutes, I can deal with any questions that the court has for me.
Yes, if that's the attitude you're adopting, you'll have your 12 minutes uninterrupted.
Thank you, Justice Kampembe. We address 5 issues. The one is to start with what the appropriate standard is in the rescission application. That should take us to the equality equation, followed by us dealing with section 12(1)(b) and 35(3) of the Constitution. And then we end off with what the proper approach should be. The appropriate standard we submit is to look at what is in the interests of justice. Because Rule 29 does not say that you apply Rule 42 simpliciter. Rule 29 says that you apply Rule 42 with the necessary changes. And we submit that those changes could include a consideration of what is in the interest of justice. Now, that immediately takes us to the equality argument. And in this regard, we say that it is correct, of course, to assert that everyone is equal before the law. But then the same provision of the Constitution that reinforces the principle of equality also asserts that everyone has the right to equal protection and benefit of the law in section 9(1). It would seem to us from the general tenure of the majority judgment that in pursuit of the principle of equality before the law, the applicant doesn't appear to have been afforded equal protection and benefit of the law. We'll deal with that when we deal with section 12(1)(b) and 35(3) of the Constitution. The majority, it appears, seems to have treated him differently because of his status as a former president, his so-called outlandish behavior, his malevolent attitude towards the judiciary, his being an influential figure, and the court's majority decisions desire to send a clear message to the public. This, with respect, is not the language that is synonymous with equal protection and benefit of the law. Because the question that immediately arises is whether this court would have come down as hard and as uncompromisingly on a Mr. De Beer of Liberty Fighters Network or a Mr. Koos Becker of Naspers. With respect, and to paraphrase counsel for the, to paraphrase the counsel provided by the Indian Supreme Court, a copy of which we sent in special reference 1 of 1964, a fit of pique is hardly a basis for convicting a politically influential figure for contempt and sentencing him to 15 years. The majority's finding that the applicant's constitutional rights have in no way been limited or disregarded in paragraph 77 of the judgment seems to be a patent error in terms of Rule 42(1)(b) of the Uniform Rules of Court. It is a patent error because it appears that its understanding, the majority's understanding of a trial as used in section 12(1)(b), includes an opportunity afforded to the applicant in motion proceedings or hybrid proceedings in this court. But those proceedings are not trial proceedings as envisaged in section 12(1)(b). It is as a result of that patent error, we submit, that the majority decided that section 36 justification analysis does not arise. A reconsideration of that patent error is in the interest of justice because a man is currently languishing in jail as a result. So what does section 12(1)(b) tell us? Section 12(1)(b) is clear and is not ambiguous. It prescribes a trial, not a mere hearing or filing of affidavits in motion proceedings. In interpreting the word trial, one should look at what the clear purpose, the clear meaning of the word, of course, within its context in section 12(1)(b). And one need look no further than the Endumeni line of cases in that regard. There is a big difference between motion proceedings in which a party is sought to be found to have been in contempt of court after the filing of motion court papers on the one hand, and a trial procedure, whether it be a criminal or a civil trial, vastly different purposes, vastly different procedures. And section 12(1)(b) clearly requires a trial, not a hearing. Had it required a mere hearing, it would have said so. It didn't. And so we say 12(1)(b) is very clear in that regard. Turning to 35(3), and this is where I'd like to spend some time, possibly about 3 or so minutes. 35(3) of the Constitution, it says it applies to accused persons. But what do the courts tell us? Burchell, the full bench judgment of the Eastern Cape High Court, said committal for civil contempt orders remains a particular form of crime of the contempt of court under the new constitutional order, and that the respondent brought before court for committal in civil contempt proceedings is an accused for purposes of section 35(3) of the Constitution. We are not aware of any subsequent decision of a higher court that has expressly overruled that decision. In fact, Faki in the SCA confirms the finding when it says in paragraph 22 that, and I quote, where the state prosecutes an alleged contemner at common law for non-compliance with civil order, the requisite elements that must be established beyond reasonable doubt. In such a prosecution, the contemner is plainly an accused person in terms of section 35(3) of the Bill of Rights, and enjoys the interrelated rights that section 35(3)(h) confers. And it tabulates them as the right to be presumed innocent, the right to remain silent, and the right to appeal. And that's in paragraph 22 of the Faki judgment. Now, that being so, it would seem on the authority of Faki that the applicant was within his rights with respect not to file an affidavit when invited to do so. As we understand it, this was an invitation to him. He wasn't ordered to file an affidavit. He elected to remain silent, as is his right. The effect of that silence is that this court was left with an undisputed facts as regards the commission of the crime of contempt. Now, Burchell tells us that in circumstances where the court is faced with undisputed facts and inferences have to be drawn, it would have to be kept in mind that the ultimate inference as to the guilt of the offender must be the only reasonable inference, not merely the most plausible or probable one. The majority seems to have taken into consideration public statements which it could not confidently attribute to the applicant and admitted them into evidence for purposes of guilty finding of contempt. But the question is, was this the only reasonable inference that the applicant had made these statements? Well, the majority seems to have adopted the most plausible or probable standard without engaging with a Burchell judgment and say why it was wrong in this regard. What's more is that the full bench in Burchell confirmed that in civil contempt matters, sufficient care should be taken to ensure that fair procedure in accordance with, as far as possible, the provisions of section 35(3). This is consistent with Faki at paragraph 22. And what happened in Mamabolo with respect is not materially different from what happened here. The only difference would seem to be that there is a complainant, but that complainant is not an ordinary complainant, but the Deputy Chief Justice, who is a member of this court. That effectively could be said is in Mabobolo, as in Mabobolo, to have charged the applicant, prosecuted him, convicted him, and sentenced him without affording him fair trial rights like the right of appeal and the right to remain silent. I would commend paragraphs 54 to 59 to this court in this regard. So Mabobolo does not support a summary imprisonment for contempt. It rails against it. I should close off by saying this. Our submissions are confined to the effective imprisonment for contempt of a punitive measure, not as a coercive or for a coercive purpose. I should also make mention that in our submission, the distinction between civil contempt on the one hand and criminal contempt on the other is really a difference without substance. It's a difference in form with respect. At the end of the day, both in civil contempt cases and in criminal contempt cases, there is one thread that runs through it. Both of them impinge upon the authority of the court. So it is the authority of the court that is sought to be reinforced. And so there is no exceptional reason for the courts to depart from section 12(1)(b) and section 35(3) rights. Those are our submissions, Justices. If I may continue, then I will take any questions that then arise from our submissions.
Mr. Ngolwana, I'd like to take you to some of the two of the judgments, please.
Yeah.
Do you have FARCI before you, the SEA judgment?
If I don't, I will find it, Justice. Yes, I have it in front of me.
Yes, look at paragraph 42.2. Cameron JA is summing up there.
Yes.
Is it the following? The respondent in such proceedings, that's civil contempt, is not an accused person, but is entitled to analogous protections as are appropriate in motion proceedings.
Yes.
How do you understand that?
I understand it to, yes, I understand it to be precisely what it says. But then if one looks at what the same judge says in paragraph 22 of that judgment, this is what he says. And I'm reading from the second sentence. Where, well, let's say the decisions deal with statutory presumptions and reverse onuses, but they undoubtedly entail that where the state prosecutes an alleged contemner at common law for non-compliance with a civil order, the requisite elements must be established beyond reasonable doubt. In such a prosecution, the contemner is plainly an accused in terms of section 35(3) of the Bill of Rights and enjoys the interrelated rights that section 35(3)(h) confers. That is the right to be presumed innocent, the right to remain silent in the face of the charges and not to testify during the proceedings. I readily grant that Justice Cameron there is talking about what he terms criminal contempt, which is why I make the disclaimer, Justice, that the distinction in our submission between criminal contempt and civil contempt is really, I hesitate to say artificial one, because it's not artificial, but it's a distinction in form rather than substance. The real issue is to bring back the authority of the court and ensure that people obey court orders. And so the approach with a view to enforcing that should not denude a defendant or a respondent of what's generally regarded as fair trial rights.
Yes, and also that statement at paragraph 22 must be understood in the context of what the key issue was in FARCI that he was discussing, and that's a question of onus. Is it beyond reasonable doubt, or is it on the balance of probabilities? And therefore he holds that it must be beyond reasonable doubt because imprisonment may follow. But I'd like to also refer you then, if you have PECO of this court, if not, I'll read it for you. Okay. PECO 2.
I don't have it before me.
Can I just read PECO 2, one sentence for you, paragraph 36. The court says, in a respondent in contempt proceedings, FARCI said, is not an accused person as envisioned by section 35 of the Constitution. And what the court is doing there is endorsing what I've just read to you in Cameron J.A.'s judgment. Do you have any quarrel with that? I just want to see if you accept that portion of the judgment was endorsed by this court in PECO 2.
Well, if that's what PECO 2 says in the Constitutional Court, I have no reason to dispute it, because then that is the law, Justice.
Thank you. And then lastly, Mr. Ngolwana, I just want to read for you what Nkabinde ADCJ said in Machabeng at paragraph 58, and I quote, in PECO 2, this court, that's a paragraph 58, in PECO 2, this court endorsed the holding in FARCI that because contempt proceedings resulting in committal combine civil and criminal elements, it seems undesirable to straitjacket it into the protections expressly designed for a criminal accused under Section 35(3) of the Constitution.
Yes.
Do you have a quarrel with that statement?
It would be foolhardy of me to have any quarrel with that statement. Safe to say this, Justice. The determination of whether or not fair trial rights should be applicable should really not be dependent upon the label that one puts on the party who is facing the deprivation of liberty. When liberty is at stake, one should not be thinking first, well, is this an accused or is this not an accused? If a right is conferred and it is the exercise of that right that will arrest the deprivation of liberty, then by all means that right should be conferred. And I think there is a paragraph in the minority judgment that says this, that it should not be the label that determines whether or not a right is applicable. And I'm not saying that one should second guess what the introductory part of the Constitution says. That's Section 35(3) applies only to accused persons. What I'm saying is, using a purposive interpretation to the Constitution, one should, if one likes, either broaden the meaning of an accused, because an accused is not, in my submission, necessarily a criminally accused. It could be a person who is accused of doing something but not criminal. But also, at the same time, or the other side of the coin, one should not be looking at what the label is that is applicable to the defendant before one decides whether or not their rights are to be enjoyed by that defendant. So the short answer, Justice Majid, is I don't quarrel with the PECO 2 excerpt which you've read to me. I don't quarrel with Matlabeng as you've read to me, because I can't. It's what the law is. What I'm saying is this court has an obligation when faced with specific facts, specific circumstances. Here you're dealing with a 79-year-old person. As the guardian of the Constitution, the court should lean more on the side of ensuring that their rights are, as it were, enjoyed to the fullest than to look to limiting them because the person doesn't fit a particular label.
I want to ask one last question, Mr. Ngowane, on that score. On occasion, it has happened in the past, and I've had experience as counsel in one such case. But for example, MK combatants would refuse to participate in a criminal trial out of objection to the apartheid state who was prosecuting them. In that case, counsel is there physically, but the instructions are clear that you are not to cross-examine any witnesses. You are basically hold a watching brief. You do not participate at any stage, even until sentence and afterwards. So there's a conscientious objection. So that accused does not participate at all. Now here we have a situation. Sorry, the evidence is then led, and the judge convicts that MK combatant and sentence him or her to whatever imprisonment. Here we have a situation where the commission has instituted proceedings in terms of the Commission Act with the SAPS, and then when nothing happens, it comes before this court, it gets direct access. There's no opposition to it. And then when it comes to the contempt proceedings, the order gets served on both the attorney and the applicant, and the applicant says not only that he will not, through his attorneys, that he will not participate at all in these proceedings. The affidavits get filed, and then ex abundante, as Mr. Mpofu says, generously, this court invites the applicant on sanction to make submissions. He does nothing. He writes an insulting letter of 21 pages to the court, to the Chief Justice. And then the court proceeds and convicts him A of contempt and B sentences him to 15 months imprisonment, the majority judgment. What's the difference between the proceedings here and the MK combatant who refused to participate in the proceedings in the criminal trial?
Well, the difference is this, Justice. I can't quarrel with the narrative you have put to me. But the difference is the Constitutional Court is not bound by a mistake of law that has been committed or may have been committed either by the litigant or by the legal representative of the litigant. The Constitutional Court has an obligation when faced with undisputed facts as you've narrated them, not only to draw inferences by looking at whether this is the only reasonable inference to draw, but also the Constitutional Court has the obligation to protect, to give the litigant the full protection and benefit of the law to the extent to which the litigant is entitled. And so the mere fact that there has been non-cooperation by the litigant, whether it be on legal advice or not, the Constitutional Court, in fact, no court is bound by such a choice. In fact, there is a judgment on a different tag of 2018. I think it's AfriForum versus the University of the Free State, a judgment of this court, where I think it's in the early 20s. I'm afraid I think it's in the updated written submission that we've done, where Justice Mogoeng, Chief Justice Mogoeng, there makes it plain in a different context, as I say, that a court is not bound by what the parties may have agreed upon or by what a party may have conceded. The court still has to make its own independent decision. And that's all I can try and convince this court to do. But the short answer is there is no material difference between the narrative you put to me and what happened in this case, Justice Mitchell.
Yeah. Thank you, Mr. Ngwana. I said lastly, but I need to add that you see the challenge that I have here is that we are dealing with a rescission application where a litigant has consciously refused to participate in the proceedings at all, and then this is the quandary. There are defenses disclosed afterwards now, and the SCA said in Lodi 2 properties, quote, the existence or non-existence of a defense on the merits is an irrelevant consideration, and if subsequently disclosed, cannot transform a validly obtained judgment into an erroneous judgment. That's at paragraph 87 of Lodi 2.
Yes.
That is the quandary. We sit with a matter where the respondent then did not participate at all. 3 times invited to do so, declined or refused, and then now we are asked to rescind the judgment which was carefully deliberated. Earlier, Mr. Mpofu reminded us that it took 3 months. Now that's careful deliberation, I would suggest. So where's the error?
Quite so. I hear what Justice Majid is saying, and I feel for the applicant and his counsel. It's an Herculean task that they have to fulfill in convincing this court to grant the orders sought. But my refrain, to borrow from my learned friend, Mr. Mpofu's vocabulary, is to say this court must do that which it considers to be in the interest of justice. Is it in the interest of justice for this court to punish an octogenarian for having snubbed it? Is it in the interest of justice to punish as an 80-year-old, almost 80-year-old, because he's made statements that are disparaging of this court? Or is it in the interest of justice to roll the clock back and consider what it is that the court might have done had there been these defenses that are belatedly put before you. Do those make any difference in the interest of justice? That would be my consideration, not to defend what the applicant may or may not have done. In fact, what the applicant has done or omitted to do, whether that is in terms of legal advice or not. It was unacceptable. There's no running away from it. But it has happened. The court is now seized with this request, a mea culpa of sorts, to say, look, I've erred in what I did. I've listened to advice, and the advice was not to my benefit ultimately, as I now learn. So please reconsider and see whether this is in the interest of justice for me to languish in jail at my age during what is undoubtedly the most devastating pandemic that we have had since at least 1918, as far as I'm aware.
Yes, Mr. Ngabane, I have no further questions. I'm duty bound to point out to you, as I did to Mr. Mpofu, the applicant in this case was convicted of contempt, not because of what he said, but because he did not comply with an order of this court. What you're talking about, what he said was aggravation in terms of the sanction, but he was not convicted for contempt because of what he said, however bad that may have been of judges of this court or of any other court of the judiciary. Thank you, Mr. Ngabane.
I accept that distinction, Justice Majid. Thank you.
Yes, Mr. Ngalane.
Yeah, we don't have any further submissions, save to remind the court about the Council of the Indian High Court, which says that judges should be careful about employing or utilizing or using contempt proceedings when it is upset, to paraphrase. Thank you, Justices. We don't have any further submissions unless there are any further questions for clarity.
Mr. Ngalane, let me understand your argument regarding Section 12. Does it mean that Section 12 requires in every instance where a court is likely to order detention of someone, that there should be a trial?
Yes, that's our submissions, Justice Jafta. And in virtual, I'm sorry. In virtual, you would have seen, I think it's paragraphs 21 to 26, where Justice Froneman addresses seeming or what were identified as difficulties in having a trial in every such case. And I thought he dealt with them swimmingly. I don't want to waste time by having to read them to you. They appear, I can only take you to paragraphs 22 to 26 of the virtual judgment, and particularly in paragraph 25, where he summarizes that it doesn't necessarily make things inordinately difficult or inconvenient for the process where a trial or Section 35(3) rights it is dealing with there are applied.
And or am I mistaken to say you made a submission that virtual was approved? I'm not sure whether you said by the SCA or even by this court.
No, it was the negative of that. I said, okay, I am not aware of a judgment that has expressly set aside Birchall expressly.
Now,
I didn't say it was approved.
yes, Lala, I understand that. I'm trying to think back. I was involved in Machabing, and a reference was made to Birchall in Machabing. I'm not quite sure in what sense that reference was made. But you see, your argument, if we uphold it, it means then that there can never be imprisonment of a contemner following civil proceedings like motion proceedings, because that would not have amounted to a trial.
Yes, well, that is my submission. Outrageous as it may sound, that is how I read the Constitution. When it says it requires a trial,
yes,
then it requires a trial. And the trial need not be, in my submission, a criminal trial, because one can have civil trials. There has to be leading of evidence, witnesses led, witnesses cross-examined, and then it turns into a criminal element towards the end, when there is going to be a criminal sanction, where a person after conviction, not before, after conviction is then given an opportunity to advance argument in mitigation of sentence, and the complainant advances argument in aggravation of sentence. That's what makes this a problematic process, to have a person imprisoned following motion proceedings, which is where only a decision is made on paper. Of course, something else that could be done, Justice Jafta, is as it happens when there are disputes of fact. I'm not saying there are disputes of fact in this case, I'm just postulating. Where there are disputes of fact, as you know, in motion proceedings, where the court can simply refer those disputes to a trial. That's perfectly plausible in circumstances.
And because the word trial is not defined in the Constitution, you should assume its ordinary meaning, or am I wrong?
Absolutely. No, absolutely, you are not wrong.
And could it be wrong to assume that the framers of the Constitution, when they were dealing with that provision specifically, they knew what trial means in the South African context?
Absolutely, Justice Jafta.
Now,
I think also that there is a can't remember where I saw it when I was a rank junior. I used to love quoting these things, that there is a presumption that says the legislator is presumed to know the law. And so I'm quite certain that the drafters of the Constitution would have known precisely what a trial is, that it's not motion proceedings of matters decided on paper.
and you see, what troubles me, perhaps you can help me out here, was that provision not designed to arrest what used to be administrative detentions without trial? Police could just collect you and put you in detention indefinitely under apartheid, and you would never see the door of a court. Was it not designed to deal with such situations? Can we say a detention following a judicial hearing is what the section targets?
Well, Justice Jafta, it may well have been designed for the purposes to which you advert, but non-constat that it wasn't designed to ensure that no one is ever incarcerated without a trial is my submission. So if there is going to be a deprivation of liberty, one should be, I submit in terms of section 12(1)(b), be afforded fair trial rights, including the right not to be incarcerated or detained without trial. So to admit that the provision may have been included in the Constitution for the purposes to which you advert doesn't necessarily mean that it cannot cover the field, as it were. It cannot cover instances where the liberty of a person is at stake.
But that understanding of the section, and I appreciate the argument, because it seems to me that if one has to give trial its ordinary meaning, one can only come to the interpretation that you are advancing. But if one has that understanding of the section, does it mean that even contempt of court that is committed in court, if somebody disrupts a hearing, the court cannot summarily deal with that person and impose punishment unless a trial is held? See, the difficulty there is because now it is the same court that has to deal with the contempt. So this issue of a trial, doesn't it create a difficulty in that situation where the contempt is committed in court and the court has to deal with it summarily so that the administration of justice can be safeguarded?
I would be very surprised if a South African court would throw in jail a person who disrupts court proceedings summarily. This is why I made a distinction, Justice Jafta, between contempt proceedings and sanctions that are intended to coerce a person to comply on the one hand, and contempt proceedings that are intended to punish a person for what the person has done. Our submission deals with the latter. What you are postulating to me, I would submit, would fall into the former category. It is highly unlikely that counsel, for example, or maybe a person in the gallery in court starts smoking when smoking is not allowed in court, that person could be bundled up and thrown in a prison cell. Chances are the person would be told to put out the cigarette smoke. If he or she persists, would then be warned that if you don't do this, this is what's going to happen. If they persist, then there's going to be a suspended, maybe custodial sentence that we will keep you in jail overnight until you comply. But to throw that person at the first call in jail for smoking in court, questions of disproportionality may arise and all sorts of other questions in a constitutional democracy.
Yes, but that's a different issue that relates to the seriousness of the crime and the sentence to be imposed. The issue I think I'm debating with you is whether there are exceptions where detention can follow without a trial. Because remember, we're trying to find out what actually does section 12, is it 1B mean? Does it mean that you can never have a detention of someone without a trial? You can only have a detention of someone with a trial, where there has been a trial. So I'm testing that does it, it may well be, it means that, but I'm not quite sure whether it does. And it seems to me that you also think it should be going to the extreme to say, even those who commit contempt in court, disrupting proceedings, cannot be detained because there would not have been a trial before.
Justice Jafta, I love the way this is playing out. I'm supposed to be, well, not trying to convince you, but to assist you in the deliberation of these difficult questions. But
that is why I'm asking them.
Yes, but I must confess, I'm persuaded by you that there may well be exceptional circumstances where a detention for contempt summarily without a trial process may well be necessary. But we don't know in what specific circumstances that could happen. So I don't want to make a submission that says, yes, a person may be detained without trial, without following section 12(1)(b).
Yes.
But rather, I would say there may well be circumstances or instances where that could happen.
Yes.
But what those circumstances will be, that could happen.
Yes.
But what those circumstances will be would have to be dealt with on a case-by-case basis. A court cannot give a list of instances where that can happen.
Actually,
so the short answer to your question, Justice Jafta, is there may well be exceptional circumstances.
Yes. So that should inform our interpretation of section 12(1)(b), shouldn't it?
I accept that, yes.
Okay. And actually, Mama Bulo tells us, it gives examples of when the unconstitutional summary procedure may apply. And I think the first one is the infa contempt of court, and the second one is where the NPA would have declined to prosecute.
Yes. And in paragraph 59, as I recall, Justice Krickler then says the matter should be referred to the National Director of Public Prosecution, which is where I would have come in closing.
Yes.
That the approach that this court should take should rather be to send the matter for investigation and prosecution rather, because the police, I'm told, do the investigation. The NPA prosecutes.
Yes.
Yes.
Now, do I have to understand your argument then that it's no longer sort of absolutist, that
quite right.
Where there's no trial, there can be detention. So your argument now rather is, but this is not the sort of case. Is that the argument? That
yes.
Here you don't have factors justifying the exception of a trial. A trial should have been followed before detention was imposed.
That is correct with respect, Justice Jafta. Particularly, perhaps this is also a factor that the commission, which was rightly criticized by this court, but differently constituted, for the manner in which it has approached the matter, because they are the ones who came up with a ruling. I think it was the second respondent the Deputy Chief Justice, who I believe is now acting Chief Justice, who made a ruling that they were going to institute criminal proceedings. So that may well have created an impression. I know I'm speculating, but perhaps it may be a factor that the court may take into account, that even the commission had in mind some kind of a trial process with a view to bringing Mr. Zuma to book for defying it.
Yes. Lastly, just for clarity in my mind, would I understand then the position to be this, that it is not helpful to inquire into whether the common law principle that permits contempt to be pursued in motion proceedings to be generally unconstitutional? One needs rather to look at the circumstances of the specific case to say, in this specific case, the process followed was not justified because of its impact on the rights of the person whose liberty is going to be taken away.
I accept that entirely, Justice Jafta.
Okay, thank you.
Justices, those are our submissions, unless there are any further questions.
Thank you, Mr. Ngalwane. Mr. Mugaitobi.
Thank you, Justice Kampepe. I'm grateful to the court for the opportunity. There are two reasons why the court should dismiss the application. The first is that the threshold provision under Rule 42(1)A of the Uniform Rules of Court, either as formulated or even on the expanded understanding of Rule 42(1)A, which is yet to be crystallized into a legal standard. The second, independent of the first, Mr. Zuma always to his prison cell, his pocket. He could tender to comply. It is an extraordinary feature of this case that to this date, Mr. Zuma persists that in a commission of inquiry chaired by Justice Zondo, he will not appear. I listened carefully to Mr. Mpofu's tender towards the end of his address, but it is still a conditional tender that for as long as Justice Zondo is chairing, Mr. Zuma will not comply. But despite the brazen contempt, because he has been told by this court to attend the commission as chaired by Justice Zondo, despite that brazen contempt, which is persisted with in these papers, Mr. Zuma does not want to take punishment either. Let me turn then to the Rule 42 argument. In the founding affidavit of Mr. Zuma, there are 6 grounds for rescission. In the heads of argument, they are reduced to 3. In the oral submissions, only 2 were persisted with. And those 2 were the failure or the alleged failure to give Mr. Zuma the right of an appeal and the alleged failure to give Mr. Zuma the right to mitigate or sanction. Neither of those 2 constitute an error for the purposes of Rule 42(1)A. We have cited the text of the rule in paragraph 34 of our heads of argument, where we say Rule 42(1)A provides that a judgment or order may be rescinded on the basis that the judgment was erroneously sought or erroneously granted in the absence of any party affected thereby. This rule has been the subject of debate in at least 6 judgments of the Constitutional Court. One of them is Daniel versus President of the Republic of South Africa. In paragraph 5 of Daniel, this is how this court has explained the meaning of Rule 42.1a. The general principle is that once a court duly pronounced a final order, it becomes functus officio and has no power to alter the order. That is a salutary reminder of the gravity of the function court. But it also, however, 42 of form rules creates exceptions to this principle. In paragraph 6, the court then explains what an applicant in the position of Mr. Zuma must illustrate. It says the applicant is required to show what he relies on. This could not have granted the impugned order. In other words, the error must be something this court was not aware of at the time the order was made, and which would have precluded the granting of the order in question had the court been aware of it. So, two elements must be established. One, there must be an issue of fact about which the court was ignorant at the time it gave the judgment. Secondly, that issue of fact must be of the nature that had it been known to the court at the time, it would have precluded the court from granting the order. But there is a further qualification, which I would say is a third consideration. The court must ask why that fact was not known at the time. And this is where the judgment quoted at paragraph 38, footnote 22 of our heads of argument. It's clear that the or non-existence depends on the merits is, and if subsequent cannot transform a validly obtained judgment into an erroneous judgment. So where do we stand then on the first two requirements, error and Rule 42.1a? Is there a fact about which the court was ignorant when it gave its order judgment? Would that have precluded the court from granting the judgment? And 3, what are the reasons why that fact was not known at the time? In the heads of argument that have been submitted by the applicant, some attention is given in 6 pages from page 5 to page 10 into 2 allegations of fact. The first allegation is that the commission withheld information from this court, and the nature of the information that is alleged to have been withheld relates to Mr. Zuma's medical condition. The second is that the commission did not disclose to this court the position it was adopting in relation to Mr. Zuma's review. It's notable that none of those have been argued today, but just to make it clear that those 2 elements have no substance whatsoever. Firstly, in the Zuma 1 case, the commission fully disclosed that it was told by Mr. Zuma that in November 2019 and January 2020, the reason he could not appear was because he had a medical condition and had undergone a surgery. That you will find at page 57, paragraph 97 of the record in Zuma 1, page 59, paragraph 102 and 103. But moreover, you will find this expressly referred to at paragraphs 40 and 44 of the judgment in Zuma 1. So quite clearly, it is a false assertion to state that the commission withheld information from this court. The same issue relates to the status of the review. Here is the correct position on the review. Mr. Zuma instituted review proceedings, and this is stated at pages 94 and 95 of this court's judgment at Zuma 2. And it is stated at page 416, paragraphs 105 to 107 of the answering affidavit of the commission in these proceedings. Here is the position. Mr. Zuma brought review proceedings. The commission, as required to do, produced the record. It says in the answering affidavit that that record was produced more than 2 months ago. Under Rule 53 sub 4, Mr. Zuma had the duty to supplement the record or to indicate whether he stands by the notice of motion or not. He has done neither. That is where matters stand. It's entirely self-serving in those circumstances to blame the commission, where it is in fact Mr. Zuma who is not progressing his review application. That should dispose then of the two arguments made between pages 5 to page 10 of the heads of argument. Let me turn then to what constituted the majority of the debate today, which is the issue of Section 12 of the Constitution, its relationship with Section 35 and the degree to which it applies to contempt proceedings. It is necessary here one fact upfront is that this matter was fully debated by the majority and the minority. It is not a fact, it is unknown to the judges at the time they granted the order. And it is not that if it had been known, would have precluded the granting of the judgment. So it falls outside of the parameters of Rule 42(1)(a), as articulated in Daniel, confirmed in the Supreme Court of Appeal decisions. But not only is it not a fact that was unknown at the time the judgment was granted, it is also perfectly compatible with the judicial determinations from this court. There are 6 in total cases that have examined this question, 6 judgments that have examined this question. They start all the way from Nel versus Roux. It's a judgment of 1996, published in volume 4, BCLR 592 CC. At paragraph 14, the judges of this court, I think it was a judgment of Justice Ackerman, but it was a unanimous judgment in the end, were examining the predecessor to Section 12 and the predecessor to Section 35. They said the following at paragraph 14. The Section 11(1), which was the Section 12(1)(b) of today's Constitution, relied upon by the applicant, is the right not to be detained without trial. The mischief at which this particular right is aimed at is the deprivation of a person's physical liberty without appropriate procedural safeguards. That's so crucial. In the end, he addresses squarely the question as to whether or not Section 12(1)(b) should result in the duplication of the rights in Section 35(3). And it says, the trial envisaged by this right does not, in my view, in all circumstances, require a procedure which duplicates all the requirements and safeguards embodied in Section 25(3). That is the current Section 35(3) of the Constitution. In most cases, and those are the baseline requirements, it will require the interposition of an impartial entity, independent of the executive and the legislature, to act as arbiter between the individual and the state. In fact, in that case, when he concludes the judgment, Justice Ackerman says that the section under consideration was unconstitutional only to the extent that it precluded the involvement of judges in trying and sentencing a contemnor. The next case which considered this issue squarely is DeLange versus Smarts, which this court has considered at length in its judgment in Zuma 2. This appears at paragraph 67 of DeLange versus Smarts. And it again repeats the following. In Nel Roux, and again, this was Justice Ackerman writing for the majority, this court held that the trial envisaged by the right not to be detained without a trial did not, in all circumstances, require a procedure which duplicates the requirements and safeguards embodied in Section 25(3) of the interim Constitution, but in most cases requires the interposition of an impartial entity independent of the executive and the legislature to act as arbiter between the individual and the state. Later on, the issue arose specifically in Faki, and Faki has been debated by Justice Majid and Mr. Ngalwana. And in fact, the three questions that Justice Majid put to Mr. Ngalwana at the beginning simply exposed how low Mr. Ngalwana's submissions have been. But this is what is stated specifically now in the context of contempt. If we go to Faki, paragraph 24, this is now the third judgment in which this issue is again revisited. It says there can be no reason why these protections should not apply also where a civil applicant seeks an alleged contempt committal to prison as punishment for compliance. And then it says, this is not because the respondent in such an application must inevitably be regarded as an accused person for the purposes of Section 35 of the Bill of Rights. On the contrary, with respect to the careful reasoning of the Eastern Cape decisions, it does not seem correct to me to insist that such a respondent falls or fits within Section 35. Now, let me pause here and say one thing. Towards the end of his submissions, Mr. Mpofu referred to the Bachel decision. Mr. Ngalwana also cited the Bachel decision. What they both omitted is to tell this court that that was a decision expressly considered and expressly overruled in Faki. It is referred to at paragraph 16 of Faki in summary form. And it is then answered at paragraph 24, where the judges say, let me repeat this. On the contrary, with respect to the careful reasoning in the Eastern Cape, it does not seem correct to me to insist that such a respondent fits within Section 35 of Bachel versus Bachel. It is a 2000 expressly considered in the SCA and expressly departed from in the case of Faki. Then it continues. Section 12 of the Bill of Rights grants those who are not accused of any offense the right to freedom and security of the person, which includes the right not to be detained without trial, but not to be deprived of freedom arbitrarily and without just cause. And then it says this provision affords both substantive and procedural protection, and an application for committal for contempt must avoid infringing it. So for the third occasion, the Constitutional Court and the Supreme Court of Appeal say the essence of Section 12 is that there has to be substantive and procedural protections, but that is not the same thing as a duplication of Section 35. And then it says in paragraph 25, where it is now directed dealing with the issue of motion, it says, and in interpreting the ambit of the procedural aspect, highly appropriate to regard the position of a respondent in punitive committal proceedings as closely analogous to that of an accused person, and therefore in determining whether the relief can be granted without violating Section 12. Here is what should happen: to afford the respondent such substantially similar protections as are appropriate to motion proceedings. For these reasons, the criminal standard of proof is appropriate here. So we get an explicit recognition of the propriety of motion proceedings for contempt. That issue is then dealt with finally when Justice Cameron sums up at paragraph 42. And at paragraph 42(2), he says, the respondent in such proceedings is not an accused person, but is entitled to analogous protections as are appropriate to motion proceedings. Now, the fate of Faki is examined for the first time by this court in Pego. And Pego makes it clear that there is a distinction in paragraph 31 between coercive contempt as well as punitive contempt. It deals in this paragraph 31 and explains, by contrast, punitive orders aim to punish the contemptor by imposing a sentence which is unavoidable. Then it deals then specifically with Faki at paragraph 36. It says, however, importing them, it's now dealing with the procedural protections. We must be cognizant of the context of contempt proceedings. A respondent in contempt proceedings, Faki said, is not an accused person as envisaged by Section 35 of the Constitution, and the protections afforded to a contemnor should not supersede the capacity of a non-state litigant who may not have the administrative might to establish motive. Therefore, the presumption rightly exists that when the first three elements of the test for contempt have been established, mala fide, willfulness are presumed, unless the contemnor is able to lead evidence sufficiently to create reasonable doubt as to their existence. So for the fourth occasion, we know what Section 12 means, that at baseline, it's a procedural protection. We also know that contempt proceedings can be pursued, in fact, should ordinarily be pursued. We now know as a characteristic of Justice Cameron of the prudential justification, because he adds that it is to protect a civil litigant who is successful. A litigant who obtains a judgment cannot get it enforced. It has no mechanism of ensuring the success or the fruits of their success unless they go to court on motion proceedings. So this is now the Constitutional Court in 2. Therefore, which is now the fifth judgment, when this court engages with this topic in a careful judgment from paragraph 63 right up to paragraph 83, it consolidates all of the development of the law on Section 12, Section 35, and contempt proceedings and motion court proceedings. And it is so clear that it is fully cognizant of the law. At paragraph 63, this much is clear. At paragraph 64, this is also clear. At paragraph 65, when it repeats things it has said twice before. However, this is not a conventional criminal trial. And I emphasize that I'm alive and deferential to the jurisprudence of this court that affirms that a respondent in contempt proceedings is not an accused person as envisaged in Section 35 of the Constitution. And then it says, notwithstanding this distinction, Mr. Zuma does indeed face the prospect of imprisonment for unlawful conduct that our law defines as an offense. It is useful and instructive to consider the Supreme Court of Appeals characterization of contempt application, which describes it as a peculiar amalgam, for it is a civil proceedings that invokes a criminal sanction or its threat. But it again repeats the propriety of motion proceedings. It again repeats the same point that Section 12, the trial in Section 12, can be covered by motion court proceedings. Then the entire judgment, one can see from 67, 68, 69, based on precisely this issue. The same point is made about the appeal, as well as the Section 36 complaint. The Section 36 complaint is dealt with by this court at paragraph 74 of the judgment. And where it ultimately concludes is to simply say that there is no need to engage on a Section 36 analysis. And the reason why there is no need to engage on that Section 36 analysis is because the motion contempt proceedings is perfectly compatible with Section 35 of the Constitution. Again, the court answers explicitly the issue of the, at paragraph 77, the majority judgment says, I shall not belabor this point any further, other than to emphasize that a situation that contempt through civil proceeding, and that many of the specific rights listed in Section 5.3 cannot fit comfortably or at all within these motion proceedings. I agree with Cameron J.A. that not all of the rights under the provision will be to or could easily be grafted onto the hybrid process. This is because the Section 35 rights were crafted with a specific criminal process in mind. Then it says, moreover, if one is prepared to accept that contempt of court may be litigated through civil proceedings, as our jurisprudence unequivocally does, and Justice Kambembe is right right. It has happened 5 times before. It is simply unavoidable that a contender in civil proceedings will not be categorized as an accused person and enjoy each of the rights enshrined in Section 35. Thus, since the constitutional rights to which Mr. Zuma was entitled have in no way been limited or disregarded by this court in determining this matter, a justification analysis under Section 36(1) simply does not arise. In paragraph 78, the judgment comes back to the issue of the appeal, and it considers it carefully, and it eventually rejects the notion that there is no appeal. So far from a scenario in which there has been an error because a fact that should have been known was unknown, and that fact would have precluded the granting of the judgment, we have an extraordinary situation in this case. Each and every complaint that was raised today by Mr. Mpofu and Mr. Ngalwana is exhaustively considered by the court, and it is exhaustively and carefully determined. And ultimately, it is found against them on each point. And we have Justice Theron to thank for that, because it is in her judgment that these concerns arise. And it is in response to the minority judgment that the majority judgment is then made conscious of these objections and has to answer them point by point. But that is simply a reflection of a mature judicial system in operation. The idea that the debate between the two judgments somehow lend itself to an error capable of rescission simply no application whatsoever. So if we know for sure that Section 12 comprises a trial, motion court proceedings have been approved by this court to constitute a trial for purposes of contempt proceedings. Then it becomes quite clear that Mr. Zuma repeated refrain has been convicted and sentenced without trial is just false. Mr. Zuma had a trial, and it was a trial in accordance with the approved procedure for contempt of court proceedings. He knew what case he had to meet. It was set out exhaustively in the papers of the commission. He knew what sentence was being asked for. It was also set out exhaustively in the case of the commission. On the 9th of April, he was invited by this court to put any circumstances that would influence this court to grant the appropriate sentence. At every turn, Mr. Zuma said he is not interested. He told this court, he told the public, and he told the commission that he is not interested in participating. Not only did he tell us that he is not interested in participating, it's also necessary to look at the language that he used in telling us, because it is one thing to say, I don't want to participate, but it is also another, the language that is used. Mr. Zuma said he has reconciled himself with being a prisoner of the Constitutional Court. So he actively, consciously knew that imprisonment was a possibility, and he reconciled himself with this possibility of imprisonment. Mr. Zuma also deliberately did not respond to the applications. We have cited his explanations for not responding from paragraph 16 to paragraph 23 of the heads of argument. He has told us in these papers in explicit language that my reasons for not engaging with the applications to the Constitutional Court were based in large part on the lack of finances to engage lawyers to focus on the urgency basis and in terms demanded by the Commission and accepted by the Constitutional Court. I must also say that I put my trust in the clearly mistaken view that I could not be forced to appear before a judge whose recusal was the subject matter of an ongoing process. And then he says, I was clearly wrong in this belief, which I held in good faith. Then in paragraph 40, he gives another reason. He says, the second reason was that I was advised that I had the option not to participate in the proceedings and to trust the court to engage with the Commission's application on its own merits. Then Mr. Zuma also tells us quite astonishingly, that he intentionally did not comply with the judgments of this court. We see that at paragraph 54 of his own founding affidavit. He says, we've quoted this at paragraph 25 of our heads of argument. My response was difficult and robust. And even though I said things that regrettably and seemingly appear insulting, I am entitled to express strong views against an oppressive system. Let's just pause there. Expressing strong views against an oppressive system. This court is regarded by Mr. Zuma as the oppressive system because these were views expressed against this court. And then he continues, so I did not comply with the orders of the Constitutional Court because I believed that they were unlawful. To issue an order that I should appear before a by inquiry and to obey its instructions was fundamentally because of two reasons that I set out in my review application. It is a review he is not pursuing. But what we know here that it is a case of a litigant who has told the court, I did not comply intentionally. The reason I did not comply is because I did not recognize the authority, the legal authority of the judgments granted by the Constitutional Court. But that is where we are, Justice Khampembe, I'm afraid. We have a litigant who has explicitly told us that he will not be complying with the judgments of the Constitutional Court. His reasons are that he does not regard them as legally authoritative and correct for him to comply with them. And the law on this topic is quite clear. If you have a litigant who has a court order, and this is not an issue about the, I heard Mr. repeatedly go back to the issue of the summons. This is no longer an issue about the summons. The application to this court in Zuma transformed the status of the summons into a binding judicial determination. This is a matter now that failed to be raised under section 165 of the Constitution. That section, it's crucial to record two of its provisions. The first one is no person or organ of state may interfere with the functioning of the courts. I cannot imagine any greater interference than a litigant who has come before you and has told you, I did not comply because I thought you acted unlawfully. And that decision means he chooses when you have acted lawfully and he chooses when you have acted unlawfully. Cases before this, Justice Khampembe, one of them you actually wrote in the Minister of Transport case, where you specifically said, even if a litigant believes a judgment to be wrong, they ought to comply. They can challenge it later. Once they win, then at that point, they will be excused from complying. But the mere fact that a litigant chooses for themselves what to comply with, what not to comply with, is a direct breach of section 165.3. It's a breach of the fundamental law of the country. Secondly, in section 165 sub 5, an order or decision issued by a court binds all persons to whom and organs of state to which it applies. Mr. Zuma is one such person. So we have an explicit constitutional reminder that he was bound, regardless of the opinion that he adopted with regard to the correctness or otherwise of the decision. And his application today to this court, what it ultimately boiled down to is that he has a preference to the judgment of the minority. I could also have that preference that the minority judgment is the correct expression of the law, but I have no right to disobey the majority judgment because I prefer the minority. But Mr. Zuma's preference of the minority judgment does not translate into an error in the majority judgment. It does not mean that the majority judgment, even if it is wrong, it does not mean the majority judgment is now the subject of rescission. And what has been underlying today's proceedings has been the repeated accusation that you, as the Constitutional Court, have violated Mr. Zuma's rights. And that Mr. Mpofu has repeatedly stated that you, as the court, are exactly in the same position as a minister, or an administrative official or a magistrate's court. That, of course, as a matter of law, is plainly wrong. The reason the Constitutional Court is established is so that it can be the final arbiter of what the Constitution means. It does not mean that the executive should not decide what it means. It does not mean the legislature should not pass legislation in which it interprets the Constitution. But it is only the Constitutional Court that takes a final view on the meaning. That we know from Section 167 of the Constitution. Not only are you the apex court in terms of the judicial hierarchy, you are also the final court of appeal. Once you have made a determination, that's it. The buck stops with you. So to be told today that in a careful judgment in which you balanced the rights of Mr. Zuma with the public interest and with judicial authority, by giving that judgment, you acted in an unconstitutional way. That itself is an extraordinary submission. It's in fact reflective entirely of Mr. Zuma's own attitude to this court, where he says, I did not comply because I considered it to be lawful and unconstitutional. In other words, I took the law to my own hands. So we would say, based on those three reasons, where there is no error, quite clearly under Rule 2, there is no error. There is a persistence on the papers that Mr. Zuma did not regard himself as bound, and he has told you that he did not regard himself as bound. And based on the third consideration, that your own jurisprudence has made it abundantly clear that the Section 12 rights are perfectly compatible with motion court proceedings in contempt of court proceedings. You should be able to dismiss the application without more. What we then got from Mr. Ngalwana, who Justice Majid's inquisition, or rather inquiry from him, illustrated the depth of the hollowness of what he was saying. What we got from him was that we should not apply what he called Rule 42(1)A simpliciter. What we should do instead is we should apply the interest of justice standard. Now, let me say one thing before I answer the issue. Interest standard is not novel. It has been dealt with by in Minister of Justice and Constitutional Development versus Tonto and others, which was also a rescission case, reported in 2010, volume 7, BCLR 629 CC, in which it says that it is not deciding whether or not Rule 42 comprises the full extent of the powers of the court to rescind, vary, or amend its own orders. And then there is also another judgment called Bapalane Ramokuka community versus Mpela family and others, in which at paragraph 26 and 27, the following appears. In invoking and applying Rule 42, this court has previously left open the question what power it may have as a court of final appeal to vary its powers under the common law or under its inherent power to protect and regulate its own process or under its power to develop the common law, taking into account the interests of justice. In Mulawuzi, which is a judgment by Justice Teron, the court comes back to this topic. And then it says, one, it is important for this court to speak once and to speak finally. And that is necessary in order to safeguard the rule of law, which that comes from the court ought to be unambiguous, so that those people who are required to comply know that they must comply. But then she says, you should not be too fixated and too rigid about the possibility of rescission. And then she explains the circumstances where this might happen. And in paragraph 40 of the judgment, this is what she says, where she sets out one of those examples, The applicant is serving a sentence of life imprisonment, of which he has already served 10 years. His co-accused, convicted on similar evidence, had their convictions and sentences overturned. A grave injustice will result from denying him the same relief simply because in his first application, he did not have the benefit of legal representation, which resulted in the failure to raise a meritorious constitutional issue. Now, we know from this judgment that what the court was concerned with, in fact, Mulaudzi was a unanimous judgment. What the court was concerned with is they had a criminal accused who was serving a life imprisonment. His co-accused, having been convicted of the same offense, had their offenses overturned. His own decision, when he tried to apply to the Constitutional Court for leave to appeal, had been, but it turned out that the reason it had been turned down was poor legal representation. Can we honestly say that we have had poor legal representation in the case of Mr. Zuma, a person who throughout has had 2 senior advocates acting for him, in circumstances where he himself does not say that I've had a problem of poor legal representation? So we cannot even begin to compare the type of circumstances that would have arisen in the S versus Mulaudzi case. What we have here is the opposite. Not only has Mr. Zuma been represented by 2 senior advocates throughout, he has also been represented by a senior attorney. It is significant that at the critical moment, on the 14th of April 2021, it was in fact his attorney, Mr. Mabuza, who attached what Justice Majid labeled today as an insulting 21-page denunciation of the court. It was done with the attorney's participation. He sent the letter under his cover. So we have someone who is clearly cannot be compared to the bewildered litigant in S versus Mulaudzi. We have a former head of state who has acted consciously all along. And this fact about Mr. Zuma having acted consciously is something that you cannot ignore in your assessment of the evidence, because it cuts through this entire argument we've been having today. This is all an interesting debate, but it is completely beside the point, because the fact of the matter is that Mr. Zuma cannot bring himself to any cognizable grounds of rescission. Now, Mr. Ngalwana's contribution is to say you have to look at the broad of justice. But where do the interests of justice lead us in this case? We've debated the interests of justice at length in our heads of argument. The interests of justice, firstly, require that you should uphold the Constitution. More than anything else, you should uphold the Constitution. You should uphold your standing as a court of final instance. You should uphold your standing as the highest court in the Republic. It is not an issue that you elected to hear this case directly without a right of appeal. You knew this, you were aware of it. It was a motivation that we raised. Mr. Zuma knew it as well. His attorneys, his advocates knew that if the case is accepted by the court as a court of first instance, it will also be a court of final instance. I heard today, rather astonishingly, that when you take a case as a court of instance, you put yourself in the same position as a magistrate's court or as a high court. Well, that just needs to be stated to be rejected for absurdity. What you knew is that you were taking the case as first and final instance. And the reason you knew that is because you control your own jurisdiction under section 167, 6A of the Constitution. You took the case because, as you say in the judgment, you wanted to protect the standing, the reputation, not just of the judiciary, but of the legal system, because the standing and the reputation of the legal system was under ongoing threat. Sadly, on the papers that we have seen introduced by KSAC, introduced by Helen Suzman Foundation, those threats have not abated. And in fact, arguably, they have. And so the duty becomes even stronger today to affirm the dignity and the reputation of the court. That's the one element of interest of justice. The second one is what we deal with at paragraph 85. in which we say there is an interest of justice in finality in litigation. And here, you remember that we spoke initially about the rescission procedure having been an exception to the res judicata principle. Once you've decided that res, and the rescission procedure is an exceptional procedure. Why that is so is because of what Justice Chastelson said in Minister of Justice versus, where he says the principle of which underlines the common law rules for the variation of judgments and orders is clearly relevant to constitutional matters. There must be an end to litigation, and it would not be tolerable. It would be intolerable and could lead to great uncertainty if courts could be approached to reconsider final orders made in judgments declaring the provisions of a particular statute to be invalid. Now imagine here, where you have used the term bent over backwards, where you have extended the opportunity for Mr. Zuma to be heard. Now we set out in the beginning of the heads of argument, the opportunity. There are 7 in total, 7 opportunities in total that were given to Mr. Zuma to participate in this process. On occasion, he either denounced the court, denounced the judiciary, denounced the commission, and eventually, as Chief says, insulted the court. After the judgment, one of his ventriloquists, the Jacob Zuma Foundation, has also now descended into the realm of insults. So the second consideration under interest of justice is finality in litigation. And we say that this risk of uncertainty looms large in a case such as this, especially where, like Mr. Zuma complains facts that he says should have been taken into account. We heard from Mr. Ngalwana today. It's unclear how, as an amicus, they got to know of these facts. We heard from Mr. Ngalwana today about Mr. Zuma's age. We also heard about comorbidities. We also heard about the current climate being a COVID climate. But let us be clear about this. These were facts that were always known to Mr. Zuma. These were facts that Mr. Zuma was conscious about. He reconciled himself with the possibility of imprisonment, full well these facts. He cannot, whenever he wishes to reopen the case, because the consequences of what evoked have now come into fruition.
Mr. Nukotobi, sorry, can I interrupt you, Mr. Nukotobi? Sorry. There's something that bothers me. It seems now that in the supplementary affidavit, paragraph 10, the applicant is suggesting that he be released pending this outcome of this case, and Mr. Mpofu has also made submissions. But now, I mean, there was never an application for a stay once the application for rescission was launched. I was quite surprised by that, not in this court anyway. And there's still not an application for stay through an amendment of the notice of motion. I always thought that you ask for your relief through your summons in an action and through your notice of motion in an application. What is the Commission's attitude about that request and that submissions?
At this stage, Justice Majid, there is no application. And we have dealt with this at paragraph of our heads of argument, where we've pointed out that in any event, yes, it's paragraph 89, where we say Mr. Zuma's alleged health concerns are noted. There is no reason put forward why they were not raised when this court specifically invited mitigating circumstances. Moreover, these concerns are completely unsubstantiated. Laconic statements do not constitute admissible evidence, which would require this court to relax the rule of finality in litigation. A litigant must plead a case by defining the relevant issues and by setting out the evidence upon which it relies to discharge the onus of proof, resting on it in respect thereof. Vague, unsubstantiated statements do not amount to pleading a case. This court is thus precluded from having regard to such statements which are not supported by any evidence. So you have two problems. The one problem is that you have no application before you in which the stay is requested. What we did have, according to the evidence introduced by the supplementary affidavit is an application instituted last week on Tuesday before the Pietermaritzburg High Court. And I hear Mr. Mpofu being critical of that court, but he has not lodged an application for leave to appeal. That court quite correctly dismissed the application. And in the course of our submissions, which are in the judgment, we specifically invited Mr. Zuma to bring an application to the Constitutional Court for a stay. Today, as we see in the afternoon of Monday, there has still been no application. It is just an impossible task because the court simply cannot consider anything, quite apart from the fact that the evidence that is contained, quote unquote evidence, contained affidavit, is the scantiest, not anything. So things that completely disable the court from giving any meaningful consideration to this. The one is that he has not brought the application despite the invitation. And secondly, even if you look at the content, it's vague allegations that are not supported by any evidence. And they are, quite frankly speaking, laconic. So
thank you.
The third element on the interest of justice is you have to look. Yes, Justice Drift. Sorry.
I have a few matters which trouble me here. I think let us start where you are so that you can deal with them. Do you accept that even though they have based their claim on Rule 42, if we find that Rule 42, the requirements of Rule 42 are not satisfied, we can still look at whether, under the interest of justice, the claim should be considered?
Justice Drafter, in principle, that is true, but let me refer you to what we say in the heads of argument. Precisely on that point, it is, yes, it is the point about pleadings, where the court, I think it was your judgment, if I'm not mistaken, Justice Drafter, the court says holding parties to pleadings is not pedantry. If you are going to raise a constitutional issue, you have to raise it explicitly in your founding affidavit so that the respondent knows what the case is and the respondent can engage with the case. If you look at the founding affidavit, the entire case is about error. There is no heading on interest of justice which sets out additional facts to those which concern Rule 42 1A, which makes it impossible for the court to exercise its function of examining the interest of justice separate and distinct from Rule 40A, because it's simply not by the pleadings. So the judgment, not able to find it immediately, but I know for a fact that it has been set out. In fact, the principle, Justice Drafter, you would know, because I've seen in many judgments and actually in many councils' heads, the reference to the phrase holding parties to plead is not pedantry. So everybody knows that comes from you.
No, I understand that.
Yes.
Which sort of answer the question that was troubling me, but let me put it, even though it seems that you have an answer to it. I had a look at section 35. 35 to D, which says everyone who is detained, including every sentenced prisoner, has the right to challenge the lawfulness of the detention in person before a court, and if the detention is unlawful, to be released.
Yes.
I was wondering whether that right, because that is not a right that is exclusively enjoyed by choose persons. It's not like those listed under sub 3. It's a right that is also enjoyed by a sentenced prisoner. So
Yes.
I was wondering whether that right has any role in the assessment of where the interest of justice lie in determining whether or not the matter must be entertained. I understand your argument that says, but even so, it must be foreshadowed in the affidavit. If it's not foreshadowed in the affidavit, you have no business to look at it because parties must be held to their pleadings.
Yes. Yes, that is the short answer, Justice Schafter. I mean, because, and in fact, in Olomisa, you say, this is a passage that comes from a minority judgment in Gavas and Satan. You say, this is so crucial for constitutional litigation. If you are going to assert a constitutional right, you must tell us so that we know what case we are meeting.
Yes.
The honest truth about these pleadings, Justice Schafter, is that anyone who would have looked at these pleadings would have said, this is a case about Rule 42.1a. Because even that passage in the founding affidavit where they set out the errors, it's all errors predicated on the notion that Rule 42.1a is applicable. And you see this from page 26. There is a list of rights, and at page 27, again, another list of rights. And then when you look at page 29, under the heading, was the relief erroneously sought and accompanied by errors or omissions? So all of those are then the errors that go on up until page 35. What you will not find is that they are case under section 32D. In other words, there's in their right to challenge the lawfulness of the detention. Quite apart from the fact that challenging the lawfulness of the detention sanctioned by the Constitutional Court would inevitably put you in collision with the judgment of the Constitutional Court, which you must say is a wrong judgment, which is a test for appeal, not.
Mr. Mpofu, I think, argued that, well, look, because of the status of the Constitutional Court, against whose decisions you can't appeal, the only avenue available is for you to ask for reconsideration. What do you say to that?
Yes, that will not help, Justice Schafter. If you come, and even if you were in the High Court, if you came to the High Court and you accused the High Court of committing errors, if you did not prove those errors, the case would be dismissed. It would not matter that you have an alternative right of an appeal. And this is where we are. If they do not prove the errors, the case should be dismissed. The issue of the reconsideration does not take place outside of the pleaded grounds of rescission, because they say rescind for us because you have committed errors. And then they say reconsider for us because you have committed errors. Today, those errors crystallized into two. One side is you did not give us an appeal. On the other side, you did not give us a chance to mitigate. That's the full extent of the case. But you have, in fact, considered the implications of not giving them an appeal. You have considered the implications of Section 36. You have considered the implications of Section 35. So what we ultimately have here is that we want to redebate the case.
On the cases that you referred us to relating to Section 12,
we know.
Can I ask you to specifically give me references where they deal with the actual meaning of trial as envisaged in Section 12, if they do say trial as contemplated in Section 12 includes motion proceedings?
Yes, so firstly, the question of the meaning of trial. In other words, the argument we have here, whether or not the trial is the same as Section 35(3), that you will find at paragraph 14 of Nel versus Roux. It's clear that it's.
I'm sorry, that I understand. A trial cannot be a trial only if it caters for the rights in Section 35. You can still have a trial that does not cater for that. What I'm interested in is the interpretation that says, when Section 12 says you have a right not to be detained without a trial,
yes,
it means you have a right. The word trial includes if you have a hearing in motion proceedings,
yes,
that would constitute a trial.
Yes, no, yes, that's what is in paragraph 24 and 25 of FACI in the majority. That's where, in fact, in paragraph 25, and in interpreting of the procedural aspect, it seems to me entirely appropriate to regard the position of a respondent in punitive committal proceedings as closely analogous to that of an accused, and therefore determining whether the relief can be granted violating such to the respondent such substantially similar protections as applied to motion proceedings.
You see, it does describe them differently, not as a trial. It seems to me the concern of the court there, the focus was whether or not the procedure or process had the fair right, fair trial right safeguards, as opposed to saying this, which is what we know as lawyers, we know that motion proceedings do not constitute a trial normally. Now, if the court were to say the word trial does not carry its normal meaning as used in Section 12. In Section 12, it also includes motion proceedings. I would expect it to say it explicitly, because motion proceedings are not a trial.
Yes, well, Justice Shafter, firstly, just to go back to paragraph 14 of Nel versus Roux and paragraph 67 of DeLange versus Smarts. Nel versus Roux is clear. The trial envisaged by this right does not, in my view, in all circumstances, require a procedure which duplicates all the requirements and safeguards embodied in Section 25(3) of the Constitution. But what's the positive content? In most cases, it will require the interposition of an impartial entity independent of the executive and the legislature to act as arbiter between the individual and the state. And you then go to...
I still understand that. I understand that. I have no quibble with it. But I still understand it to mean it must be a trial. You don't have to say it is a trial only because you can tick the boxes in all boxes in relation to Section 35.
Yes.
Some of those requirements in Section 35 may not be there, but it must still be a trial.
Yes, but Justice, but that question is, in our respectful submission, completely answered by evaluating whether or not the motion procedure for contempt breaches Section 12, which is what FACI is about. And FACI says it's perfectly compatible with Section 12. And Section 12 is the trial right. In fact, the minimum requirement for a trial, according to Nel versus Rule, the minimum requirement is an imposition of an impartial entity independent of the executive. And you can look at this trial issue. When I looked at these cases, you look at this trial issue as a spectrum. On the one side of the spectrum is a summary procedure, a person in FACI committing contempt. That is a trial which in some instances has been found to be lawful. In the middle is motion court procedure, where there is a full exchange of pleadings, where there is no exclusion of oral evidence if the respondent, by the way, which may even, in fact, even give them greater protections, where a respondent may ask for a matter to oral evidence. And then on the extreme end of is then witnesses giving evidence. But those three are themselves manifestations of the trial, from summary procedure to a full-blown sitting with witnesses giving evidence. But that's all a trial.
Well, I thought, Mr. Nguracha, and correct me if I'm wrong, I thought if we are called upon to interpret what Section 12(1)(b) means,
yes,
we have as a starting point to look at the language of the section and determine the content and scope of the right in relation to that language. And if we do that, we have to say, and it may well be that this is what it means. We have to say trial as contemplated there, having determined, includes motion proceedings.
Yes.
If we do that.
Yes, there's a different way of putting the same proposition, Justice Chair. Firstly, let me answer the one question about what question is before the court. That is not the question before the court. The question before the court is examining an error, a basis to re-enter the debate. And I have shown now that you have no basis to re-enter the debate. So the narrow question is, do we have the basis to re-enter the debate? The answer is no. Then you've asked me the question as to how, in fact, you should approach the question of interpreting the trial. So I say there is a different way of putting the same proposition. And that way of putting the same proposition is a motion court process for contempt an infringement of Section 12? That, in fact, is the pertinent question. And if you
but the section uses the word trial. No one would be detained without a trial. You have a right not to be detained without a trial, meaning you can be detained if there was a trial, isn't it?
Yes, no doubt. I accept that entirely. What the point I've simply been in court is your oath towards Machabeng and Peko. The SCA is the most exhaustive and the most learned. In fact, after the SCA is probably this judgment by Justice Khampempe that is the most learned on the topic, because you examine the textual violations, you ultimately come to the conclusion. And so if you were to drill this thing down, remember in Nel versus Roux and in the Smarts versus the Lange, those were instances about what to do with a witness who is recalcitrant from testifying and whether or not you could arrest them summarily. And the finding there was you can, as long as the summary arrest is not done by, I think it was a body of creditors in the Nel and Rue case, as long as at the base minimum, that is done by the judiciary. So if you look at what Justice Ackerman ultimately says in the finding, he says the section is unconstitutional because it does not interpose the judiciary. So the focus of the section is always, do you have an independent judiciary making the determination? The language trial is seen in a spectrum from summary to motion to what we call a trial, which is witnesses giving evidence. But all of those are mechanisms of giving effect to section 12. But motion for contempt, you have said it twice, it's perfectly constitutional under section 12. And that is what has been held in Faki. So I'm afraid you will have to substantially revisit your authorities if you are to find that motion court proceedings are inappropriate for contempt proceedings.
Well, I'm not quite sure about that because my recollection of Phekwe and Machaweng, for example, is the distinction that is drawn between civil contempt and criminal contempt. And civil contempt, as I understand it, is a process which does not lead to a conviction and a criminal penalty. It's a process that leads to some civil remedies. So that distinction was drawn. Here, we're dealing with a criminal contempt. And that is a process that leads to a conviction and sentence. So I'm not sure whether you are right to say we will have to revisit our decisions. You may be right, of course, but you see, what I have not picked up, Mr. Ngugaitobi, in the short time that I had in preparing for this hearing was to pick up a case that really says what is meant by a trial is any judicial process. If it's a process that is run by a court, it constitutes a trial for purposes of Section 12. If that is what we are saying, I think we need to substantiate why we're saying that. I understand a proposition that says, no, don't get confused. If Section 12 says a trial, it doesn't mean a trial that will have to meet all the requirements of Section 35.
Yes.
That I have no quibble with that proposition.
Yes. Well, Justice Chafter, that's enough for me to succeed. That you simply reject the idea that underlies the application, which has been rejected in this court. So that would be enough. The question as to whether or not trial in its full manifestation would include a summary procedure, motion court procedure, can be parked for another day. What is enough for today is simply you to be satisfied that on existing authorities, only 2 points you should be satisfied with. On existing authorities, the Section 35(3) protections have not been imported full scale. Secondly, motion court proceedings have been approved as being appropriate and not in breach of Section 12. Those are the only 2 things you have to be satisfied with. The debate we've been having is an interesting debate, but it is not a bar to a judgment by yourself, not you personally, but by the court in favor of the respondent.
Yes. lastly, what troubles me, and it may not also be relevant for the determination of the issues that you have just mentioned. What troubles me is this in relation to the applicability of Section 35. As I see it was open to the Commission to go and lay a criminal charge when Mr. Zuma did not comply with the court order. Or am I wrong?
Yes, Justice Chafter, I mean, I know for sure that it was open to lay a criminal charge when he didn't comply with the summons. But when he didn't comply with the court order, the contempt is enforced through a civil contempt. You bring an application to court and you compel him to comply.
Well, would the process suggested in the De Beer matter not lead to the laying of a charge?
No, Justice Chafter, we must remember that De Beer is a substantially different case to what we are dealing with. De Beer is closer to S versus Mamabolo. Because De Beer is not a case where you have issued an order in which a respondent refuses to comply with. De Beer is a case where a respondent, in correspondence to the registrar, impugns the court. But there is no order against De Beer to do something which he then resists. In the same way as what had happened in Mamabolo.
Yeah.
In Mamabolo, what was then recommended was a charge to be laid with the NPA or with the police rather. And the same thing in De Beer. But what we are dealing with here is a person who refuses or resists explicitly, openly, brazenly to comply with a court order. That process, as pointed out by Justice Cameron, would simply not be conducive to the proper administration of justice if the remedy of contempt by motion, because you must remember that this remedy, I know that we have been criticized by Mr. Mpofu that there is a deputy chief justice who's a member of this court and he has used senior counsel to bring a contempt directly to the constitutional court. Quite frankly, I don't know where that enters into the equation. But you must remember that what is crucial about this remedy of civil contempt is an individual who has been successful in court but is facing a recalcitrant respondent. So Justice Cameron says it must remain open to them to come to court and to compel compliance, failing which, as pointed out in Machabeng, to sometimes as an alternative, sometimes as the primary relief to ensure their incarceration. So I'm not sure that it is entirely accurate that we were precluded from coming to court to seek the incarceration. I think, in fact, it was the primary relief in the head.
No. I'm not exploring that. I'm not saying my understanding of it, and it may be wrong, is that if it is a crime, if we accept, if we move from the premise that contempt of court is a crime, whether one has disobeyed a court order or has done some other form of contempt, they have committed a crime. Hence, we have this whole notion of a conviction followed by a penalty. Am I wrong?
Yes, no, I get your point. I mean, in those circumstances, I think that is whether it was appropriate for us to approach the court on proceedings seeking punishment.
No,
and I think the answer to that is, I mean, the answer to that is in PERCO.
I accept that, Mr. Ngogaitobi. My concern was lying in this. There are two options available to a litigant who has an order made in their favor and it is not carried out, as I see it, is either you go to lay a charge or you pursue contempt of court proceedings as the commission has done. Am I right?
Yes, you may be right. We'll have to look at the first part of the case because I cannot at this point in time confidently give you the answer. But let us assume that's correct to facilitate the debate.
Yes. The concern that I have then is in relation to Section 35, it seems to me that for the person, the contemner, who would have enjoyed the protections in Section 35 had a criminal charge been laid, somehow does not enjoy the same protections if the route of civil proceedings is followed.
No, that's true. I mean, but that's water under the bridge. That debate has been had. It's been found, and this is the point, since 1996. It's been found that you can actually bring a civil contempt, and it's been found that civil contempt need not duplicate the Section 35(3) rights. And it's been found that is constitutional. And there are strong public interest reasons for that, which have to do with the proper administration of justice. These are all set out in Fagi. They are all endorsed in both Machabeng and in Pego. They say it's much better to have a functioning judicial system, and we need the mechanism of contempt in order to keep the judicial system functioning.
So what is it a case of the means, or rather the end justifying the means?
It is a question that this topic that we are debating has been exhaustively discussed. And it has ultimately been concluded that the civil contempt process is compatible with the Constitution. If we had adopted an approach that is not compatible, that would be a different debate.
Finally, Mr. Nguyen, as I understand it, lawyers have different understandings of what civil contempt means and what can be granted in a civil contempt. There are those of us who believe that you can get a conviction and a sentence in a civil contempt. Some of us believe that you can't do that. You can get other remedies which are civil in nature in civil contempt. But I heard your argument. Thank you.
Well, I mean, the one thing that is unique about a contempt, it is one of the few crimes that can be purged. You know, you cannot purge murder. You cannot purge theft, but you can purge a contempt.
Yes.
And that, in fact, is the last point I should be making.
Thank you.
Yeah.
Can I ask this, Mr. Nguyen? This is, I'm just curious.
Yes.
The last time you were here, you told us that the commission was not insisting that Mr. Zuma go testify because it was about to wrap up and there wouldn't, practically speaking, be time for him to testify. Now that the extension has been granted, would the commission be interested in having Mr. Zuma to testify?
Justice Jafte, I'm glad you've raised this because it's another false allegation made by Mr. Zuma in his allegation, in his papers, because the actual papers that when we brought the contempt proceedings, we specifically left the door open for Mr. Zuma to undertake to comply. In, I think it was paragraph 20 of the founding affidavit when we came to the Constitutional Court. We had never made the case that because the commission's time frame is coming to an end, therefore Mr. Zuma cannot. We simply said in that paragraph 20, if the court is of the view that Mr. Zuma should be compelled to comply first before an arrest, arrangements, it was I think footnote 47, arrangements would have to be made so that that is possible. Now, in the founding affidavit here, Mr. Zuma falsely claims that he never had the option of complying before the decision was made to find him guilty and to impose the sanction. I came to argue the case, and this is one of the reasons why this is just inexplicable how the allegation, which is clearly untrue, could have been made. When I argued the case before the Constitutional Court, I think on the 20th of March, if I'm not mistaken, 25th of March rather, the point was Mr. Zuma has explicitly told us that he will not comply. This is precisely what is at paragraph 51 of the majority judgment. And this is what Justice Khampembe says. I reiterate that with or without a coercive order, Mr. Zuma has made it clear that he will not purge his contempt. He has offered neither contrition nor apology. And it's actually interesting that Mr. Ngalwana tells us today that Mr. Zuma has apologized because he uses the word mea culpa. There is just no evidence of that apology. Mr. Zuma himself doesn't apologize, but an amicus comes to apologize on his behalf. Contrition, no apology, let alone any suggestion that he intends to obey an existing or future order of this court. So the submission, quite contrary to the fact that it was to do with timing of the commission, the submission was, in the light of the attitude adopted by Mr. Zuma towards complying, it serves no purpose to issue a coercive order. The only appropriate order is a punitive order. So it's actually not accurate that the commission took the view that Mr. Zuma had no option of complying. The correct position was, in the founding affidavit, he was told that there is that possibility. He told us he was not interested, and that's why the submission, as correctly upheld by Justice Khampembe, was in the light of your attitude, because contempt is one of the few things that you can purge, and if you purge it, you get away.
Now that the circumstances have changed, he's in custody, his attendance at the commission can be achieved by simply requisitioning him. Is that not so?
No, Justice Chafter, I am not sure about that aspect. What I know, what you can work on are the pleadings. And on these pleadings, Justice Chafter, with the greatest of respect, Mr. Zuma persists with the contempt. He has told you many times that he will never appear before a biased chairperson. This is despite your own court order. And one should not factor in extraneous evidence on an issue as sensitive as this. Mr. Zuma had the option in these proceedings today, in this application today, he had the option of heeding what was said by Justice Khampembe. He had the option of offering the contrition, the apology, the suggestion that he will obey the existing and the future court orders. On the pleadings today, he has done none of those. So you have no basis assuming that something that will happen, the requisition, and on his appearance, there will be cooperation. He could have said that he did it. He told us the opposite.
Thank you.
So thank you, Justice Chafter. Two more points on interest of justice. I've already made the first two. The third one is this one that I'm grateful that you have invited me to articulate. That is paragraph 89 of my heads of argument, what you should do about the health concerns. I've answered that in relation to Justice Majid's question. And paragraph 90, which is the fact that he has not purged. And then the last point is, if you look at the language that he has used, he has been chastised for this language. In paragraph 91, we've summarized everything he has said about this court. What you are left with is the clear impression that you are left with you are left with the impression that you have a person who is, despite the punishment, despite the imprisonment, has still not taken the view that actually judgments of the Constitutional Court to be complied with. When I began my submissions, I started by reminding everyone that Mr. Zuma has always held the keys to his own prison door, which he could use by the simple act of tendering to comply, not on his terms, but on the terms that have been prescribed by this court. This court has told us previously how to treat a person in the position of Mr. Zuma, found to be in contempt, ordered to do something, but refuses to do it. It is in paragraph 4, our heads of argument, where we say, what do the interests of justice actually require in a case like this? This court unanimously, it was a judgment by Justice Colapel. Those interests will not be best served and will be undermined if the applicant is allowed to proceed and deal with the merits of the appeal in the absence of him remedying his conduct by complying with the August order. It will dilute the potency of the judicial authority, and it will send a chilling message to litigants that orders of court may well be ignored with no consequence. At the same time, it will signal to those who are the beneficiaries of such orders that their interests may be secondary and that the value and certainty that a court order brings counts for little. Imagine this case, Justice Chapter. You wrote the judgment of the court on the 28th of January, 2021. You said that all Mr. Zuma was required to do is to account for his period in office. That's all he was ever required to do. That's all. All of this could have been avoided if only he had heeded your own judgment, which did not impose impossible obligations, simple obligations of accounting for his term in office. Today, we have persisting contempt. You are told to revisit your order. No contrition, no apology, nothing. Just persistent, brazen contempt. In those circumstances, the interests of justice do the opposite of what Mr. Ngalwana suggested they do. They require you to dismiss the application in clear, unambiguous terms. Insofar as this application, so-called, that is now intended to be introduced, I've already made my submission in response to Justice Majid. What is clear is that there is some urgency in the delivery of an outcome by this court, so that the current uncertainty is closed. Thank you, Justice Khampembe. I have nothing else to say.
Sorry, Mr. Ngaitobi, just on the question of procedure, can we really say that there is no application before us, an application for the stay? Looking at, is it paragraph 9 of the supplementary affidavit?
Yes.
There's cross-referencing to the notice of motion. The reference, I think, refers to further and or. Would it not be a case of form over substance to say there isn't?
No, Justice Madanga, you have to bring a substantive application because this is separate relief, not even consequential relief. It's just totally separate relief, which there are parties with an interest in it. We obviously have an interest in the benefits of the order that the Department of Justice and Correctional Services has an interest. We also have no evidence to support the allegations that have been made. All we have is the possibility of introducing new evidence.
No, the question,
so even if we took the most generous construction.
The question of evidence goes to the question of whether or not that application will then succeed. Just address the question whether we do have an application before us.
Yes, Justice Madlanga, I would say that even if you were generous, that does not constitute an application. It is a supplementary affidavit, no notice of motion, no separate relief. If you were a respondent, it's impossible to know what you would do in such a scenario. And the prejudice in those circumstances is manifest. So I would say that simply doesn't constitute a proper application. Thank you, Justice Matlanga. I've already told the presiding judge that I have nothing useful to say to this court anymore.
Thank you, Mr. Mugai-Toby. Mr. du Plessis.
Thank you, Justice Kampepe. I'm sure, like Ms. LaRue, I would ask the court, in the spirit of equality of treatment, to extend also to the other amici the same protection of 12 minutes that was afforded to Mr. Ngulwana.
Yes, Mr. du Plessis, you shall be given that protection.
Thank you, Justice Kampepe. Justices, there are three unbearable constitutional ironies, we say, at the heart of this case. The first irony is that Mr. Zuma deliberately squandered his chances repeatedly before the court, but now he wants the same court to hear his case anew and to reopen it. The second irony is that Mr. Zuma was declared to be in and sentenced for contempt by this court, yet he wants the same court to overturn that declaratory and sentence, but while he remains defiantly in contempt to this day. And the third constitutional irony is truly perhaps the most staggering one with respect, and that is that Mr. Zuma wants this court to rescind its decision on the basis that it, the court, erred, all the while insisting that he, Mr. Zuma, has not erred, that he has done no wrong. So he wants the outcome of this case to be that he walks away with absolute impunity and accountability free. We know that from the written submissions for Mr. Zuma by our learned friends who insist that the order must be rescinded to, in their words, swing open the prison doors of his prison cell. But not once, with respect, do our learned friends or Mr. Zuma accept that he was contemptuous in either Zuma 1 or Zuma 2. And our learned friend in oral argument said that they do not accept that his conviction was correct. They insist, indeed, on paragraph 3 of this court's order being the declarator also being rescinded. And there is no, with respect, mea culpa as suggested by Mr. Ngulwana. But justices, we focus our submissions on the interests of justice largely. But let me just briefly say that as a matter of law, we agree with the Commission that Mr. Zuma's application palpably fails the legal test for rescission. Mr. Mugai-Toby has already shown why Mr. Zuma's case fails on the law. We would only add one further point on the legal case for rescission arising from the debate that took place earlier today. We know that Mr. Zuma was afforded an opportunity more than once to provide his views on sentence, once in the ordinary course as a litigant, and then again through this court's directive of the 9th of April, 2021. And we stressed here, it's been perhaps overlooked in the debate, that as a litigant in motion proceedings, he would have had the advantage of Plascon Evans had he put up any form of affidavit. But he elected both times to abjure the chance. And there was no mistake by him. We know it was a deliberate and doubled down election, and it was emphatically unequivocal. The HSF has put up in its answering affidavit the letter that this court knows well that was sent by Mr. Zuma, the 21-page letter in response to the court's directives, where the court had asked specifically for Mr. Zuma's submissions on mitigation. In that letter, Mr. Zuma's position could not have been clearer. He said three things. He said, I was content, and I'm using his words, I was content to leave the determination of the issues in the mighty hands of the court. I still leave the matter squarely in its capable hands. That was at paragraph 10. At paragraph 62 of his letter, he said, this court must know that it will imprison me. And for that, I leave it to you and your court, he said. And he concluded by saying, I've accepted that my stance has consequences. So whatever process the court followed, he left the court to deal with it. So he did not just sit back, to use the expression in the debate that was being engaged in between Justice Chiki and our learned friend, Mr. Mpofu. Mr. Zuma didn't just sit back. He publicly, unequivocally, expressly washed his hands of the case. And as this court said in its judgment at paragraph 72, his conduct thereby demonstrates a deliberate choice to, instead of furnishing this court with mitigating factors, once again air his views through inflammatory statements. So if I might just briefly highlight that Mr. Zuma's counsel now in this court in the debate this morning says that despite that election, that clear, express, unequivocal election, Mr. Zuma's rights cannot be waived because they are constitutional ones. Well, with respect, there are three fundamental problems with that argument. The first is that it's inconsistent with this court's and other courts' case law on preemption of one's right to rescission. And that's the important point. This is a case about the right to rescission, Does Mr. Zuma have the right to come to this court and ask for what his notice of motion says is a Rule 42 rescission case, and his finding affidavit says is a rescission case? Has his right, which he claims before this court, been rescinded by his conduct, or in that context, preempted? It's clear, we say, that a right to appeal or to seek rescission can be preempted. And it can be preempted even though it's a constitutional right. And in that respect, we reference this court's decision in SARS versus CCMA. It's 2017, volume 1, SA 549 CC. This court at paragraph 26 said that preemption is a waiver of one's constitutional right to appeal. So constitutional rights can be preempted and they can be waived. And in Carter versus First Rand Bank, which we've referenced in our written submissions, His Lordship Mr. Justice Rogers extended the right of preemption to rescission. So in this case, the litigant, Mr. Zuma, washed his hands of this court and its process in toto. The position with respect that his counsel now advances appears to be the following: that you're afforded an opportunity to have your say. You're repeatedly rejected. The consequences you have washed your hands of then follow. You thereafter claim that you did not waive your rights because you could not waive your rights because they were constitutional rights. Well, with respect, that firstly misses the point that the right in issue is the right to preemption and the right to seek, the right to rescission rather, and whether that has been preempted. But it's also clearly untenable as a matter of logic. The position that our learned friend wants this court to adopt would be fatal to the finality of any fair process. Imagine the law of prescription. You deliberately let your claim prescribe, but then you insist that it must be reopened because of a Section 34 right of access to court. Or PADGA, which this court knows well. You deliberately refuse to honor the delay rule, but you insist that you can nevertheless have your review heard because of Section 33 rights. Or an accused right to a trial. You deliberately refuse to plead or intentionally remain silent, and you're convicted, but you insist that you can reopen your trial afterwards because of your Section 35 rights. With respect to our constitutional democracy, the rule of law and judicial authority would grind to a halt if a party could, despite such intentional elections, and this case is the paramount example of an intentional election, if such a party could then after the fact seek to reopen the litigation. The second fundamental problem with respect to Mr. Zuma's argument is this. In Skumbi, this court said that it was difficult and the bar was high in relation to waiver of constitutional rights. But the court didn't say that it was impossible. This court has never ruled that it is impossible for constitutional rights to be waived. What Mr. Mpofu, with respect, never properly deals with is that in this case, this court very carefully considered Mr. Zuma's choices, made against the background of the fair process that it extended to him and then held him to his choice. And it's important to recognize that conceptually. From within that process that had been extended to him, Mr. Zuma was time and again afforded his rights, but he elected to say nothing and offer no defense. He chose not to exercise his rights. That was his choice. But the correct question then is whether the right to rescind has been preempted, and it was. And then third, and very briefly, and finally on this point, this issue of waiver and this issue of whether constitutional rights that Mr. Zuma had, and which this court extended to him, could be, in this context, ultimately waived by him, has already been decided by this court in its 29 June judgment. It's finally ruled on this score. And that is clear from the fact that the minority judgment, again, by Justice Turon, and in this respect, the debate is easier because one can highlight that this debate has already happened before the court. At paragraph, in that judgment, the court was clearly aware that there was a minority paragraph 196 of the minority judgment, which specifically raised the issue of whether constitutional rights could be waived. But that was ultimately and effectively rejected by the majority because the majority's decision was that in this case, Mr. Zuma had been given all of the perfectly fair chances time and again to be engaged in the process, but he had decided not to do so. And in those circumstances, nevertheless, said the court, it could go on to find the declarator necessary and issue the sentence that it ultimately imposed. So on the law, the legal test is clear, Justices. The pleaded case for rescission by Mr. Zuma doesn't get out of the starting blocks for all the reasons already given by my learned friend, Mr. Nkai Toby, but also because of preemption. As Justice Majid says, where is the error in this case? There is no error. And a debate ultimately in this case, which in the end conduces to something that our learned friend said, is between a majority and a minority judgment, cannot give rise to rescission application. That would not only be destructive of our rules on precedent, that any party who ends up having a final judgment issued against them says, but I've read the minority judgment. I want to come to the court and I wanted to rescind the majority judgment. Well, that would be the end of precedent. It would also, and we say this boldly, it would also probably be the end of minority judgments. Who would want to write a minority judgment that then repeatedly forms the launch pad for rescission applications before this court or others? So as I've said, it's ultimately the question of justice interests that we wish to focus on. So we respectfully submit in the remainder of our submissions that in this case, the matter in any event falls to be dismissed because of the interests of justice. Let me say in that regard very briefly the following by way of introduction. Mr. Zuma's case has been, and we say this with respect, it's been difficult to pin down, but it now appears to have become about fashioning some or other exception for Mr. Zuma under Rule 42. But I stress that's not his pleaded case. His case in his notice of motion in paragraph 1 specifically says that he is seeking Rule 42 rescission. And in paragraph 10, he says this is an urgent application as contemplated in Rule 42. And you see that as well. I won't read them to you. Paragraphs 56 to 65, he speaks about the legal framework of his case, and he says it's a Rule 42 case. And in paragraph 69 and paragraph 94, he reiterates that he is claiming that there were errors made under Rule 42. But with respect, we say he comes nowhere close to making out a case that those errors were committed under Rule 42 because of the obvious point that Daniels, this court's decision in Daniels, says that you don't come for rescission in respect of errors that the court was aware of or mistakes or defenses that it was aware of. It has to be errors that the court was not aware of. This court was aware of all of the defenses that Mr. Zuma now attempts to flout before the court, and it dealt with them comprehensively and dismissed them. So ultimately, it doesn't get out of the starting blocks as a Rule 42 case, which is, and we say this with respect to our own friends, where that case has to be kept. You don't get to, in a case as important as this, plead a full case on 42, and then in the court, an oral argument, begin to make out a different case. But that's what's happened. A case under the interests of justice. And we say in this context that there is nowhere in our learned friends' founding papers any proper explanation of what the interests of justice are in this matter. Our learned friends make out no case why, on the basis of exceptional circumstances, any of the grounds that he raises could justify a reopening of the matter. And we say this with respect because pleadings are important. It would be dangerous to do so in this case because we'd be dealing with a new case with obviously very far-reaching consequences for all of this court's orders, not only in direct access cases, but under exclusive jurisdiction cases, as well as appeals. Indeed, as we now know, the exceptional circumstances of this case confirm that it could never be in the interest of justice to allow rescission under the pleaded case or his new unpleaded case in oral argument. We say that through this court's overriding power that it has in a direct access case under section 167 of the Constitution to dismiss cases for direct access on the basis that it's not in the interests of justice to hear the matter. And this court has already said in Bafalane that even if this court could, outside of Rule 29 read with Rule 42, change a final decision that had already been made, that would only be possible where it would be in accordance with the interests of justice to reopen a matter in that way. But then the court added a critical additional point. It said the interests of justice would require that that be done only in very exceptional circumstances, said that court at paragraph 19, said this court rather, in paragraph 19 in Bafalane. So the question is justice served by allowing this effort by Mr. Zuma in the most exceptional and truly extraordinary circumstances of this case to reopen? And we say the interest of justice test doesn't help Mr. Zuma. They count very firmly against him for 4 reasons. For 4 reasons, we say, and we'll be brief in respect of each of them, that the dangers of Mr. Zuma's conduct pose to our democracy was recognized by this court in its 29 June judgment, and this court cannot be moved off the line that it drew. The first reason is this: the severity of the harm to the rule of law by Mr. Zuma's conduct.
Mr. Du Plessis.
Yes, Justice Kempepe. Thank you, Justice Kempepe. I assume that you meant that the protection time is up. Thank you.
Yes.
Thank you. The judgment that so the first point we make as to why, in the interest of justice, this court should not entertain some form of interest of justice exception, is that the judgment that Mr. Zuma once rescinded is not an ordinary case of contempt. We know that. This court said it's the most exceptional threat to the rule of law that this court in the country has faced since the start of our democracy. So 2 weeks ago, in paragraph 1 of its judgment, this court described Mr. Zuma's attack against this court as a series of threats and direct assaults and calculated and insidious efforts by Mr. Zuma to corrode its legitimacy and authority. And that's why the court said that it was ultimately moved to take this case by direct access and urgently. Said the court, if these circumstances do not warrant swift and effective judicial intervention, then I do not know will. The administration of justice requires this intervention. So Mr. Ngwane very correctly accepted that there may well be exceptional circumstances where and when there may be a necessity for a contemnor to be committed to prison. And he mentioned the point of contempt in facie curia and where the NPA declines to prosecute. But with respect, we say this case is a paramount third example of a necessary exception where somebody must be committed to prison. The harm in this case was so exceptional that the process followed by this court was adopted. This was, as it said, that even though a contemnor is not an accused person as is envisaged by Section 35, the fair procedure required by Section 12 may, depending on the circumstances, necessitate a process that's akin to that afforded by Section 35. The court looked at that very closely, and that's the process that this court decided to follow. It's unthinkable, we say with respect, that given the severity of that harm, its nature and its source, that it could be in the interests of justice to grant rescission. Putting it differently, this court at the highest court was perfectly entitled to choose the approach it did to adopt what our learned friends call the Zuma option. But it was entitled to do so on the facts. It had to do so on the facts, as we'll point out in a moment. But it was also entitled to do so in light of its own previous jurisprudence. This court said in the EFF case at paragraph 19, said the following: as the highest court in constitutional matters and the ultimate guardian of the Constitution and its values, it has to adjudicate finally in respect of issues which would inevitably have important political consequences. This court, the highest court in the land, is the one the Constitution has said must deal with disputes that have crucial and sensitive political implications. This court did just that. The second reason, Justice, the interest of justice counts against Mr. Zuma is that the threat continues. It's not stopped. This court in its 29 June judgment took time to record at paragraph 30 that Mr. Zuma's assaults and his alleged contempt are ongoing and relentless. He belatedly now comes to the justices to insist that the court must reconsider its order, but the threat has not dissipated, justices. Since 29 June, the assaults have not abated. They've been aggravated in 3 ways. The first way is he's willfully defied the sanction that was imposed upon him. We know that the court had ordered in terms of paragraph 5 that he had to hand himself over by Sunday, the 4th of July. He deliberately refused to do so. And his open defiance plunged the country into a constitutional crisis. It forced the police to do their duty under paragraph 6 of the order. And that willful contumacy of this court's order was brazen, justices. It lasted from Sunday night, 4th of July, until when the police arrived at his home to arrest him late on Wednesday night. He thus refused to undergo imprisonment or to hand himself to the police ongoingly for that time. And to say that he had purged himself of contempt by eventually handing himself over to the police is to ignore with respect that he only went at the 11th hour and only when the police had arrived. It seems obvious that had they not arrived to arrest him, Mr. Zuma would still be at Nkandla. The second means by which he has continued to defy the order is that he's refused to recognize that he's in contempt of either this court's order in Zuma 1 or Zuma 2. He said so through his counsel. This court has ruled in Zuma 1 that Mr. Zuma must appear, and this court knew about his rescission application, but it said that his refusal to appear was contemptuous. He refused to comply, we know that. Mr. Mpofu now says that he will appear, but we know that he will only go on his own terms, so long as it's not before Justice Zondo. Well, that is continued self-help. He wants his own order to appear before someone other than Justice Zondo. And so therefore he continues to ignore the judgment and order of this court, which rejected all of those arguments and all of his claims around the biased hearing that he was going to have, and which ordered him nonetheless to appear. It's also apparent in the first place from his public statements that have been made by his foundation. We've highlighted that his foundation has specifically after this court's judgment denounced it as judicially emotional and angry and not consistent with our constitution. That we challenged Mr. Zuma in respect to that. We said, you should distance yourself from that in the answering affidavit. You haven't distanced yourself from it. And in his replying affidavit, he didn't deal with that at all. And in that context, one can see the pleadings in the answering affidavit of the HSF at paragraph 31 and the replying affidavit by Mr. Zuma at paragraphs 43 to 45. So there's ongoing contempt there too. And there's further contempt, and that's not only by his foundation, that is by Mr. Zuma himself. His own words, he publicly stated and confirmed on affidavit before the Pietermaritzburg High Court last Tuesday on the 6th of July, that he had done nothing wrong and there should be no investigation into corruption at all. That was from the Citizen newspaper that had been put up in that case. And in respect of that newspaper article, Mr. Zuma accepted that he'd said that. He accepted that what the Citizen newspaper had said was correct. And critically, those statements were made after this court's judgment on the 29th of June. He said these words, he says, "It will be difficult for me to hand myself over for imprisonment when I've done nothing wrong." The third means by which he shows continued defiance is on display with respect, justices, in this very rescission application. Under oath, he has demonstrated remarkable self-help and disdain for this court's finding and orders himself. He has said that this court was fundamentally flawed. He has said that he's entitled to express strong views against an oppressive system. And he says that he didn't comply with the orders of this court. This is truly remarkable because I believed that they were unlawful. Mr. Zuma believed that they were unlawful. So this is self-help by contempt upon contempt. And again, we say with respect that in those three ways, Mr. Zuma has now continued to show directed and deliberate contempt for this court, its orders and reasoning in a calculated attack on the rule of law. And so we have this court's jurisprudence in SS versus VS, which means that it could never be in the interest of justice for him to approach this court and succeed. Because in that case, the court said that it is unconscionable when a party seeks to invoke the authority and protection of this court to assert and protect a right it has, but in the same breath is contemptuous of that very same authority in the manner in which it fails and refuses to honor and comply with the obligations issued in terms of a court order. But that's exactly where we are today. So to this court, in SS versus VVS, at paragraph 35, the court used the interest of justice standard there. And it said this, it said the interest of justice will not be best served and will be undermined if the applicant is allowed to proceed and deal with the merits in the absence of him remedying his conduct by complying with the August order. Said the court, it will dilute the potency of the judicial authority and it will send a chilling message to litigants that orders of court may well be ignored with no consequence. And so this court made that clear in SS, but it went one step further, justices. It said, there is a heightened obligation where court orders touch interests lying much closer to the heart of the kind of society we are seeking to establish. And in the present matter, that couldn't be truer. This court's orders touch interests that lie at the heart, soul, and the future of our constitutional democracy. It's not just the litigants' interests, but the nation's interests. And that's not only in respect of the State Capture Commission and its work unearthing corruption. It's also in respect of this court's order of the 29th of June. This court said in making that order, never before has the judicial process nor the administration of justice been so threatened. Yet, and justices, on this point, in the interest of justice weighing, we say the following. The hope of never again that this court expressed has been dashed by Mr. Zuma repeatedly since, again and again. And so in those circumstances, Mr. Zuma has once more left this court with no choice. He remains committed to his contumacy, and he does so in the teeth of this court's judgment. He has put himself deliberately with respect beyond judicial redemption. The third reason, justices, the interest of justice count against him is that this court has already finally ruled, and importantly, we stress, it's already finally ruled that it is not just permissible to declare him in contempt and sentence him, but that this court was obliged to do so, that its discretion left it with no choice whatsoever in light of the circumstances. So in confronting the attacks in its 29 June judgment, this court has already ruled finally on the interest of justice test as to the relief that was necessitated. Its rulings on the interest of justice then stack up firmly against Mr. Zuma. Those interests, said this court, were so severely threatened that the court felt that it had to take the case urgently, that it had to take it by direct access. And then it said that it had to deal with Mr. Zuma because the continued and persistent contemptuous conduct, said the court at paragraph 35, risks denigrating the rule of law, and in paragraph 36, that it's therefore in the broad public interest that this court sends an unequivocal message that its orders cannot simply be ignored with impunity. So this court, the Constitution's highest guardian, looked at the risk in a clear-eyed way, and it carefully weighed the source, the nature, the severity of the risk to the interest of justice, and it then turned to the relief necessary that had to deal with that risk. And justices, we say this with great respect. The majority said that the only just and equitable order was imprisonment. So this court, as the rule of law's uppermost protector, said that a constitutionally fair process had been followed, with all of this courts and Supreme Courts of Appeal jurisprudence on civil contempt having been carefully weighed, and critically, that Mr. Zuma's rights had been carefully and deliberately protected within that process. And then it said, after all of that, and given the harm, this court, in a final passage, in paragraph 41, said, it has been left with no option but to commit Mr. Zuma to imprisonment in the hope that doing so sends an unequivocal message in this, our constitutional dispensation, the rule of law and the administration of justice prevails. In short, this court said there was no escape for Mr. Zuma. It was constitutionally obligatory for it to sentence him in the way that it did, as a necessary defense of our constitutional democracy. Now, justices, if the interest of justice meant that there was no other option but that sentence on the 29th of June, there's even less of an option now. If anything, by his aggravation, he has confirmed the need for the contempt finding and the sentence to stand. The interests of justice, of course, guarded by the justices of this court, couldn't possibly countenance anything less. And then fourth and finally, and we will be short on this fourth and final reason, the interest of justice count against Mr. Zuma, is that there's the overwhelming public interest in the finality of the rule of law and rules and this court's decisions being applied firmly in this case. This court knows that the rule of law ordinarily holds the twin principles of finality and legality as higher principles. This court said so on multiple occasions, and Ms. LaRue for CASAC no doubt will speak further on this in a moment. But the approach that Mr. Zuma seeks to establish is not only anathema to the rule of law and judicial authority, it's one that would paralyze the judiciary, would ensure chaos over certainty. Apparently, through some form of expansion of Rule 42 for this court to reconsider its decisions through some or other interests of justice test, but that expanded rescission jurisdiction would, even leaving aside the facts of this case, would clearly open all of the floodgates. But the point is, therefore, that ordinarily this court would guard strictly against any attempts to reopen cases because of the untold and the obvious damage that it could inflict on the rule of law. And that's why Mr. Mpofu was driven to accept that the only time this expansion of Rule 42 could happen is where there's a clear unconstitutionality inherent in the court's judgment. Yeah, there's not. The very supposed issues raised by Mr. Mpofu were clearly considered and ruled on. But the facts of this case confirm that it should be the heightened duty on this court not to do so here, because the precedent set would go beyond damage to the rule of law. It runs the risk of being utterly destructive of our system of law and this court's authority as the final and dispositive voice on what our law means. We had hoped that it was not necessary to say so, justices, but we must, alongside this court, be clear-eyed in making this submission for two critical and closing reasons. The first is this is not a case that lends itself to allowing an exception to the usual rule of finality, because just 2 weeks ago in this court's judgment at paragraph 97, when explaining why Mr. Zuma stood to be imprisoned for his contempt, this court said the following. It said, Mr. Zuma is no ordinary litigant. He remains a public figure. He continues to wield significant political influence while acting as an example to his supporters. He has a great deal of power to incite others to similarly defy court orders because his actions and any consequences or lack thereof are being closely observed by the public. If his conduct is met with impunity, he will do significant damage to the rule of law. Yet that's exactly what his application will ensure today. Impunity for Mr. Zuma. He doesn't admit any wrong. He simply asks that this court's orders must be rescinded. And of course, that would mean inevitable decay for the rule of law. The second reason is that by his application, Mr. Zuma has put this court to a deliberate challenge. With respect, the challenge is clear. It's him or the Constitution. We respectfully say that this court's defense of the Constitution must be equal to and greater than Mr. Zuma's defiance of the Constitution. This court's judgment and order are the line of defense. It's a vital line of defense of our constitutional democracy. That the constitutionally necessary response to Mr. Zuma's ongoing, long-held and publicly stated rejection of everything this court has tried to hold dear. So in closing and in conclusion, we ask this court to see the case for what it is. And we say so obviously with deep respect to the court as our ultimate guardian. With his options running out, Mr. Zuma is now supposedly warmed to the court that he repeatedly cold-shouldered. But it's not a good faith approach. It's by a litigant who for months deprecated this court, and whose deprecation continues even now, and who refuses to acknowledge that he's done anything wrong, and that wishes to revisit a final and binding judgment of this court through the lens of a minority decision. While the defense of the Constitution required and continues to require that Mr. Zuma be declared to be in contempt of court and to remain in prison. And to allow this challenge would mean, with respect that this court and our lower courts that look up to it for guidance will be thrown into the realm of chaos. They would operate in an open-ended tangle vulnerable to whim, to fancy, to abuse, and sadly, as the last week has shown, threats of violence. Law would not rule. So we would ask that the application for rescission be dismissed.
Mr.
Those are
Du
submissions. Thank you.
Mr. Du Plessis. You mentioned the question of waiver. How has this court, in its judgment, dealt with the question of waiver and whether constitutional rights can be waived?
Well, it did so, Justice Turan, by recognizing, of course, that there was a very deeply written and closely written minority judgment, and the minority judgment dealt with the question of waiver. But in response to the question of waiver, the majority judgment said two things. It said that, firstly, that Mr. Zuma's rights had not in any way been limited. They had been respected. So there wasn't a question of his rights having been in any way infringed whatsoever.
We're not talking about limitation now, Mr. Du Plessis. We're talking about waiver.
Yes, and then secondly, Justice Turan, in addition, the court went on and said that in respect of Mr. Zuma's position, there was no debate for the court that it nevertheless had to find that he was in this case to be committed to prison. So whatever his rights might have been about the issues on waiver, whatever his rights might have been in respect of rights that he thought were constitutionally important ones, right to, for instance, a trial in terms of Section 35, or rights that he thought that might have been violated in some other way because of a Section 36 process.
Sorry to interrupt you. My question is, how did this court's judgment deal with the question of waiver of constitutional rights? Did it deal with it? Can you refer me to the passages where it dealt with it, please?
No, Justice Turan. All I can say is that one has to read the judgment of the majority as effectively saying that despite what had been raised by the minority around a waiver of constitutional rights and that such rights can't ordinarily be waived, the Constitutional Court nevertheless disagreed with all of that and said that it was going to come to the conclusion that Mr. Zuma had to be in prison.
Well, so can you refer me to the passages in the judgment where it says it disagrees with the fact that constitutional rights cannot be waived?
No, Justice Turan, that's not what our submission is. Our submission is that it knew that this court had dealt with, in the minority judgment, the question of waiver of rights. It knew about that. And the question of waiver of rights had been raised in the minority decision because one of the points had been made by the minority saying that ordinarily its complaint with the way in which the rights of Mr. Zuma had been dealt with was because constitutional rights are important and they aren't ordinarily waived. And this court in the minority judgment referenced the Scumbi decision. But the point is that despite that, the majority engaged with each of the arguments of the minority. And its overall conclusion was, despite the fact that there might have been a complaint about a waiver of constitutional rights, that it was going to come to that conclusion. So it didn't deal.
In the judgment, is there an engagement with the waiver of rights?
In the minority judgment.
In the main judgment, in the judgment that now stands as the judgment of this court.
No, well, it doesn't engage with the question of waiver in that sense. As I've said, Justice Turan, what it recognized is that there is a waiver argument that has been raised against the majority's reasoning. The waiver argument had been raised by Justice Turan and Justice Jafter in their minority decision. It recognized, it read the minority decision, no doubt as closely as all of us have. And it recognized that despite those points, it was nevertheless able to come to the conclusions that it did. And it came to those conclusions recognizing that even if there had been an opportunity to supposedly waive rights, there were protections that had been afforded and the necessity of the order that ultimately was imposed. So it doesn't directly
if we were to assume that this court's if we were to assume for a moment that this court's judgment did not deal with waiver, would that amount to an error of law?
No, Justice. Because as we've said already, the Constitutional Court has in Scumbi recognized that constitutional rights can be waived. It's not impossible. And that in the circumstances of a right of preemption, as I highlighted earlier, in the CCMA versus SARS case, it is quite clear that in those circumstances, there is a constitutional right to an appeal, but that can be preempted. And as we were stressing, that's really the debate, is whether in light of conduct by a litigant, their constitutional right to appeal, or in this context to rescission, can ultimately be waived. And we've said that that's the correct categorization of which rights are an issue here. Because this court said, and in paragraph 76, Justice Turan, this court said to the majority, I'm satisfied that this court has taken cautious steps to ensure that Mr. Zuma's rights, enshrined in Section 12 and buttressed by Section 35, have been protected during the course of these proceedings. Indeed, I'm satisfied that this court took appropriate steps, mindful of what has been said by this court in the past of the seriousness of implicating a person's personal liberty, to afford Mr. Zuma such substantially similar protections as are appropriate to motion proceedings. That effectively is to say, through the majority decision, that it has taken account of all of the criticisms of the minority decision and all of the concerns, of course, ultimately to say that Mr. Zuma's rights would be protected.
And how does the judgment deal with the Section 12(1) right? The right not to be detained without a trial. Does the judgment accept that there could have been a limitation of that right?
Well, Justice Turan, of course, the judgment references the Lange versus Smuts. It references all of the court's previous jurisprudence in this respect. And at the end of the day, it balances all of that. And it says that it's not so much a question of a Section 12 right violation. It's a question of whether the process that had been afforded to Mr. Zuma.
That's my question. My question relates directly to Section 12. Was there a finding that Mr. Zuma's Section 12 rights has or has not been limited?
Well, effectively, that's what the court was saying. It was talking about there being a trial in the context of civil contempt. And the court referenced the fact that there is going to be a Section 12 process that has to be akin to the Section 35 process. So
yes, and in the Section 12 process that this court adopted, did the court express a view as to whether that Section 12 process in any way limited Mr. Zuma's rights?
No, it found that his rights had not been limited at all throughout the process. So the process that the court was looking at was whether there was a Section 35 process akin to a Section 35 process in a civil contempt matter. And the court looked at it very closely.
If you say his rights were not limited at all, or his Section 12 rights was not limited at all, can I refer you to Kutsia, please? Kutsia versus the government of the Republic of South Africa.
Yes, Justice Turan.
And particularly at paragraph 10, I'll read to you what is said there, and you could perhaps give me your comments. It says, certainly to put someone in prison is a limitation of that person's right to freedom. To do so without any criminal charge being leveled or any trial being held is manifestly a radical encroachment upon such rights. And Kutsia was a decision of this court. What would your comment be?
Well, Justice Turan, I couldn't do better than the majority decision in your court in this matter. At paragraph 76, the majority said, I'm satisfied that this court has taken cautious steps to ensure that Mr. Zuma's rights, enshrined in Section 12 and buttressed by Section 35 as canvassed above, have been protected during the course of these proceedings. I'm satisfied that this court took appropriate steps, mindful of what has been said by this court in the past of the seriousness of implicating a person's personal liberty to afford Mr. Zuma such substantially similar protections as are appropriate to motion proceedings. And then at paragraph 77, Justice Turan, this court said at the end of the passage, it said, thus, since the constitutional rights to which Mr. Zuma was entitled have in no way been limited or disregarded by this court in determining this matter, a justification analysis under Section 36(1) simply does not arise.
I must say for myself, I'm a bit confused as to what is meant by protected. I know what is meant by limited and where someone's rights have been limited, but I'm not sure what's meant by protected. Does it mean that the full suite of rights have been guaranteed?
I think, well, I think that the court was clear that in the context of this case, his rights were protected, the rights that were necessary to ensure they had a fair process. Absolutely. The court was clear about that.
I know in our jurisprudence, we speak about rights being guaranteed and we speak about rights being limited.
Yes.
I'm not sure what protected means.
Well, all I can say is, again, that in this context, the court said that they have been protected during the course of these proceedings. I would imagine that that means that they've been guaranteed. And as much as they are guaranteed, to put it differently, they've been protected.
Yes. Thank you, Justice Kampepe. Thank you, Mr. Du Plessis.
Thank you, Justice Turan.
Mr. du Plessis, do you have any further submissions to make?
No, thank you, Justice Kampepe.
Ms. Leroux?
Thank you, Justice Kampepe, and may it please the court. Coming at this point, more than 8 hours into the debate today, and obviously coming at this point as KSAC, where we have limited our amicus intervention to two discrete topics, essentially the relationship between finality and the rule of law, and then a point that I'm not going to address in argument today. It is in our heads of argument from page 14, paragraph 27 onwards, about extracurrial statements and conduct that may be relevant and should be admitted in these proceedings. So let me start by taking advantage of where I come in the debate and take a step back and ask, why do we think the country is watching this case so closely? The country is watching this case for more than 8 hours today and will stick with us until my learned friend completes his reply, because everybody is asking themselves the same essential question: will the court change its mind? And if the court changes its mind, KSAC asks, what does that mean for the rule of law? Because it won't just be in this case. It will have implications for other cases, whether those are just cases before this court on direct access, or whether it's even more broad and encompasses all litigation in the legal system. And why are we concerned about this? Because we would say that this case tests not only the Constitution, but also our commitment to the rule of law. And it does it because we say that the rule of law, one of the foundations on which it rests, is the principle of finality. And what finality means for the rule of law is that you accept when you lose in litigation. You arrange your affairs in accordance with a court order, and everybody else in a similar position arranges their affairs knowing that the law that will apply to them is the law that's been pronounced in a decision. And it matters because you accept that loss and you conduct yourself accordingly, even if you disagree with the decision. Even if there are some judges who disagree with the decision that pronounces the law as it applies, because there's a majority decision. So even if there is a dissent, the law of the majority is the law that will apply. And we know that there will be another case. And in that next case, litigants may be encouraged by the statements in the minority decision. And the justices who preside in that case may themselves be persuaded to adopt or develop the position that started off as a dissenting and minority view. And in our system of precedent, that is how our law changes and develops. But it doesn't happen in the same case. We wait for the next case. And so if we look at much older constitutional democracies with similar apex courts, if we just look at the well-known examples we see, for example, in the United States, the Supreme Court for a very long time entrenched racist inequality. It then realized that it was wrong, and it was persuaded by what had been a minority and dissenting view to then luminously announce the principles of equality and non-racism that then prevailed. We know, for example, that it was initially against gay rights, in endorsing the criminality of those who were not heterosexual and heteronormative. We then know that eventually, through a series of engagements between majority and minority views, and through the diligence of litigants to continue to persist and press cases, the court changed its mind. But what is striking about all of those is that it's not the same court changing its mind in the same case. And we say that that is what is at stake in this case. The case comes to you very clearly and boldly labeled as a rescission decision, as a rescission application. And we know, and let me just repeat the principles, that rescission is a very narrow exception to finality. The three grounds that are set out in Rule 42.1 are very limited in their scope. So the first has obviously enjoyed most of the attention today. What does erroneously sought and granted in the absence of a party mean here? But the other two grounds for rescission are equally important, because when this court writes its judgment, it will be addressing that broader point of when is rescission available. And there we see, for example, in 42.1b, an important qualification. So when the court does revisit an order or judgment that it has given and make a change to that order in the same case, it does it only to the extent of the ambiguity, error, or omission that it is addressing. So to use an example that my learned friend, Mr. Mpofu, used a few times this morning about I get sued for a debt for 100 Rand, but the court issues an order for 1,000. That mistake, that error, is clearly the type of patent error that would enable the judgment or the order to be corrected to say, oh, you're not required to pay back 1,000 Rand, you're required to pay back the 100 Rand. And that's what that qualification means. It says when you've satisfied the grounds for rescission and the court picks up its red pen to adjust the order, it does it only to the very limited extent of making sure that the order reflects the intention of the court, not because there's been some type of patent error or there's some ambiguity. It's also to ensure that the order was granted where the procedural requirements to grant that particular relief were mistakenly understood to have been satisfied, but in fact they weren't, and it made a difference. So if we think of the many, many thousands of default judgments that our courts routinely hand down, if those are granted where in fact there had not been proper service, and therefore the person, the respondent was not on notice, and that's why they didn't appear, those are the type of circumstances where the Rule 42 power is used by the courts. And it's in order to ensure the integrity and credibility of the legal system that that is so. So we would submit that if we look at some other aspects, it should become clear that finality matters for the rule of law. If we take a step even further back, litigants come to the courts of our country in order to resolve disputes that they have between them. They have opportunities to choose how to frame that case. Is it going to be a contract claim, a delict claim? Is it based in criminal law, civil law, which branch of the law? And litigants make elections at every step of the way. We know, because we all have jobs, that different lawyers take different views of the facts, of the strategies that would be available, of the law that would be applied. And we know that in every single case in the law reports, there was at least one legal team that thought they had a chance to win and persuade the court, and yet they lost. And it means that just because you could have had a different strategy run by different lawyers doesn't mean it becomes a basis for the court to change its mind in your case. So you lose the case, you're desolate and distraught, and you go out because you're not in lockdown level 4, and you go and have a drink to drown your sorrows. And you encounter a lawyer who says, oh, but that's crazy, I could have got you off that. There's this and this and this case that you could have used, or this strategy. You don't get to go back to court unless you can fit that mistake into the very narrow confines of the Rule 42 avenues to revisit a decision. But it doesn't just mean that litigants are held to the elections they make, the choices they make throughout the course of a litigation. It also has consequences for the judiciary. That's because finality actually is also given expression to in the doctrine of functus officio. So a court has performed its office when it issues that order. And it doesn't just mean that it moves on to the next case. It means it no longer has authority over that dispute. It's discharged of that authority. And so again, there must only be very narrow and limited grounds where a court reinvests itself with authority on that particular dispute. A third and final point is the consequences of permitting rescission in broader circumstances than the current law. And that is what would happen to the status of parties. And here I will dip into the facts of this case as an amicus, just to show the confusion that the mere setting down of this rescission application caused. We saw the Minister of Police and the Commissioner of SAPS write to the court and say, what do we do now since you've set down this rescission application? We saw Mr. Zuma himself write through his attorneys and say, I've got my Pietermaritzburg case. I understand your order has particular timelines attached to it. Where do we stand? Now imagine that type of confusion as to the status of parties and how they should regulate their affairs, rippling across our entire legal system. And we would submit that it's possible that the false hope of this application may play some role in the unfortunate events that we see rolling across the country. Because there are people who think, and I in fact saw newspaper headlines this morning describing this as an appeal, that the court will change its mind in the same case, the way an appeal court can change the outcome of a case where it sits in an appeal over a lower court. There are also obviously practical consequences here. The time, the delay, the additional cost, the waste of our scarce judicial resources, if a rescission application can be interposed throughout the course of litigation. We would submit that it undermines our appellate hierarchy because you would have these continuous attempts to revise and revisit what should be final judgments. And a final practical risk that we can see is that we don't know why, as a matter of principle, if this court were to open up rescission, why should rescission only be available once? Why shouldn't we have rescission on rescission? So this court entertains the application, it changes its mind. Why should the commission not come and say, well, now I've got some rights that I've identified in the Constitution, and I think you got those wrong too. And maybe the court will change its mind again. Then Mr. Zuma will presumably return because there's no in principle break on this slide into reconsideration / rescission where it seems to stray into the merits of a particular judgment. So for all of those reasons, we would submit that the law of rescission as we know it, and as it has been affirmed repeatedly by this court, should be where we stand. That is firm ground for us in our legal system, both in terms of the rule of law and in terms of the administration of justice. So when we hear the debate today, there are a few elements of this that we would also like to highlight as cause for concern when you retire to write your judgment. Because we've heard, for example, that it becomes necessary to have interim arrangements if a court is entertaining rescission / reconsideration. And that effectively changes the outcome. So there's a particular state of affairs that obtains when the court issues its first judgment. Then when it decides to entertain a rescission / reconsideration, it requires interim arrangements that presumably go back to the status quo before the first judgment. And you can see that that uncertainty, that chaos, to use the words of my learned friend, Mr. Du Plessis, is is very undermining for the functioning of the legal system and confidence and credibility in the rule of law and in the decisions of our courts. We've also heard the debate this morning around whether this would only apply in direct access constitutional court cases, or could it apply more broadly? And we know that, and there was debate about, is it case by case? What's the general principle that could be identified here? And all of that means that in every case, there will be incentive to switch lawyers, get a fresh set of eyes, get some more ideas about what you could come to court with, and reopen and re-argue your case, changing outcomes at every step. What that essentially does, whether it's limited to direct access constitutional court cases, or whether it's the broader position, which I understood my learned friend, Mr. Mpofu, to be adopting, that there probably wouldn't be a basis to exclude the High Court decisions and presumably those of the Supreme Court of Appeal as well. Where we effectively end up is in perpetual rule nisi land. We end up where every order becomes a conditional order. Every order becomes conditional unless you can think of something else to come back to us on, and then it might become binding. So we end up in a state of conditionality, which is the very opposite of the finality that the rule of law and our system of precedent requires. So we would submit that when this court retires to write the judgment, what it in fact is being asked to do is demolish the law of rescission as we know it, and ignore that it would in fact be refashioning it as conditional appeal on merits, a reconsideration. And that reconsideration language is important because it's the language that we use when we send decisions of administrative bodies back to be redone. And the courts of our land are not administrative bodies that should reconsider the same facts and just come to a different outcome and do a better job. When this court is writing its judgment, it'll be asked.
Your protection time has expired.
Thank you, Justice Kambepe. When this court retires to write its judgment, it will be asked to explain whether this only applies to Mr. Zuma, and if it doesn't, which it can't because of the equality principle, how does it mitigate this risk that every other losing litigant, or even more narrowly, every losing respondent in default proceedings in our courts, or even more narrowly, every losing litigant in a direct access case before this court, presumably they're all invited to come back. And then the losing side in that decision is invited to come back. And the court is therefore required to identify where this will end.
Ms. LaRue, can we understand where we are? You started off by saying the whole country is watching the proceedings and people are worried that the court is going to change its mind. I just want us to disabuse the minds of those who do not understand that there can be a rescission. As I understand your argument, you're not saying that there cannot be a rescission. You are saying that rescission must be granted here only if the requirements, established requirements of rescission have been met. Do I understand that?
Yes, Justice Jefter.
So everybody who's watching from home should know from now that this court in law can rescind its decision provided certain requirements are met. Now, the submission, general submission, maybe you did not intend to make it, that courts do not do reconsideration. They do, isn't it, that the SCA, when leave to appeal has been refused by 2 judges or so, the applicant can apply to the president of the SCA to reconsider that. Or am I wrong?
No, Justice Jafta, that's correct.
So we do have a reconsideration that happens in courts. So to say that reconsideration is a matter of administrative bodies may have been overemphasis on the point.
And Justice Jafta, I take that point. I would just say that even when the president of the SCA, in the language of the rules, reconsiders a petition, it's because there's a particular mechanism that enables that to happen. And the submission here, and I think the arguments that have been made by the Commission and by the Helen Suzman Foundation today, and even by Mr. Mpofu and Mr. Ngowana, is that rescission is a particular mechanism or device that at the moment we understand to be available in 3 narrow and defined grounds. And this court would be expanding those if it introduced the idea of reconsideration into Rule 42. It would be announcing a new interpretation. It would be catering for a set of circumstances that haven't previously been the 3 circumstances in which rescission is available. And it's that development that this court is being invited to make by the applicant.
But is that accurate? I understood Mr. du Plessis to accept that over and above the requirements of Rule 43, the interest of justice standard has been considered by this court as another test for whether or not there could be rescission.
Indeed, Justice Jafta. But again, the particular facts of this case, which of course I'm anxious not to traverse onto because I only have amicus status, but when the court writes its judgment, there will have to be the principles identified from the facts and circumstances of this case that will apply in future cases. And there therefore will be an expansion of when Rule 42, as interpreted in this judgment, will be available to future litigants. And it's that potential uncertainty that we are cautioning against in our submissions.
Already, in the case that Mr. du Plessis referred us, a decision of the court, of this court, in SS v. BVS, this court recognized the standard of the interest of justice for purposes of entertaining a rescission application. So lawyers know that. Now, I just want to clear, the path and understand so that people don't get confused as if this court were to entertain a rescission, because some of the submissions that you are making are quite troubling to me, that this court has created confusion by the fact that it has agreed to hear the matter. And I thought, how else can the matter be dealt with if this court doesn't hear it? Whether a good case has been made out for rescission or not, that's another thing. But for the court to say, you have made this application, we're not going to entertain it. I don't understand that. What I would understand is the court would say, you have made the application, we have considered it, but we have dismissed it. But there would be entertainment of the application. So I don't understand why confusion should flow from the court setting the matter down, because it doesn't say it has decided it one way or the other. So those kind of submissions are fueling the confusion that might exist out there insofar as whether in law this court is competent to entertain a rescission application, and if it meets certain requirements of the law, the application might succeed.
Justice Jefter, with respect, obviously, I agree with everything that you've said. I was pointing to the fact that when this court announced that it would hear the application today, parties that had duties and obligations in terms of the order that is the subject of the rescission application indicated confusion about the status of whether or not they should act on the order because the court was entertaining.
Were they right though? One thing is when parties are taking advantage of certain things, the order was clear. Certain steps had to be taken at particular times. Barring the stay of execution of the order, every lawyer knows that the order has to be carried out. So I don't understand that too, because the order was there. If any of the parties wanted that order not to be carried out, it was incumbent on it to come back to the court and say, for these reasons, we're asking you to stay execution of this order. And the court would consider that. So I don't understand that argument as well.
And Justice Jefter, with respect, we are in agreement. I was merely pointing to the fact that presumably after talking to some lawyers, the Commissioner of Police, the Minister of Police, and Mr. Zuma both had some doubt in their mind as to the state of the law. And all that KSAC is pointing out is that that type of confusion and uncertainty will be a feature in future cases. So it will demand of the courts, whether it's just this court or whether it's all courts, depending on how the judgment is written, it will be incumbent on courts to be very clear about what it means if you bring such an application. What are the consequences for the order that is the subject of the sought rescission? You know, we know enough about the confusion about, you know, whether reviews suspend orders and what happens in appeals. We'll be adding to that debate and that uncertainty. And that's the rule of law caution that KSAC is sounding, is to say that when this court writes this judgment, if it could give guidance as to how to mitigate against that danger and that risk, to minimize that confusion and that uncertainty, so that parties know where they stand, if there's now going to be the expanded procedural device made available to losing litigants. That's the submission.
Can I also point out that there are apex courts elsewhere in other jurisdictions, which as well have reconsidered or rescinded their judgments, their own judgments, under certain circumstances that are laid down there. The case that I would commend to you is a judgment of the House of Lords in the Pinochet matter. It's reported as R.V. Bow Street Metropolitan Stipendiary Magistrate et others ex parte Pinochet, Uganda, number 2, 1999, 1 all ER 577. It's a decision of the House of Lords. And the principle that they laid down there is this: Upon goats, in principle, it must be that your lordships, as the ultimate court of appeal, have power to correct any injustice caused by an earlier order of this House. However, it should be made clear that the House will not reopen any appeal save in circumstances where, through no fault of a party, he or she has been subjected to an unfair procedure. So this is not a practice that is followed by this court alone. Yes.
And Justice Jafta, I'm obviously indebted to you for reading the relevant paragraph. I would just highlight that even there, it's qualified by these requirements of no fault of the party.
Yes.
And so if this court were to follow that kind of reasoning, then the question would be, in your judgment, was there any fault by the applicant that needs to be taken account of here? So even that qualification, if we were to go down a similar path, it wouldn't be a blanket. There would still be requirements. The judgment would still need to guide future cases.
Now, Ms. Leroux, speaking for myself, I accept that rescission should be used sparingly. And there must be strict requirements for it to be granted. And only if those requirements are met that it should be granted. It can't be a willy-nilly kind of remedy, because it undermines the principle of finality that you have articulated so well.
Thank you, Justice Jafta. Justice Kampepe, then just to make the final point, all that CASAC asks is that this court's judgment clearly do four things, whatever its contents in determining the merits of this case. It must affirm this court as being the final word on cases that come before it. It must affirm the limited circumstances and make clear the requirements of those circumstances where the procedural device of rescission in terms of Rule 42 will be available in future litigation. It must affirm finality and the related point that even if you disagree with the outcome, it's important that the final pronouncement of our courts be respected. And by doing all of that, this court's judgment will have affirmed the rule of law and our Constitution. Thank you, Justices. Those are our submissions.
Thank you, Ms. Leroux. The court will take a short adjournment of 5 minutes.
Court will adjourn until 18:03. You may now switch off your microphone and mute yourselves.